Trial resumed. Jury not present.
The court said, "Good morning."
All counsel said, "Good morning, Your Honor."
The court said, "Please make your appearances."
Mr. Ferguson said, Micah Ferguson, Ryan Finkel, Juliana Murray for the United States, and were joined by a paralegal. Isabel Loftus, Your Honor.
Mr. Kamraju said, "Good morning, Your Honor." Siddhartha Kamraju, Sabrina Schroff, and Scott Skirek for Mr. Guo. And we're joined at counsel's table by Jorge Salazar, and Mr. Guo is with us as well.
The court said, "Please be seated." By letter dated June 30, 2024, the government moves to preclude the defense from introducing 5 categories of evidence. On July 1, 2024, Guo filed a letter in opposition, ECF number 386, and the government filed a reply, ECF number 387. First, the government argues that testimony of non-victim investors is irrelevant and, therefore, inadmissible under Federal Rules of Evidence 402 and 403. Specifically, the government seeks to preclude the fact that some investors do not believe they were defrauded. Guo contends that defense witnesses should be allowed to testify that they heard the alleged misrepresentations upon which the government relies, but did not view them as important in their investment decisions, because such testimony is evidence that the jury should consider in assessing the materiality of the alleged misrepresentations. Guo letter at 2. In determining whether a scheme to defraud existed, the jury is tasked with the defendant's intent. United States v. Thomas, 377 F.3d 232, 243, 2dr 2004. Whether an investor feels actually victimized is irrelevant. See United States v. Washington, 21 Cr. 603 2023 WL621 9203 at *9 SDNY September 22, 2023. Moreover, the government need not prove that the scheme successfully defrauded the intended victim. United States v. Dynome, 86 F.3d 277, 283, 2dr 1996. That said, under the Second Circuit's decision in United States v. Litvak, 889 F.3d 56, 65, 2dr 2018, the defense may elicit testimony that bears on whether Guo's alleged misrepresentations were material to the reasonable investor. Indeed, in its reply filed July 1, 2024, the government concedes that the defense can call witnesses to testify that they did not believe certain statements made by Guo were material. For example, those witnesses might testify that Guo's statements regarding guaranteeing losses were not important to their decision to invest. Governor reply at 2. I will permit the defense to ask its non-victim witnesses about what information they personally considered in deciding to invest, what weight they gave to various statements and why. The defense may not imply, however, that the government's victim witnesses were comparatively negligent or gullible. See Thomas, 377 F.3d at 242-43. For example, the defense cannot ask its witnesses for their opinions of other victims, or to opine about what statements other victims should have considered or disregarded. In short, the defense shall limit its questioning to each witness's own investing experience. Next, the government objects to defense witness 1's anticipated testimony about a variety of matters, including his targeting by the CCP. Governor letter at 4. The government first takes issue with the timeliness of when exhibits related to defense witness 1 were provided by the defense. ID at 6-7. The defense states that, consistent with Rule 16, they provided the exhibits for defense witness 1 once they decided to use the exhibits as part of Guo's case in chief. Guo letter at 3. As I've stated, I expect the parties to be nimble. I credit the defense's representation as officers of the court as to the timeliness of their disclosure, and I will not preclude the exhibits on that basis. On the substance of the government's letter, in my May 2, 2024 order, I held that Guo may offer evidence that his fears of CCP targeting were objectively legitimate. Order at 14. ECF number 319. Accordingly, defense witness 1 may testify about being arrested and interrogated by the Chinese police and being coerced by the CCP into filing complaints against Guo, which adds objective credence to Guo's beliefs. Guo letter at 2. I disagree with the government that the timing of defense witness 1's arrest renders it irrelevant. Governor letter at 5. Although defense witness 1 was arrested in October 2022, over 2 years after the GTV private placement in which he participated, the arrest occurred within the time frame of the alleged conspiracy and may support non-culpable explanations for Guo's conduct. ECF number 243 at 6. Although defense witness 1 may testify as to his own interactions with the CCP, and the CCP forcing him to file false complaints against Guo, I will not allow testimony that is based on pure speculation. For example, defense witness 1 cannot testify as to the intent or motivations of the government's victim witnesses. Nor can he speculate that victim witnesses are biased in favor of the CCP or are CCP spies. Moreover, defense witness 1 cannot testify that Chinese authorities wanted to use a fraud case to bring down Guo, a speculative claim, to the extent that this testimony has any probative value, such as for its effect on defense witness 1's state of mind. It is substantially outweighed by the risk of prejudice. It risks creating an inference that the prosecution team is improperly linked to the CCP or in any way malicious, which I have previously forbid Guo from arguing. Order at 13. Lastly, the government argues that defense witness 1 should not be allowed to testify that his profits were frozen by the governor letter at 6. I agree that this would contravene my order that prohibited Guo from arguing that the SEC or the government are responsible for the victim's financial losses. Order at 18. However, Guo states that he will not elicit testimony implying that the SEC is responsible for any alleged losses. Guo letter at 3. Therefore, this portion of the government's request is denied as moot. Third, the government seeks to preclude defense witness George Higginbotham from offering hearsay testimony about a conspiracy Higginbotham joined to seek to persuade the Trump administration to repatriate Guo to China. Governor letter at 9. The government is correct that the admission of co-conspirator statements is only allowed under Rule 801d. 2. When such statements are made by the co-conspirator of an opposing party, and Higginbotham does not fall into that category. But Guo is correct that there may be permissible non-hearsay purposes for admission of Higginbotham and his co-conspirators out-of-court statements, but I cannot evaluate this in the abstract, and I will address objections as they arise during Higginbotham's testimony. Accordingly, the government's motion is denied without prejudice. As to the fourth issue, the testimony of expert Maggie Sklar, the government's motion is denied as moot, because the defense does not intend to elicit such testimony. Fifth, the government seeks to preclude summary witness Thomas Bishop from testifying about redemptions provided by the Himalaya Exchange. The government argues that because the redemptions are not a defense to the charges, they are irrelevant. Government letter at 10. I disagree. Although the fact that the Himalaya Exchange permitted its customers to redeem $, for currency is not a defense to fraud, testimony about how the Himalaya Exchange did business is relevant to complete the narrative of how the exchange operated and how funds flowed through the exchange. Accordingly, the government's motion is denied. Are there any further applications?
Mr. Ferguson said, "Just may we have one moment, Your Honor."
The court said yes.
Mr. Ferguson said, "Thank you, Your Honor." One other application that we had raised previously related to the statement the defense was objecting to on 403. Separate from the letters last night, where Mr. Guo says, "The United States will never falsely accuse you." In sum and substance, listen to what I say. The United States will never falsely accuse you. I had mentioned this, I believe, last week. And defense counsel who I've been speaking with about it was not present, so we tabled it. But given we're going to rest this morning, Your Honor, I wanted to resolve it so we could put in the appropriate version of the summary chart with that redacted or without that redacted. And the government's position is, there's clearly high probative value to such a statement. It's a statement of an opposing party. It's Mr. Guo's recorded statement. And it's not unfairly prejudicial. There's nothing unfairly prejudicial about it. Routinely criminal defendants confess to crimes. And if they go to trial, confessions are admitted at their trial. There's number 403 problem with such statements.
Mr. Kamaraju said, yes, thank you. I think Mr. Ferguson's use of the confession analogy actually shows the problem with this testimony. When confessions are admitted in court, they are admitted for relevant facts. So, for example, if a defendant confessed, I shot somebody, then that has relevance to the particular crime charged. The statement that they're eliciting here is a blanket statement about the U.S. government moves slow. They will never falsely accuse you. There's no particular fact in this case that goes to other than the ultimate question the jury has to decide. Which is, has the United States government incorrectly charged Mr. Guo here? So unlike a confession, that basic connective tissue between a fact that is in dispute, a specific fact that is in dispute, and the confession doesn't exist here. And so it has no probative value of those facts. All it is Mr. Guo's opinion at the time of this statement as to the U.S. government's veracity. Or whatever the right word is. It's not a statement with respect to the particular charges here. It's not a statement or an admission with respect to any fact that the government has tried to allege. And so on that basis it has very little relevance, but it does have a significant amount of unfair prejudice, which outweighs whatever relevance the government may be able to argue, because essentially it places before the jury a weighted opinion that the government I think obviously will try to argue is Mr. Guo's confession that their entire case is correct. And I don't think that's the question that the jury has to consider. The jury has to consider the evidence of the specific allegations that the government has made to determine whether the government has met its burden with respect to that. So on that ground, relevance and 403, we would object to inclusion of this.
Mr. Ferguson said, whatever context they want to argue this statement should be viewed as, they can argue it. But it doesn't mean it's not admissible, Your Honor. It is not substantially outweighed by a risk of unfair prejudice. And just to be clear, the defense is putting on an entire defense case centered on the fact that Mr. Guo's belief that, in part, the DOJ was targeting him as an arm of the CCP was objectively reasonable. They have 9 witnesses that are going to put on this defense case. That's the gravamen of the defense case. This rebuts that. And it's Mr. Guo's own statement. He recorded it, he put it on the internet himself. He voluntarily did all that. There's nothing unfair about the jury hearing what Mr. Guo said during the time period of the fraud when discussing investigations by the SEC and U.S. authorities. This isn't some unrelated context. He's talking about this case and says, the United States will never falsely accuse you. In fact, he's talking about supporters of his, investors, who had complained to the U.S. authorities and suggesting to his followers that they were going to be criminally charged by the United States because those complaints were false. It's clearly relevant. It's clearly admissible. It's a statement of the defendant himself that is against his penal interests. There's no question it's admissible. Thank you, Your Honor.
Mr. Kamaraju said, just briefly, Your Honor. 1. As the court has made clear, and as the defense has made clear, we have no argument. No part of our defense case is to argue that the prosecutors at this table or that this prosecution is being motivated or constructed or directed by the CCP. So the point that Mr. Ferguson was making may be responsive if our defense was that this particular prosecution was being driven by the CCP. That's not our point. And frankly, Your Honor, they're the ones who brought up in the first instance the DOJ's infiltration by the CCP through their protest signs. We didn't introduce that at all in the beginning. So the concept that this statement rebuts a defense argument that the defense is not trying to make doesn't make it relevant. 2. They're right, we're allowed to argue the context. But the statement itself still has to have independent relevance to be admissible. And this statement does not make any particular fact more or less likely, other than the ultimate decision that the jury has to make with respect to guilt. So for all those reasons, we maintain our objection.
The court said, I'm going to permit the government to introduce the statement. Is there anything further?
Mr. Ferguson said, "Not for the government, Your Honor."
Mr. Kamarju said, "I just had an administrative question for Your Honor. So it sounds like the government anticipates resting this morning. As a formal matter, we would obviously make our Rule 29 motion subsequent to that. I presume the government will oppose. I don't know if it's Your Honor's practice to reserve or to hear argument on it. If it were to reserve, I just thought for efficiency's sake, rather than excusing the jury entirely and having that motion practice, I could just make on the record a note at sidebar that we're formally moving and they can make their opposition. But it's whatever Your Honor's preference is. I just wanted to know for planning purposes."
The court said, "I'm happy for you to make it at the sidebar."
Mr. Kamarju said, "Thank you, Your Honor. That's all I have."
Mr. Ferguson said, "No. Thank you, Your Honor."
The court said, "All righty. We'll start at 9:30.
Recess.
The court said, "Please be seated. I just received word that alternate number 4 is not present and is currently in Terrytown, and so that would mean that if he were to remain, we would be delayed by at least an hour. And so the question that I have for the parties is whether you would consent to my excusing him."
Mr. Kamarju said, "Your Honor, I think given the COVID situation and the length of the trial, we think it's important to have our bevy of alternates. I understand the delay, but just for the record, I think we would object."
Mr. Finkel said, "Your Honor, the government's view, and I think this is within your discretion, is that it makes sense to move forward. We're just a few days away. We have 3 other alternates. 3 or 4 other? 3 other alternates. The jury has been remarkably prompt. Timing is also an issue. Which is to say, if it takes too long to finish the trial, we're going to have problems with the rest of the jury. Understanding that the jury expects the trial to basically be done on July 12th. So saving an hour here for alternate juror 4 might hurt us with the rest of the jury. And so it's the government's view, of course, it's Your Honor's discretion. That carries the day as always, that we should move forward and just lose 1 additional alternate. We have plenty just in case."
The court said, "The defense agrees that it's a matter of my discretion, that the defense need not consent to my excusing alternate number 4.
Mr. Kamarju said, "Yes, it is ultimately Your Honor's discretion."
The court said, "All right, so I am going to excuse number 4 and we can get started."
Jury present.
The court said, "Good morning. Please be seated. Good morning and welcome back."
The juror said, "Good morning."
The court said, "We're going to continue with the direct examination of the witness. You may continue your inquiry."
Mr. Ferguson said, "Thank you, Your Honor."
Jessica Volchko, resumed. Direct examination. By Mr. Ferguson.
"Good morning, Ms. Volchko."
Good morning.
Mr. Ferguson said, "Your Honor, the government's going to offer, at the start, a few exhibits pursuant to stipulation. So exhibits listed in Stip 8. These are government exhibits 3100 to 3107. And then exhibits listed in Stip 13. These are government exhibit SW series, and it's 114, 129, and 133. The government also offers, to the extent they are not already in evidence, the government exhibits listed in Stip 21. And then finally, the government offers a new stipulation that's marked as Stip 23 concerning government exhibit C62 video clips. And further to that stipulation, the government offers government exhibits C62 V1 through V13, and government exhibit C62 TX.
Mr. Kamarju said, "Just on the last one, Your Honor, we just note our continuing objection."
The court said, "They are admitted."
Government's exhibits 3100 to 3107 received in evidence. Government's exhibits SW114, SW129, and SW133 received in evidence. Government's exhibits listed in Stip 21, received in evidence. Government's Exhibits STIP 23, C62V1 through V13, and C62 TX received in evidence.
Mr. Ferguson said, "Thank you, Your Honor." Ms. Loftus, if we could go to GXZ9, please. And we're going to go to page 34.
By Mr. Ferguson.
Ms. Volchko, in the top left, do you see the date there is August 7th, 2020?
That's correct.
And focusing you in the center column, could you read the text under V1, please?
Timestamp, under V1.
Yeah, and beneath timestamp.
The communists want to play guerrilla games. Let's play and see who is better at this. Aren't you looking for that hairless bean, and James to smear us in the US? Aren't you trying to frame us with the SEC? And use the DA's office to smear us, as well as the DOJ.
And could you now read the text under V2, please?
As long as you have done something illegal, it is impossible for you to get away with it. It is just a matter of time. Do you know what it means to report a faked crime? In the United States, this is very illegal. Lying to the federal or U.S. government officials, 3 to 5 years, nothing else to say. They 100% will be after you if you report fake things. Then, I will tell my comrades. What do we have to do with G Club? There are probably 3 million and 5 million who intend to buy G Club now. Between 3 million and 5 million people.
Mr. Ferguson said, and we could go to the next page, Ms. Loftus. And I'll ask you to keep reading, Ms. Volchko. I'll tell you when you can stop.
In the past, I said that if you buy G Club, you will have G Fashion stocks. Do you remember that I said that? 20%, 20%. So now, we have a problem, which is, if you talk about the stock, as long as this word shows up. That is why now Sarah and our comrades should not talk carelessly. There is not any. You should not talk about this stock word. Because GTV is already a legal U.S. company. Every share of which is protected by the U.S. government. That's the great thing about the United States as a country. Its regulatory agencies are the strictest, the most stringent one. Now me, Guo. If I took even a dime, let alone $1, from it, it will be the same stealing as taking 100 million. The protection of small investors in the United States is paramount. You know, right now we have 29 subpoenas. There are 29 investigation orders. We're asking the SEC to investigate, and we're asking the DA's office and the DOJ to investigate. You can investigate as long as you guys get our stuff clarified. But during the process, we really admire the United States government, who is very serious and very responsible. What is found now is that a son of a bitch, whose name I would not say, invested $500,000 and said he was cheated. This was a communist agent. Now they start to investigate his background. As well as Bean Dowdu and the $40,000 that she claimed that she sent to Sarah. Her background is also under investigation. And those who said they were cheated, and they are all under investigations for their backgrounds. The U.S. government moves slow, but it will never falsely accuse you. You must remember my words, it will never falsely accuse you, okay?
And Ms. Volchko, if you can skip down now to the bottom paragraph, where it says timestamp, 107. And if you could read a few paragraphs starting there with, but comrades.
But comrades, you should remember me, Guo will give you 3 promises. The G Club membership cards that you purchase will have nothing to do with me legally. But I promise that I'll be responsible for the consequences of all the things sold by the G Club. I will work hard to make G Club the largest membership company in the world. The G Club will never go public. But the G Club holds 40% shares of G Fashion. Meaning that the world's G Clubs together constitute 40% shareholder. How much is G Fashion worth? From today, as well as from a month ago, $100 billion. G Fashion will not necessarily be a U.S. company. Don't forget that. It is not necessarily a U.S. company. Just like G News. G News is now 100% independent and has nothing to do with me legally, nothing to do with me. We are doing this to hide from the Communist Party. We are fighting a guerrilla war, right?
Mr. Ferguson said, if we scroll down. And why don't you just read the first sentence under V4?
G Fashion is now worth $100 billion, $100 billion. Our goal is to make it $1 trillion in 3 to 5 years. We hope.
Mr. Ferguson said, all right. Now, Ms. Loftus, let's go back now to step 17, please. And Your Honor, may I approach to provide a hard copy to the witness?
The court said you may.
Mr. Ferguson said, and Ms. Loftus, if we could go to page 4 of step 17. When you're ready. And if we could zoom on the second row, with 1B69.
By Mr. Ferguson.
All right. Now, Ms. Volchko, what type of device is 1B69?
According to the stipulation, it is an iPhone 12 Pro.
And where was it recovered?
Wong apartment, inside a bag in closet.
Mr. Ferguson said, all right. Now, Ms. Loftus, if we could now go to one of these extractions, 1B69BT. And I think it's an Excel, Ms. Loftus. You may need to open it separately. Okay. Thank you. Now, Ms. Volchko, let me focus you first on the column C here. Who are the participants in this chat?
The participants are a contact name of M, and the owner of the device.
What's the owner's name?
Yvette.
And what does it mean when a participant in a chat has the owner parenthetical?
That's the device that was extracted.
Mr. Ferguson said, all right. Now, Ms. Loftus, if we could scroll to the right slightly. And focusing you on column Q, Ms. Volchko, where it says source, what does it say underneath source?
Signal.
What is Signal?
Signal is a third-party messaging application.
All right. And just looking to the right of that, what's the date of this first chat?
November 20th, 2021.
Mr. Ferguson said, all right. Now, Ms. Loftus, we can scroll back. And to make this read a little easier, Ms. Loftus, are you able to hide the CC, BCC, priority, basically columns D through H? All right. Now let's go to row 49, Ms. Loftus. Please.
By Mr. Ferguson.
Now one of the participants was M, Ms. Volchko, right?
Yes.
Okay. Now can you read, now focusing you on column B? That's the sender of the chat, right?
That's correct.
Can you read, what's in column J, the translation for row 49? Mr. Ferguson said, scroll up, Ms. Loftus. And row 49 also has a 47 in column A. Do you see that?
Yes.
And can you read the translated body there?
Great. Thank you, Mimi.
Do you know who Mimi is?
I do not.
Mr. Ferguson said, let's go to row 90, please. All right. And Ms. Volchko, and this is another message from Yvette, the owner?
That's correct.
And can you read what that voice message translation is?
Mimi PH, it's like this, possibly starting from today, or tomorrow, that attorney from HKI. Lee PH will prepare you, that is to fully prep you to testify. And then, that, they. Should be Lee to whom that Aaron PH will give, that is to give some coach. Because Aaron cannot directly participate in your prep. Right, then, Yesterday to Wong PH, said to have you secretly call my phone, and let me listen on the side, ha ha ha. Yes. So perhaps you just call my phone. What time will it be? And then you call my phone. You can call me with this. Don't say anything, then it should be okay. I put it on silent mode and just listen, what do you think?
And then I'll read the responses from the M. Mr. Ferguson said, if we could scroll down a little bit, Ms. Loftus. So it says, ouch. No need. I'm not a 3-year-old child. My dad really doesn't understand me very well. He makes it sound like so hard. He has been nagging me for 3 days. Just say I won't call. Mr. Ferguson said, and we can scroll down now. Let's keep scrolling down. Let's go to row 112. And actually, let's just go to row 132, actually. Okay. Now this is another chat from Yvette, right, Ms. Volchko?
That's correct.
Can you read the translated body?
You tell him or her whether you're willing to, you tell him or her. She asks if you're willing to testify, your tone should be that this is your boat, right? This is your boat. What you have heard now is, hey, this is your boat. What is going on? How come now the boat belongs to my dad? And now my dad is going to jail because of it. It's said that he's going to jail. What is going on? You should start from this tone, this is your belonging. You start from this perspective and tell him, her why you are going to testify, isn't that right? And then, you're not saying that you could help, but saying that this is your property, and you must claim your rights. Your tone should start from the perspective of the owner.
Mr. Ferguson said, Ms. Loftus, could we pull up quickly in Trial Director Government Exhibit 1413? And actually, before we do that, Ms. Loftus, I'm sorry, could we scroll to the right just so we can see the date of that message? And Ms. Volchko, under timestamp, what's the date of that message?
January 21st, 2022.
Mr. Ferguson said, all right. And if we could go to Government Exhibit 1413, Ms. Loftus. And if we could scroll down. And Ms. Volchko, could you read the very top sentence that starts, whereas the evidentiary hearing?
Whereas the evidentiary hearing specified by the First Department's November 4, 2021, order was held on February 2, 2022.
And is February 2, 2022, about 2 weeks after the message we just looked at?
Yes.
Mr. Ferguson said, if we could go back to the Excel, please. And if we could go to row 130. We can skip that. We'll skip down a bit just for time. Go to row 137. All right. And row 137, it's also number 135. Is that another message from Yvette?
That's correct.
Can you read the translated body, please?
Fine, you can come to me at any time, Overall. Even with your own lawyer, our own lawyer afterward. Our dialogue is just pretending that this homework in the background has not been done, as the tone always means that. Well, you are one of the managers and representatives of the entire family's assets, and then the management and representation of family assets in the entire China and Europe, and Asia are different from those in the West. It's equivalent to you being one of the family representatives. The assets you hold are your assets, they are the assets that the family has authorized you to hold. This is your boat, right? And then after that, that is, regarding to your ship, That means that you are not saying you are insisting. But saying if you can show up to help. And saying that this is your asset, you have to be responsible for the family. You have to be responsible for your own assets, and go out to claim this right. You heard that someone distorted and said that this boat belonged to your father. And since your father got into trouble because of this matter is completely intolerable to you. This is why you have to come forward to testify. This is the basic keynote and tone behind it, yes. Regarding this boat, it was your brother who paid for the boat, so, this is between you and your brother. It was your brother who went to pay for the boat. Both you and your brother are, representatives of the family assets. That's the situation.
Mr. Ferguson said, if we could scroll down. And if you could read the next message from Yvette, Ms. Volchko.
That is why Victor wants to talk to you. Because he wants to go over the whole years of 18 and 17 with you. Our entire conversations are just about when we made that application, about your story. Just making sure that this can be matched, don't have Chong pH to have difference. At the same time, he also wants to remind you, that is, to emphasize about the period of time being persecuted. Then emphasize to you about the safeties this, and then the hidden dangers of this safety being threatened. Yes, must emphasize these, yes, I am F-word being threatened and in jail so what, right, similar to this kind. And then there must be this huge potential safety hazard. In view of this, therefore you asked not to appear before. And now even if appearing, the face cannot be shown, those are the 2 points, let's emphasize them first. Yes. The attorney insists that it must be mentioned from your mouth, that's why. In fact, we have prepared with them many times for these stories behind, and they all know how to deal with it. It is just because due to their so-called bullshit professional ethics, he must hear it from the client's mouth. That is the reason. That is why the so-called bullshit is that Aaron can't participate in the prep of your deposition either. Only your lawyerly can, anyway, that's how it works. Yes, you should rest first. Feel free to contact me anytime tomorrow, feel free to contact me anytime.
Ms. Volchko, do you know who Aaron is?
I do not.
Do you know who Victor is?
I do not.
Mr. Ferguson said, all right. Ms. Loftus, let's go back to stip 17 at page 3, please. And the 5th row down for 1B204. All right. What kind of device, according to the stip, was 1B204?
A SanDisk Extreme Pro USB drive.
And where was it recovered?
Moa Mansion, inside a Faraday bag.
What's a Faraday bag?
That's a bag that can prevent any frequencies from entering the inside of the bag.
And what do you mean by that?
Any connections. So it could be cellular service, Bluetooth.
And to your understanding, what purpose do Faraday bags serve?
They can be to preserve the contents, so there's no changes occurring to the device inside.
Mr. Ferguson said, now if we can go to, Ms. Loftus, some of these contents. 1B204-13. All right. And if we could go to page 2. Please. And Ms. Loftus, we can zoom on the top. What does it say on the top left, Ms. Volchko?
Brioni, 688 Madison Avenue, New York, New York.
And then in the center in all caps, what does it say beneath that?
Invoice for Mr. Miles Kwok bespoke order.
Mr. Ferguson said, and if we could zoom out. And if we could scroll back up to the top. And what was the total amount?
There's a couple values at the bottom.
And just looking at, if you want to do the far right total.
The far right is $719,489.55.
719,000?
719,000, sorry.
That's all right. Mr. Ferguson said, let's go to stip 17 on page 2. And towards the middle, 1B121, what kind of device is 1B121?
A red iPhone.
Where was that recovered?
Sherry apartment, inside a bag.
Mr. Ferguson said, Ms. Loftus, let's pull up side by side 1B121C and D, please. All right. And Ms. Volchko, have you ever met the individuals pictured here?
I have not.
Mr. Ferguson said, if we could pull up now 4 exhibits just all at the same time, 1B121H, I, L, and M. Ms. Volchko, have you ever met the individuals pictured here?
I have not.
Mr. Ferguson said, all right. Let's go now to stip 17 at page 3, please. And can we zoom on the 3rd row, 1B255? What kind of device is 1B255, Ms. Volchko?
An iPhone 10.
Where was it recovered?
Moa Mansion.
Mr. Ferguson said, all right. Now let's put up 2 extractions side by side, 1B255C and 1B255D. All right. Now, Ms. Volchko, on the left, 1B255C, what kind of extraction are we looking at there?
This is a wireless network extracted from 1B255.
And where it says SSID, what does that indicate?
That's the name of the Wi-Fi access point.
And what's the name of the Wi-Fi access point?
MAWA.
And focusing on the right, what kind of extraction are we looking at there?
This is a password that was extracted from 1B255.
And what was the account name?
MAWA.
And what's the relation between that account and the wireless network on the left?
They appear similar.
And in password, what was the password? What's the data on 255D?
Home sweet home.
All right. Now if we could just go quickly again to step 17, Ms. Volchko. And we'll go to page 2. Second row from the bottom. And you looked at some 1B125 exhibits before, but just as a quick reminder, Ms. Volchko. What type of device was 1B125?
A blue iPhone.
And where was it recovered?
Sherry apartment, inside a bag.
Mr. Ferguson said, all right. Let's go to 1B125L, Ms. Loftus. All right. So, Ms. Volchko, I'll keep reading the Gladys messages in these types of chats. So this one, let me ask you first, what's the date of this chat?
The date is December 6, 2021.
All right. So I'll read the translation. It says, house update message about the curtain and carpet company, the building cleaning, and landscape company. I have asked the property manager Vinny and the intermediary Christine, and now I'm waiting for a reply. As for the room and movie theater on the 3rd floor, I have also asked. We also need to wait for a reply. Promemoria replied that they wanted to know the concept of the project first, what type of furniture you wanted, the photograph of the house, and the 2D and 3D graphs.
I have asked the broker for this, and I'm waiting for a reply. 4. About the Baccarat crystal lamps. We are waiting for a reply from them that they can give more discounts. The tax is about $250,000. I am considering whether we can still send them to the house in New Jersey, but they can help us pay the tax, and then a smaller discount may be acceptable. About the French brands you sent. There are only stores in France for the first brand. The link to the second and third brand is from the same company. There are branches in New York. Do you have any other favorite brands?
Mr. Ferguson said, and I think that may be it. There's no other page, Ms. Loftus, right? All right. Let's go to 1B125M. All right. And what's the date of this chat?
December 7, 2021.
That's one day after the one we just looked at?
That's correct.
All right. I'll read Gladys, and just focusing on the first chat there, in the body, there's a PDF file. Mr. Ferguson said, and Ms. Loftus, if we could open 1B125M1 from the attachments column. And Ms. Loftus. If we could zoom on the bottom right, just briefly. Ms. Volchko, are you able to read what it says in large text there?
Crocker Residence.
Mr. Ferguson said, okay. Let's zoom out. And we can just scroll, Ms. Loftus. You can keep scrolling. You can just scroll through the end. All right. Let's go back to the chat now, please. It's 1B125M. All right. And if we could scroll down slightly. And we can scroll up. You can go back to the top, Ms. Loftus.
By Mr. Ferguson.
All right. So I'll read Gladys. It says, another floor plan for the house in New Jersey. And then there's a photograph, and it says, this is the elevator interior of the house in New Jersey, and now we are waiting for the circuit breaker to arrive. It is expected that the elevators will arrive on December 20th and will work when installed. Mr. Ferguson said, if you could scroll down. Vinny, the steward, said that it would take about 45 days to connect the movie theater and the rooms. And then there's a photograph. Mr. Ferguson said, Ms. Loftus, are you able to just zoom on that photograph? All right. And Ms. Volchko, can you read the Milesqua text at the bottom there?
This, just the south side of the 3rd floor. It is now another one. Change it like this. How long will it take?
Mr. Ferguson said, and if we could zoom out. And let's scroll down. All right. And there's another photograph, and then can you read the text from Volchko?
In consideration of his current situation. That one where I circled probably needs to be built like that. Just to open it. How long will it take so that these two construction works can be completed as soon as possible? Can they be completed within 1 month? You think if overtime is implemented? Can they be completed within 1 month?
Mr. Ferguson said, if you could scroll down. All right. Now there's a picture and then there's Volchko text. Now, Ms. Volchko. In the bottom entry here, is there both text and an image?
That's correct.
Mr. Ferguson said, now, Ms. Loftus, can we please play the attachment 1B125M8?
Media played.
Mr. Ferguson said, all right. We could go back to 125M. And Ms. Volchko, could you read the translation of that?
Xiaozhua, don't put the head of the bed on the 3rd floor toward the back. Put it towards here. After entering here, most of the bathroom facilities are placed here. Which is Guomei's bedroom. This is Guomei's master bedroom. Guomei's big bathroom is here. And from here to here is her dressing room. Then this is Xiao Chao's room, a small suite. This entrance is here. These are 2 bedrooms. This bedroom and this bedroom are reserved. There can be a bathroom behind this. This is a public living room between the 2 of them. They all can come here. How long will this take? Okay. You can draw a layout and send it to him.
Mr. Ferguson said, all right. If we could scroll down. All right. And again. There's a photo and then there's a message with both text and an image. Ms. Loftus, can we play 1B125M10?
Media played.
Mr. Ferguson said, we can go back to the text.
By Mr. Ferguson.
And can you read the translation, Ms. Volchko?
This is the sides of 3rd floor. The north side of the 3rd floor is Guochang's room. Turn this area into a bed, turn this area into a bed. Open this area up, it should connect with this area. This is the bedroom. Guochang's 2 bedrooms. This is his dressing room. Here is a hallway through here. How long will it take?
Mr. Ferguson said, all right. Let's scroll down. And again, there's another image, another photo sent. And then there's a chat with a text and an image. Ms. Loftus, can we play 1B125M12?
Media played.
Mr. Ferguson said, we can go back to the chat.
By Mr. Ferguson.
Could you read the translation of the audio, Ms. Volchko?
This is Mrs. Guo's 2nd floor, the north side, the north side. Do you see it? Remember the north side of the 2nd floor, the head of the bed is here. Put it here. Then, open this up. Open this up, there are 2, this is her bedroom, this is the bathroom, and this is the dressing room. How long will it take?
Mr. Ferguson said, if we could scroll down. And can you read the next chat, please?
According to you, I need to connect and restore the entire 3 floors and the water. Electricity and restrooms need to be done. 30 days, he needs to find 3 or 4 teams to work overtime. Okay. Don't ask for help from 1 team. 3 teams must be found for the 3 floors, work overtime, give us some time. And give us a quotation.
Mr. Ferguson said, and then the next chat, let's play the attachment first. Ms. Loftus, can you play 1B125M14?
Media played. Continued on next page.
Mr. Ferguson said, can we go back to the chat? Can you read the translated audio, please, Ms. Volchko?
This is dining room on the south side, the southeast corner at the back. Kitchen is here. This Mrs. Guo is converted into a kitchen, from here to here is a cabinet which we customize. Then put an island in the middle and connect to natural gas, water supply and drainage here, which have to be done at the same time. This is one of the biggest projects for projects total, okay.
Mr. Ferguson said, "Is there any more, Ms. Loftus, when you scroll down? There's another photo, and then can you read the last chat, Ms. Volchko?"
Gladys, this place needs to face east, the place where the line was drawn. This position needs to be an ignited stove, inside is the cabinet, a kitchen island is in the middle. This needs to be done, and it's necessary to connect water and natural gas.
Let's go to 1B125N. What's the date of this chat excerpt?
December 8, 2020.
I'll read Gladys. It says, the broker Christine sends an interior designer's profile. She says the designer has designed hotels, offices, large local and New York properties and other places designated by the client. He has a good taste and is very creative and his design has high quality. You can take a look at his information and see if you like it or not. And then there's 2 web page links sent that I'll skip. It says, 3 Baccarat is still trying to get us more discounts and not all crystal whites are in stock. But the staff said it was easy to place an order and get the goods.
Okay, Baccarat. How about their attitude? Their attitude is okay. Baccarat, about this designer. When can we hold a meeting for him? This designer is excellent, but it is not enough. What we want is that super and royal grade. Ask him if they can find another one. Give Christina. We need to have a meeting with the designer as soon as possible to have a understanding, okay?
The attitude of Baccarat is okay.
Then just push that. 20 is impossible. His tax, what's the tax in New York? How much tax can we reduce? I definitely want to exempt this tax 100%.
Mr. Ferguson said, you can scroll down, Ms. Loftus, please. The tax is $250,000 and the New Jersey tax rate is 6.65%. I also asked him to exempt this for us at least.
No, at least this must be exempted. This tax must not be paid. The key is it is not 20. It is impossible. How will I buy so much? At least 50, originally 75% discount, and now 50 is okay.
Was the previous 75% discount given in China? Did you buy something in the name of Beijing Jinquan?
Yes. It seems like they returned to Beijing, Jinshuan to sell things. It is always a discount of 75%. It has always been like this. Later it was changed and then even 50 is not given. This is crazy.
If we can scroll down. You can continue.
I bought some in Jinshuan and Pangu of Beijing. The main problem is that they were registered in my personal name, namely Miles Guo.
Because they all need to look at the records when doing things here. I asked him to find out the records of our orders placed in New York. He said that the discount was 50% because it was in 2010. Now it is 10 years later and the policies are different. But I'll keep negotiating with them. Mr. Ferguson said, Ms. Loftus, do you want to just zoom in on the photos, and we can zoom out? You can scroll down. Ms. Volchko, you can continue.
The place in the circle is the one on the 3rd floor to be connected. If we break the location of the bedhead, it is connected. The location of the 2 bedheads is the corridor to be connected, but you fail to reflect it in the drawing. Second, the new kitchen is located in the corner of the 1st floor. The sink is on the north side and I drew it. No sink is around the stove. There are 2 sinks on the island of the middle kitchen. 2 sinks are placed on the north side, and the fire is on the east side. Please continue to check the drawing I gave you. There is some mistakes.
This picture shows the movie theater on the 3rd floor. You said that the room was empty. But should it be connected to the room next to it? I have marked to connect the room on the 2nd floor, but modified it to extend to the bedside. Mr. Ferguson said, let's go down to 1B1250. Now what's the date of this chat?
December 8, 2021.
And there's another PDF. I won't pull it up, but it says December 8, 21 updated floor plan. And then there's an image. Mr. Ferguson said, Ms. Loftus, you want to zoom in on that image quickly. Who's the sender of this image?
The contact is Miles Guo.
Mr. Ferguson said, you can zoom out. You can scroll down. Then there's another message from Miles Guo with text and an image. Ms. Loftus, let's play 1B12504.
Media played.
Mr. Ferguson said, we can go back to the chat. Can you read the translated audio?
Right. Change the kitchen. This place is the stove. This place is 2 sinks. This is a sink and this is a sink. Here are 2 sinks. This is the place where is kept for stoves. This is the place where the stove can be connected. This. Then a round table will be placed in this place in the future. Well, this is what it looks like. Then this place will also be made into a round table. These is 2 tables. Then remember that all the wooden chairs needed to be removed. We need to replace the staircase with all glass ones. The stairs will be very beautiful. This one comes all the way from the hallway. This is the kitchen on the first floor, which is very important, faucets, stoves.
Mr. Ferguson said, if we can play 1B12505.
Media played.
Mr. Ferguson said, let's go back to the chat and we can scroll down. If you can read that translated audio.
We add security door to this place. Doors that require card swipes. Doors that require card swipes. Then from here to the north end, you see this end. There should also be security doors that require card swipes. You can't enter without swiping your card. This is one. Then employees come down from here and come here. This is an employee space. This is all reserved. Then. This is the employee space. We will not make any change, just change it into a warehouse, nothing else to change. Then this is the swimming pool. Remember the bath space, this is the place. There is a window here. We will replace it. We will replace this place. We will replace it. Replace it with a copper window that can be opened.
Mr. Ferguson said, and can we scroll down? And then there are more pictures. We can just keep scrolling down. If we could play 1B12509.
Media played.
Mr. Ferguson said, we can go back to the chat.
Mrs. Guo's bedroom. This are the bedroom and living room. This place is the dressing room. 2 dressing rooms, big dressing rooms.
Then there's an image. You said there would be a custom cabinet at the kitchen range in the faucet position. Will there still be a cabinet?
Above the stove and on the 2 stone walls in the north there will be customized cabinets which are full cabinets. The walls will be full of cabinets and below the cabinets, is there such mosaic style?
Mr. Ferguson said, and if we could play 1B125013.
Media played.
Mr. Ferguson said, we can go back to the chat. Can you read the translated audio?
The north side of the 3rd floor, that's where the pool table is. This is Guo Chang's dressing room. Remove the cinema. This is Guo Chang's room. He can open it from here and go into his dressing room. See this, okay.
Mr. Ferguson said, can you scroll down? Let's go to 1B125p, please. What's the date of this chat excerpt?
December 14, 2021.
There are several. The first 3 chats, do you see those are .pdf, the first 4?
That's correct.
Mr. Ferguson said, can we pull those up quickly, Ms. Loftus? Let's start with 1B125p1. What does the English say?
Carpets and rugs.
Ms. Loftus, if we can just scroll through some of these pages, let's go to 1B125p2. What does it say in English there?
Furniture.
If we could scroll. Just to pause for a moment. Do you see the domain listed there, Ms. Volchko?
1stdips.com.
We can keep scrolling for a little bit. We can stop there. Why don't we go to 1B125p3? What does it say in English there?
Furniture.
We can scroll some more. Let's go 1B125p4. Beneath Certificate of Authenticity in the top right. What does it say there?
Solomon Treasure.
If we can scroll just a little bit, Ms. Loftus. Let's go back to the chat. I'll read Gladys. It says, the first door is the one from which you decided to buy products, and if we could scroll down. There's another PDF. We can skip over that. It says, you didn't see products of the first store before. But the products are good. There's another PDF, secondstore.pdf. Old man from the second store. Third store PDF. It says Jew from the third store. You can scroll down. And then can you read the text after those images sent by Milesqua?
Joe, thank you for your hard work. These two tables don't buy them because about the table after I checked yesterday, there is no such room for tables. So we won't buy those two tables.
Then there's two images. Ms. Loftus, can you see if we'll be able to read it if you zoom on those? Why don't we pull up the attachment quickly? It's 1B125p11. Focusing on the top left, Ms. Volchko. Can you read what's beneath the image of the bed?
Savoir Harlech N2 bed set handmade in London, US queen size.
What's the list price for that?
$45,300.
We can go back to 1B125p. Let's scroll down. And then if we can pick up, Ms. Volchko. At the bottom chat there.
There is no other discount for the new sofa.
And then the last chat.
These two can be bought directly by the finance department. We can enjoy 10% off with the above code.
Let's go to 1B125Q. What's the date of this chat excerpt?
December 16, 2021.
I'll read the first one. Are these all from silk and wool? Have you bought it or do you want a similar pattern?
I just want better velvet, I want better.
Let's go to 1B125R. I'll read Gladys. Before I do, what's the date of this chat excerpt?
December 19, 2021.
Boss, let me tell you about the new house, that is. I called Vinny and he said that because he wanted to accelerate all the procedures, then the contract and drawings were ready and have been sent to Evan. As for the kitchen you requested, it's extended by a lane and the staircases were sealed. He said that because he knew the architect who had been doing it for 35 years. So he knew that basically it's unnecessary to take some special permissions. Some permits or anything and specifically deal with a lane. So he doesn't think this needs to be added to the contract or add the image now because you want to do everything well as soon as possible. He said that we could do it later, just add it to an attachment indicating that this is your requirement. Then he said that now it's Elaine from the kitchen who wanted to confirm with you. You said that you wanted to add a draw. Do you want to add it to both sides or just one side? He suggested only adding to one side because the other side is narrower. But please confirm with me if it is really added to which side and the style of the draw and what color do you want? Does it need to match with others? According to him, others were built years ago. So this needs to be confirmed with you, and what style do you want?
The style is the same as his current cabinet wood, Gladys, all the same as him. It's okay. Of course, add it to one side. It's definitely impossible to add to the other side. And then it is deep enough to put the pot bowl and basin. Place things below, heavy enough. And it must be of good quality. If none, then the same wood. You can also give us a choice. No problem. Very good.
If you can scroll down, Ms. Loftus, and can you zoom on that image? Have you ever met the individual shown here?
I have not.
We can zoom out. You can continue.
Yes, that's the first thing. Second, is the middle of the island too big? Does it need to be so big? After being sealed, does it need to be so big? Okay, that's it. Great. Thanks, Winnie. It's the island. If it is too wide compared with the normal island, it is better to buy the off-the-shelf product. That is the one with an island. It's guaranteed that it's the whole stone, the highest level dolomite. For example, the table below can be stainless steel, and the drawer can also be stainless steel. The stainless steel is okay. Of course the wood is the best, just like the Max bedside. If there are any other options, the first choice will be the same at this wood. If none, then select stainless steel. But the quality must be good. If it's so wide, it's okay to be narrower.
Then there's I won't make you read the link. You can continue after that.
This table is 340,000. It can be bought after it's sure there's no problem with it. This is the most important, which will be placed in the middle of the hall. It is a great treasure. In addition, for these two baccarat lights, let's see, please communicate with him. If it doesn't work, you can find that young guy who sold the first furniture to us. You can ask him to help communicate and buy something cheaper. He can help us buy cheap things. Gladys, the bed. Just the green bed. There is a pink one. I want to order a pink bed for the room of Mrs. Guo. Order a pink one. And about the other 2 or 3 beds, please check if there is any. My room is large. All king size, the largest bed. I need to buy a bed in my room. Mrs. Guo, I want to buy a bed and then buy a bed for the room of Guo. Others are no longer using beds. No other bed is needed.
If we can go to 1B125S. What's the date of this chat excerpt?
December 22, 2021.
Can you read the translated text?
Didn't you ask him if he had any round ones? Is it in stock, and how big is the largest one?
Mr. Ferguson said, "May I have a moment, Your Honor?"
The court said yes.
By the way, Ms. Volchko, did you have any role in selecting which chats got excerpted here?
I did not.
Did you have any role in selecting which devices were part of that stipulation we've been referring to?
I did not.
Mr. Ferguson said, "Your Honor, I have a couple more exhibits the government is going to offer. Pursuant to Stipulation A, Government offers Government Exhibit 1782, and the government also offers the exhibits, to the extent not in evidence, in Stip 20.
The court said, no objection.
Mr. Kamraju said, no, Your Honor.
The court said, they're admitted.
Government's Exhibits 1780 and Stip 20 received in evidence.
Mr. Ferguson said, and I may need one other moment, Your Honor. Apologies. Ms. Loftus, can we go to 1B125K, please? What's the date of this chat excerpt, Ms. Volchko?
December 1, 2021.
First one is from Gladys. It's an image. Can we zoom on that image? We can take it down. And I'll read Gladys? Boss. This table you asked your comrade to help order is already ready and will be shipped from Shenzhen. Where do you want to ship it?
Now it's going to be delivered to our warehouse, the one in New York.
And it says, is this table intended for that company? Let me see that the company should be responsible for the expenses?
About this, use G Club or another private company for payment. Don't involve anything else. Either G Club or another private company.
Ms. Volchko. Do you have any independent knowledge of what that means, use G Club or another private company for payment?
I do not.
Mr. Ferguson said, no further questions.
The court said, cross-examination.
Cross-examination. By Mr. Kamraju.
Thank you, Your Honor. Good morning.
Good morning.
Could you just pronounce your name for me?
Jessica Volchko.
Thank you. Could we have Government Exhibit Stip 17 up, please? Could we go to page 4? Ms. Volchko. Do you remember on direct being asked some questions about the fourth device down on this list, GXB71Z?
I may have been. I don't recall if it was that specifically.
This device, this was found in the Wong apartment, correct?
According to the stipulation.
According to the stipulation, it was found inside a bag inside a closet, right?
That's correct.
And Wong refers to Yvette Wong, right?
I believe so.
So this device was not found in Mr. Guo's apartment, correct?
That's correct.
Wasn't found in Mawa, right?
Correct.
It was in a closet in Ms. Wong's apartment, correct?
That's correct.
Can we pull up GX1B71, please? You remember being shown this photo on your direct?
I do.
And this photograph comes from the device that we just talked about, right?
Can I see the exhibit number?
Sure. GX1B71I.
Yes, that's correct.
So this photograph was found on a phone that was found in Ms. Wong's apartment, not in Mr. Guo's apartment. Correct?
That's correct.
Let's take that down. Now, do you know if Ms. Wong had any connection to a company called G Clubs?
I do not.
Do you know if Ms. Wong was involved in any acquisition of benefits for G Clubs members?
I do not.
Do you know who Limari Reyes is?
I do not.
Is your only exposure to the Lamborghini shown in that photo through your preparation for testimony?
Yes.
Now, could we have GX1B124 please? Alongside it, if we could pull up the stip, GX stip 17. If we could go to page 2 of the stipulation. You see, I think it's the third from the bottom there, GX1B24Z. Do you see that?
I do.
And so that was found at the Sherry apartment inside a bag, right?
That's correct.
So it wasn't found on Mr. Guo's person, right?
That's correct.
So now we can take the stip down for a second and blow up the other exhibit, please. Let's go to page 2. Do you remember Mr. Ferguson asking you about certain email accounts reflected here?
I believe I was asked about a couple of accounts.
So, for example, I think he asked you about in row 10 an email called Guo Miles at Guo Media. You see that?
I do.
Can we look at the second account listed at the top of the page? Can you read the username?
The username is GladysC@hchtech.com.
What's the service type?
Exchange.
What is that?
That's an email service.
Let's look at the one right below it, 3. Can you tell us what the username there is?
tang2022@gmail.com.
What's the service type there?
iTunes Store.
I think we all know, but can you tell us what that is?
iTunes Store, you can buy applications for your phone.
Can we go down to the next one? What's the username there?
dhxbhcs20220327@gmail.com.
And the service type?
iTunes Store.
Can we look at row 9, please? Username there.
Jingong20.
And the service type?
Twitter.com.
And now let's look at row 12. Can you tell us what the username is there?
woiwodigianic@gmail.com.
Can you tell us again the fact that any of these email addresses appear in this report at this section? What does that mean?
These are accounts that are associated with the device, so they may have been logged into the device. Certain applications from the device at some point in time.
Can we go to page 1, please? Could we blow up the line it's right under tethering that says Last Hotspot Act? Do you see that?
I do.
What does last hotspot activity mean?
I believe that's referring to the last time it was connected to a hotspot. So you could set up your phone to almost like a Wi-Fi connection.
So this is some evidence of internet connectivity?
Yes.
What's the date on that?
May 11, 2023.
Are you aware that Mr. Guo was arrested on March 15, 2023?
I'm not sure of the date.
Would you agree with me that May 11th is approximately 2 months after March 15, 2023?
That's correct.
Now, you can't tell from just this Celebrate report who actually used the phone, correct?
I can just tell the accounts that are associated with the device.
And so you don't know who's sitting at the keyboard, right?
That's correct.
You can take that down. Can we pull up GX1B15GT? I think it is GX1B15G, and I think it's the translation. I think it's the one you had right before this, GX1B15GT. You remember testifying about this on direct?
I do.
Remind us again what the created time means.
The created time appears to be when the tag was created. So as the device was being reviewed. Either the case agent or whoever was reviewing the report would have tagging this specific note.
This is an Excel spreadsheet, right?
That's correct.
So the created time gets inserted into the Excel spreadsheet?
That's correct.
So the data on this Excel spreadsheet could be changed, right?
I guess it's possible.
That's what happened with the created time, right?
This is from the report, so that was when you generate a Celebrate report. There's certain values that are entered into the tag report.
Right. But this is not some kind of locked document, right? It's susceptible to being changed, right?
That's correct.
Mr. Ferguson said, objection, it's stipulated to.
The court said, sustained. If you would speak into the mic more, Mr. Kamraju, please.
Mr. Kamraju said, I didn't hear what the objection was.
Mr. Ferguson said, objection, it's stipulated to.
Could we pull up GX1B92B13? Do you remember testifying about this document?
I do.
So can we look at the email at the top left there? Can you just read that for us?
cool_HHR@hotmail.com.
That's not a Proton email account, right?
It appears to be a Hotmail account.
There's no date on this document, correct? We can zoom out.
I don't see a date on the document.
You see where it says experience March 2014 to current?
I do.
So we can't tell from this document what current means, right?
That's correct.
And we can't tell from this document when it was placed on the phone, correct?
Not from just looking at the document.
And we can't tell from the document who authored it, correct?
That's correct.
And you've never heard of Haran He, the man named on the document, correct?
I have not.
Let's go to GX1B2722, please. Do you remember testifying about this?
I don't recall this one specifically, but I remember looking at preliminary device reports.
We can scroll down. I think this is fine. If we blow up page 2, just the first account there. You see that that's Max Krasner?
I do.
So this is an account that this Gmail withdrawn. This Gmail account was accessed at some point from this phone, correct?
That's correct.
Now if we could pull up, we can take that down and we can pull up GX1B272B. Remember testifying about this document on direct?
I do.
You don't see a date on this document, right?
I do not.
And you don't know who Mileson is, right?
That's correct.
If we can go to page 21. Before we talk about this specifically. You testified on direct about certain signal messages that were extracted, right?
That's correct.
So when the FBI extracts signal messages, it's actually pulling the actual message out of the phone.
That's correct.
And then it gets represented on that spreadsheet that you had.
That's correct.
This is not that, right? This is a screenshot, right?
It appears to be a screen capture.
And you can't tell from the screen capture who did it, right?
What do you mean by who did it?
Who took it?
Who took the screen capture? I can't.
And at the top there you see it says Yvette.
I do.
If we can go to page 22, the next page, who's it say up there?
Mileson.
So that's two different people in your mind.
It appears to be, yes.
So this appears to be a screen capture of a collection of text messages, correct?
Correct.
And you don't know who put the collection together, right?
Who took the screen captures?
Well, who decided to group these various text chains together?
I do not.
You never heard of Max Krasner before, right?
I have not.
Your only involvement in this case at all is testifying here today, right?
Testifying and analyzing some of the digital evidence items.
You weren't part of the team that actually conducted any of the searches, right?
I was present at one of the search warrants.
Which one?
Mawa.
Mr. Guo wasn't at Mawa when you were there, right?
I don't believe so.
Could we pull up GXC9, please? Can we go to page 35? You remember Mr. Ferguson asking you to read some portions of this?
I do.
I'm just going to ask you to read a little bit. Okay. Do you see? It's the third full paragraph that starts, the protection of small investors. Do you see that paragraph?
I do.
Could you read the second to last sentence?
We're asking the SEC to investigate, and we're asking the DA's office and the DOJ to investigate.
Can you read the next sentence, please?
You can investigate as long as you guys get our stuff clarified.
You can take that down. Can we go to Government Exhibit 1B69Z? You have a copy of the stipulation in front of you still?
I do.
Would you mind turning to page 4, please? GX1B69Z was a white iPhone found in Ms. Wang's apartment. Correct?
That's correct.
And again it was found inside a bag in a closet, right?
That's correct.
So it wasn't found on Ms. Wang's person, right?
That's correct.
Could we pull up now 1B69BT? This spreadsheet is from the phone that was found in Ms. Wang's apartment. Correct?
That's correct.
In the bag in the closet, right?
That's correct.
Now, could we go to row 47, please? Sorry, I meant 49. So do you see there it says, great. Thank you, May.
I do.
And then there's a message below that's from whatever that account handle is, right?
Can you just scroll over so I can see the sender column?
Sure.
The other direction.
To the left.
Yes. It was sent from the contact.
And could you read the message that appears in row 48? I guess it is the one right under thank you. May.
There's an account on Twitter posting a video of my grandma's pass away. Can you find a team to get rid of it?
And then if you go down 2 more rows, do you see a message from Yvette the owner?
I do.
What's that say?
I'll arrange that.
Can we go to row 90, please? It's the red highlighted one. There's 2 sets of row number. Can you read the first sentence of the message there?
May, it's like this. Possibly starting from today or tomorrow that attorney from HKI Lee will prepare you. That is to fully prep you to testify.
You don't know who any of those people are, right?
That's correct.
And you never heard of Aaron before?
That's correct.
You don't know if Aaron is a lawyer involved in this case, right?
That's correct.
You don't know if Aaron has any involvement whatsoever, right?
That's correct.
Can we go to row 132, please? I guess it's 131. That one right there. Do you see about 4 sentences in there, something that starts, then, that, don't use video? Do you see that?
I do.
Could you read that sentence?
Then that don't use video because it will endanger safety, endanger your safety.
Can you read the next sentence?
You can bring out all the safety concerns including persecution.
And then the next sentence.
Because the lawyers internally are fighting with the other party, and the court that is to say about not allowing you to appear in video, which means either by audio or only by, that is to say, transcript.
You don't have any idea what the speaker means when they talk about safety concerns including persecution. Right?
That's correct.
You don't know in fact what any of this text message is about, right?
That's correct.
Take that down, and if we can go down to, you have the stipulation still in front of you?
I do.
If we can look at page 3. And do you see it's the fifth device down, GX1B204Z?
I do.
That says that phone was found inside a Faraday bag, right?
This was a USB drive.
Sorry. The USB drive was found inside a Faraday bag, right?
Yes.
You testified a little bit about what a Faraday bag is, correct?
Yes.
The FBI also uses Faraday bags, right?
Yes.
Describe for the jury how the FBI uses Faraday bags.
Sometimes when we're executing a search warrant, when we seize devices. If we can't disable any kind of communications, to preserve the data, we'll put them in a Faraday bag.
How does the Faraday preserve the data?
It blocks any signals from reaching the device, or any signals from leaving the device.
What's the import of blocking signals that are coming into the device?
It preserves the device at the state when it was seized, and it can also prevent the device from being wiped remotely.
So it helps stop remote access of the phone, is that right?
That's correct.
So like packing of the phone, right?
I guess you could say that.
Could we look at GX1B204-13, please? You remember being asked some questions about this?
I do.
And you remember being asked to read, I think it's at the top of the page, the name Brioni?
I do.
You do.
I do.
Now, pick any of these rows. You don't see any dates associated with them, right?
I do not.
And that number that you read out, $719,489.55. You remember reading that?
I do.
You have no idea when that money was spent, right?
That's correct.
Could we pull up GX1B125 please, H, I, L and M? I'm sorry. My apologies. Could we do GX1B121 C and D first? You remember being asked about these?
I do.
You have no idea when these photographs were taken, right?
Not from looking at the photographs.
You don't know who any of the people in there are, right?
That's correct.
You don't even know if this is actually a Brioni suit place, right?
That's correct.
It's just a photo of a man trying on a suit, right?
That's what it appears to be.
Now could we do GXB125H, I, J, L and M? You remember being asked some questions about these photographs?
I do.
They're photographs of men talking, right? Fair to say.
That's what it appears to be.
Do you see the bottom too? You see there's an airplane in the background?
That's correct.
This was taken in an airport hangar, correct?
I'm not sure.
Are you aware that these photos were of an interview that occurred in 2018?
I'm not.
Are you aware that 2018 is 2 years before the GTV private placement?
I'm not.
Are you aware that 2018 is 2 years before the farm loan program?
I'm not.
Are you aware that 2018 is 2 years before the launch of G Club?
I'm not.
Are you aware that 2018 is nearly 3 years before the launch of the Himalaya exchange?
I'm not.
Mr. Kumraju said, "No further questions, Your Honor."
The court said, redirect?
Mr. Ferguson said, "No redirect, Your Honor."
The court said, "You may step out."
Witness excused.
The court said, "The government may call its next witness."
Mr. Horton said, "Just something briefly from the podium, Your Honor." Your Honor. At this time the government intends to play a video that's in evidence as GXVI 151.
The court said, "All right."
Mr. Horton said, "Your Honor, we have some technical issues which we're working to resolve. It should be one moment."
The court said, "Okay."
Media played.
Mr. Horton said, "Thank you, Your Honor. The United States rests."
The court said, "All righty. Would you please step up?"
Continued on next page. At the sidebar.
Ms. Shrofa said, "We thought the day would never come."
The court said, "Okay."
Mr. Kamraju said, "At this time, Your Honor, pursuant to Federal Rule of Criminal Procedure 29. Mr. Guo asked for a directed verdict of acquittal on the basis that the government has failed to prove several elements of its case, including Mr. Guo's fraudulent intent, materiality or misrepresentations or alleged misrepresentations at issue. In addition, in connection with the money laundering counts as a result of their failure to prove the underlying fraud counts, there's no specified unlawful activity for criminally derived property. And similarly, the government has failed to prove racketeering conspiracy. I'm happy to address that further if Your Honor wants."
Mr. Finkel said, "Your Honor, as the court is aware, the defendant bears a heavy burden. As the Second Circuit has made clear, a valid Rule 29 motion of all evidence and all inferences must be drawn in the government's favor. Frankly, I think Your Honor's decision yesterday indicating motion pretty much addresses that there is sufficient evidence for this case to be brought to a jury. Happy to address any particular arguments that defense counsel is ready to if the court would like."
The court said, "The application is denied. May I tell the jury that the defense is going to put on a case?"
Ms. Shrofa said, "Yes, Your Honor. Your Honor, just under Rule 29, the statute gives us 7 days. We would ask for the court to give us additional time so that we consider what we would like to put in a written submission. We can put those timetables to the court."
The court said, "Yes."
Ms. Shrofa said, "Thank you."
Continued on next page. In open court.
The court said, "Members of the jury, the government has rested and has finished presenting evidence, but that does not mean that the case is over. The defense is going to put on a case, and we will start that after your break. It's very tempting now that the government has rested to start talking about the case, but you can't. You can't do that until I tell you that it's time, and that won't happen until after the defenses finish its case. We have summations and my instructions on the law. So remember that you're not allowed to discuss the case amongst yourselves, or with anyone else. Don't permit anyone else to discuss the case in your presence. Don't read, watch, or listen to anything from any source that touches upon the subject matter of this case. We will resume at noon."
The law clerk said, "Jury exiting."
Jury not present.
The court said, "Please be seated. Is there anything before we break?"
Mr. Kamraju said, "Not from the defense."
Mr. Ferguson said, "Not from the government."
The court said, "All righty then. We'll start again at noon."
Recess. Jury not present.
The court said, "Please be seated. Mr. Kamraju, is he?"
Ms. Shrofa said, "Good afternoon, Your Honor. He isn't here, but..."
The court said, "Oh. Has there been a decision with respect to whether or not Mr. Guo will be taking the stand?"
Mr. Skirik said, "There has not yet, Your Honor."
The court said, "Mr. Guo, do you understand that you have the right to take the stand and testify in your own defense?"
Ms. Shrofa said, "Your Honor, may we just have a moment?"
The court said, "Yes."
Ms. Shrofa said, "Thank you."
Ms. Schroff conferring with the defendant.
Ms. Shrofa said, "Thank you, Your Honor."
The court said, "So Mr. Guo, you understand that you have the right to take the stand to testify in your own defense?" The defendant, "Yes." The court said, "And you're going to discuss that with your attorneys thoroughly, and I am going to return to this question about whether or not you're going to take the stand. Do you understand? The defendant, yes, Your Honor. The court said, all righty. Let us have the jurors brought in, please.
Jury present.
The court said, please be seated, and the defense may call its first witness.
Mr. Skirek said, thank you, Your Honor. The defense calls Raymond Dragon.
Witness sworn.
The court said, would you please state your name and spell it?
The witness said, yes. My name is Raymond Joseph Dragon. That's RaymondJoseph
The court said, you may inquire.
Mr. Skirek said, thank you, Your Honor.
Raymond Joseph Dragon, called as a witness by the defendant, having been duly sworn, testified as follows. Direct examination. By Mr. Skirek.
Good afternoon, Mr. Dragon. Where are you currently employed? I am employed at Anchin, Block & Anchin, LLP. Okay. And what is Anchin, Block & Anchin? Anchin, Block & Anchin is an accounting and consulting firm based in New York City. Okay. Thank you. Mr. Dragon, where did you go to school? I went to undergraduate college at Lehigh University, where I majored in international relations and graduated with high honors. I have a Master of Business Administration degree, commonly referred to as an MBA, from the Kellogg School of Management of Northwestern University. And I have a Master's of Science degree in Economics from the University of London. Okay. Now just returning to your current employment at Anchin, Block. How long have you been with that firm? I've been with Anchin for 8 years. Okay. And what is your role at Anchin? At Anchin, I'm the Director of Business and Intellectual Property Valuation. And how large is that group at Anchin? The group is called our Forensic Litigation and Valuation Services Group. And it's approximately 20 people. And did I understand you correctly that you're the head of this group? I am the head of the Valuation Services. The overall head of the group is Anthony Bracco. Okay. Now what do you do in the Valuation Services Group? What services do you provide? I provide valuation of privately held companies, interests in companies, and intellectual property. Okay. And prior to your time at Anchin, Block, do you have other experience in valuation services? Yes. I've used valuation services in a variety of roles. I worked for an international bank in the mergers and acquisitions area. I worked for an international trading company, looking at their venture investments. All of these jobs require the use of valuation skills. And for approximately how many years before you joined Anchin did you work in those other roles that you just described for us? In addition to valuation consulting, my overall valuation banking and investment experience is over 25 years. Okay. Now do you have any certifications in the field of business valuation? I do. I'm an accredited senior appraiser with the American Society of Appraisers in the area of business valuation. And what does it mean to be a certified appraiser? Membership in the American Society of Appraisers requires that you complete a course of study specifically devoted to valuing privately held businesses. That you have at least 5 years of experience valuing privately held companies. And that you submitted 2 peer-reviewed reports of business valuations that the Society reviewed and found acceptable. Okay. Now are you a member of any other trade associations or professional groups related to business valuation? Yes. I'm also a certified patent valuation analyst. And I'm a member of the local New York City American Society of Appraisers chapter. Okay. Thank you for that description of your experience. Now what have you been asked to do as part of this case? I've been asked to determine the value of the equity of GTV Media Company. Okay. Now have you been compensated for your work on this matter? I have. Okay. And how? I bill at an hourly rate for my time. And what is that hourly rate? My hourly rate is $695 an hour. Okay. And approximately, to date, what have your total fees been? Approximately $68,200. Okay. Now have you also been reimbursed for some of your expenses? Yes. And can you just describe those briefly for the jury? Sure. I have driven into Manhattan to testify to this court area, I have parked my car. And I have also had bridge tolls. So those all together, the toll is, I believe, for New York bridges, 17.63. The parking is about 30, and the other component is, the mileage is about 67 cents a mile. Okay. And is it the case that the defense team here has agreed to cover your travel costs that you just described? Yes, it is. Okay. Now, does your compensation here today depend in any way on the outcome of this case? No, it doesn't. Does your compensation depend on whether you testify a certain way? No, it doesn't. And before you were engaged on this matter, had you and I ever worked together before? No. This is the first time that I've ever been on a case where you've been present. Okay. And how about any other member of the defense team? Have you ever worked with any member of the defense team before this engagement? No. Okay. And then how about Mr. Guo? Have you ever done any work for Mr. Guo before? No. Okay. Now I'd just like to talk a bit about what materials you reviewed in connection with your engagement. What materials did you review prior to your testimony today? I reviewed the April 20, 2020, private placement memorandum. I reviewed valuation report from a consultant. I reviewed company forecasts. I reviewed a consultant's forecast.
Mr. Ferguson said, Your Honor, objection. It's not in evidence.
The court said, sustained.
Okay. Apart from the forecasts that you were just describing, can you please describe what other materials you may have reviewed?
Mr. Ferguson said, same objection.
The court said, sustained to the extent they're not in evidence.
Mr. Skirek said, Your Honor, may we have a brief sidebar on this, please?
The court said, okay.
Continued on next page. At the sidebar.
Mr. Skirek said, Your Honor. The way we understand the court's rulings is that the witness is permitted to review any number of materials. Even those materials that are not in evidence, and at this point I'm simply asking him what he reviewed. He's not relating any hearsay from those documents, which of course we understand Your Honor has ruled on. He's simply describing to the jury what materials he's reviewed.
Mr. Ferguson said, those materials relate to portions of his proposed opinions that the court has excluded. So I don't know why they would be relevant, particularly with reference to the consulting report. That's the A&M report that Your Honor said cannot be part of his testimony. I think the comparator companies is another example of what cannot be part of his testimony. So I don't see how this is relevant at all, in addition to not being evidence.
The court said, so are you referring to general materials not specific to this case?
Mr. Skirek said, no, Your Honor. We're referring to materials that are specific to this case. But Mr. Ferguson objected. Your Honor sustained the objection when he listed materials that I take it the government takes the position are, out of bounds based on the court's rulings. I then asked him, aside from those materials, have you reviewed anything else, trying to?
The court said, but I don't know what he knows. How do I know what's been excluded? Does he know?
Mr. Skirek said, aside from the materials that the government objected to him testifying about. I asked what else has he reviewed, so.
The court said, yes, but I don't know that he can read the government's mind. So I just don't want him to start talking about something that's prohibited.
Mr. Skirek said, understood. He is aware that I am representing to the court there are other materials that he's reviewed that have nothing to do with the materials the government has objected to. That's all I'm trying to get out.
The court said, like what?
Mr. Skirek said, he's reviewed a couple of stipulations in the case that are relevant to his testimony. And he's reviewed, there are other materials. It's escaping my mind at this point. But there are other materials having nothing to do with materials that the court has excluded.
Mr. Ferguson said, if he wants to just lead and say, did you also review stipulations, that's fine. Just to make this faster.
Ms. Schrofa said, or he can object and she can decide.
The court said, so there was a suggestion. Go ahead and lead.
Mr. Skirek said, okay. I'll take the court up on it.
In open court. By Mr. Skirek.
Now, Mr. Dragon. Did you also review other materials that were provided by the defense to you in connection with your preparation for testimony today? I did. Okay. And did you review certain stipulations that were entered into by the parties in this case? I did. Okay. And were there other materials in addition to that as well? There were. Okay. Now did you perform a valuation analysis of GTV? I did. Okay. Can you just briefly explain the methodology that you used to the jury? Yes. In valuation, I use what is called a market approach. Mr. Dragon, we're focused on the particular approaches that have been the subject of recent discussions.
Mr. Ferguson said, and Your Honor, we would just move to strike reference to the market approach.
The court said, yes, that is stricken.
Okay. The methodology I used is called the backsolve method. Can you just explain to the jury briefly what that is? Yes. The backsolve method is that, used to determine the value of a company by looking at the value of a large transaction in the company's shares. Mr. Skirek said, okay. Your Honor, the defense offers Mr. Dragon as an expert in business valuation.
The court said, any objection?
Mr. Ferguson said, no objection.
The court said, all right. So he is qualified as an expert in business valuation.
Mr. Skirek said, thank you, Your Honor.
By Mr. Skirek.
Mr. Dragon, what is a valuation analysis? A valuation analysis is determining the value of a company or its stock or a portion of its stock for various purposes. In cases where the company is not publicly traded. With a publicly traded company like, say, Ford Motor Company. I could go to the New York Stock Exchange and see what the price of a Ford share is today. And then I could multiply that by the number of Ford shares outstanding and come to the value of the stock of Ford Motor Company. A valuation expert is called in when the company is not publicly traded. Okay. Thank you for that. And can you just explain to us why a valuation analysis may be performed? Sure. The valuation analyses are performed for a variety of reasons. I mean, one of them is if, say I have 3 partners in a business and one of them is getting old and wants to retire. And the other 2 partners want to buy him out. So the question is, what's a fair price for his portion of the company? That would be one example. A second example would be for estate and gift tax purposes. The IRS requires that if I gift, say, 25% of a company I own to my children, that I have that valued so that the IRS knows the value that was given to the children for estate and gift tax purposes. Another reason valuations are performed is for financial reporting. If a company is a company getting an audit, according to generally accepted accounting principles, let's say this company has an investment in another company that's private. The generally accepted accounting principles, which are often referred to as GAAP. You may have heard that term, are that this investment has to be valued at its fair value. So in order for the financial statements to be accurate. So in that case, the investment that one company has in another company would be valued. So that's another example. Another example of valuation being used is in divorce cases under marital law. You have to, under marital law, determine the value of a business, which is often a couple's biggest asset. For equitable distribution and also for alimony purposes, how much does that business throw off his income? And so a valuation expert will be called in to analyze the company, determine its income, and determine the value of the company. And then the final area or another area that valuation is used is in the context of litigation where there's a dispute over valuation. The valuation expert is called in to determine the value of the company in question. Okay. Thank you for that. Now does valuation also arise as part of fundraising for private companies? It does. Okay. And does that include private placements? Yes. Okay. Before. I'm sorry. Go ahead. When a company is planning a fundraising, they need to know what price to offer the shares they're going to sell at. So that could be a private placement or it could be an initial public offering. And the people working on the offering will determine a valuation for the company and the shares being offered. Okay. Now did you review documents relating to the GTV's private placement? I did. Mr. Skirek said, okay. If we could please bring up what is in evidence GXVK 5. Does everybody have it? Okay. Now, Mr. Dragon, are you familiar with this document that's displayed on your screen? I am. Okay. And is this one of the documents you've reviewed in preparation for your testimony? That's correct. Okay. Can you just explain briefly to the jury what this document is? Sure. This is the GTV Media Group Incorporated Private Placement Memorandum dated April 20, 2020. Okay. And is it fair to say that a private placement memorandum is sometimes referred to by the acronym PPM? Yes, that's the case. And sometimes by the acronym CIM, for Confidential Information Memorandum. That could be used as well. Okay. Now are private placements common transactions? They're very common. Private placements are done very regularly. Okay. And why do companies offer shares of their stock to investors in private placements?
Mr. Ferguson said, objection.
The court said you may answer.
Investors offer shares of their stock to, or companies offer shares of their stock to investors so that they can raise capital to expand and grow their business. Okay. And is PPM or CIM a general term that's used in the industry? PPM is a commonly used term, and CIM is used as well, although less frequently. Okay. If we could please go to page 2 of this exhibit in evidence, GXVK5. And Mr. Dragon. I'd just like to focus you on the top of this document, the first paragraph. Under the heading Confidentiality and Disclaimer. Do you see that? I do. Okay. And if you could just read that aloud, please. It says, Confidentiality and Disclaimer. This confidential information memorandum is intended for discussion purposes with select parties interested in evaluating an opportunity to invest capital into GTV Media Group Incorporated, the company, or GTV Media. GTV Media is a newly formed company incorporated in April 2020. All descriptions of the business of GTV Media in this document refers to business GTV Media intends to do in the future. There is no guarantee that GTV Media will enter into those identified businesses or that GTV Media will be successful in those businesses. Now, Mr. Dragon, did you consider this language in conducting your valuation analysis of GTV? I did. And what stage of development was GTV at the time? GTV Media was what we would call a startup company. A startup company has a business plan, has looked at the markets it intends to go into, has put together a management team. But it hasn't yet raised money or commenced operations. Okay. Now is it unusual for a company in the startup phase you just described to seek investment shortly after incorporating?
Mr. Ferguson said, objection.
The court said, overruled. You may answer.
No, it's not unusual at all. In fact, it's typical for companies to go and seek capital because they need the capital to develop their business. Okay. Now with an early-stage startup company, what ways are there of valuing such a company before it goes into business? In valuing a company like this, you can consider a variety of things: the size of the markets, the potential customers, the products and services that are going to be offered, the potential interest in these products and services, if there's forecasts available, forecasts or projections for the business, and overall, is this an industry that's growing? Is this where other companies have been successful, and if it is, then potentially is this a good business opportunity? Okay. And because a startup company doesn't yet have any historical operating record, does that prevent a business valuation from being performed?
Mr. Ferguson said, object to leading.
The court said, overruled. You may go ahead.
No, it doesn't prevent a business valuation from being done. In fact, there is a whole industry of people called venture capitalists whose job it is to look at business plans and new business opportunities and decide whether they want to invest people's money in them. Okay. Thank you for that. Mr. Skirek said, if we could please, Jorge, just turn to page 6 of this document. And please blow up section 1.3 entitled Goals. Now, Mr. Dragon, could you please read these 4 bullets? Yes. Section 1.3 Goals. To create a unique and the only news-focused social media platform revealing the truth about China. To build an online business trading platform, free of control by the Chinese Communist Party. Focused on the 1.4 billion Chinese people for their personal and business transactions. To be the safest platform to advocate for truth, freedom of speech and religion, justice, human rights, and democracy in China, and to be a bridge between China and the Western world. And allowing for free and open communication, business transactions, and trading, uncensored by the Chinese government. Thank you. Did you consider this language in conducting your valuation analysis? I did. Okay. And how did this impact your valuation analysis?
Mr. Ferguson said, "Objection, Your Honor. It's outside the scope of the court's ruling."
The court said, I'm going to permit the question.
Could you repeat the question? Yeah, sure, of course. The question is, how did this section 1.3 that you just reviewed impact your valuation analysis? As part of my analysis, I assessed the potential market for a business opportunity and my.
Mr. Ferguson said, "Objection and move to strike, Your Honor. This is outside the scope. And we may need a sidebar."
The court said, all righty. Step up.
At the sidebar,
Mr. Ferguson said, "Your Honor permitted him to testify about the backsolve method. Which is essentially they sold shares at $1 per share, they issued 2 billion shares. A lot of people bought at that price, therefore, its reasonable valuation is $2 billion. He's just talking about the market. Your Honor excluded market approach. This is not the backsolve method. He should not be allowed to offer expert testimony about this. It's way beyond the scope. And it should be stricken."
Mr. Skirek said, Your Honor, I think that analysis is a touch facile. Just because he used the word market doesn't mean that he was using or referring to the market approach to valuation. Which is entirely different from just talking generically about the market that exists for a company's goods or services. As Your Honor knows, the market approach to valuation has to deal with selecting comparator companies and looking at their revenues and looking at their profits and then trying to derive from that information a value based on other data points in the market. That is not at all what he's talking about. Now what he's talking about are qualitative factors that went into his analysis and thinking on the valuation. And that goes into whether or not the backsolve method, when it's applied, is a logical way to check a company's value by using the data points that the court has already approved as being a valid method of assessing valuation. And he's got to be able to testify to these qualitative areas that he took into consideration. The government didn't move on it. There's no order excluding these qualitative factors.
The court said, so I think this is general background information that is relevant to any valuation of a company. Not so specific as to the methods that I've excluded.
Mr. Skirek said, Thank you, Your Honor.
Mr. Ferguson said, I would say, Your Honor, it seems like this just doesn't relate to the backsolve method he employed. So we're worried that we don't know how he's going to answer these questions of, what did you think about in valuing the company? We should just get to the backsolve he actually did. Which Your Honor ruled was reliable, and not the things that Your Honor excluded as unreliable. And we did move on it. And the court excluded it.
The court said, do you have any more questions about the market?
Mr. Skirek said, we're just going through he's looking at the PPM, he's looking at the CIM, which is a key document. That's part of his analysis. And I'm just asking him, did you rely on this, what did you take from this, that's all. That's it. I mean, it's.
The court said, what else are you going to ask him?
Mr. Skirek said, there's a handful of other points in this PPM that we're going to go through, and that's really it. And it goes to your point, Your Honor's point. This is background. It's all relevant to the background of valuation.
The court said, how many questions?
Mr. Skirek said, let me just count.
Mr. Ferguson said, in the PPM is the offering of $2 billion shares and $1 a share. And we assumed that was what they were going to go to with the PPM. Not other stuff talking about things that are not the backsolve method. Otherwise we would have raised this objection in the morning before Your Honor.
Mr. Skirek said, well, there are probably 6 or 7 different things I would like to point him to that are all.
The court said, tell me what you want to point him to.
Mr. Skirek said, sure. The section, just to be clear for the record, is labeled goals, right? Goals of the company. That's what we're questioning him about now. The next section is plan. The next section is proposed transaction, which describes the shares that are going to be sold. The next is the summary of investment terms. Risk factors. The fact that the company has no operating history. The fact that the company's management has broad discretion. The fact that the company doesn't expect to gain any dividends. And that's it.
Mr. Ferguson said, Your Honor, he is not an expert on any of those things. He's reading a document as an expert. It's improper expert testimony. They should go to what he actually did as an expert. This is totally improper. You can't call an expert to bolster him reading a document that he has no personal knowledge of as if it were to bolster it. And it violates the court's Daubert orders.
Mr. Skirik said, We completely disagree, Your Honor. This is a foundational document. It is the offering memorandum for the transaction that he is. May I finish, please?
Mr. Ferguson said, Yes, of course. I am waiting.
Mr. Skirik said, I didn't interrupt you. It's the foundational document for this transaction that is obviously an enormous issue in this case. And he's got to be allowed to explain what he took into consideration. This document is in evidence, right? He's got to be allowed to say what he took into consideration. And reading factors that go to all of the things that I just read. And it has nothing to do with the market approach or the income approach to valuation, Your Honor. It has absolutely nothing to do with it. We're not asking for him to talk about comparator companies. We're not asking to talk about the projections. The court excluded discussing the Alvarez and Marcel report. We're not going anywhere near it. That is excluded. This is merely background to help inform the jury as to what he relied on in arriving at his opinion. Otherwise, there's no rule that says I need to stand an expert up and he just spits out his opinion and it's over. I have to be allowed to provide some context for it.
Mr. Ferguson said, Of course he can talk about what goes to that opinion. None of this goes to his actual opinion.
Mr. Skirik said, That's your view, not his. He hasn't even testified to it yet.
Mr. Ferguson said, They qualified this person as an expert, and now they're trying to use that expertise. Clearly in violation of the principles of the Daubert case, to bolster stuff he has no idea about. He's not offering any expert opinion about, he has no personal knowledge of, and he's going to say, yeah, no. That's totally normal, this is.
The court said, You can ask, Did you consider the offering memo with respect to? And then just hit the topics without going through the details, not reading from it. Just ask whether he considered those, the plan, etc.
Mr. Skirik said, Okay. In that context, Your Honor. May I be permitted to lead so that I can summarize what those topics are?
The court said, No, it's just the general topics.
Mr. Skirik said, Okay. All right. Well, I'm happy to give it a shot. I think without being able to ask a somewhat leading question, it's going to be difficult for me to do summary. But I'll do my best.
The court said, Well, you can lead to the extent that you can say, Did you consider the business plan? That sort of general kind of a question.
Mr. Skirik said, Sure. That was my thought, Your Honor, to some extent. Thank you.
The court said, All right.
Continued on next page. In open court.
The court said, Go ahead.
Mr. Skirik said, Thank you, Your Honor.
By Mr. Skirik.
Now, Mr. Dragon, we've just reviewed section 1.3 labeled goals, which is highlighted on everyone's screen. Now is it fair to say that this impacted your valuation analysis?
Mr. Ferguson said, asked and answered.
The court said, Sustained.
Mr. Skirik said, I'm not sure we ever got an answer.
The court said, I'll permit the answer. Go ahead.
Mr. Skirik said, Thank you, Judge. Yes, I considered this. Can you explain, please?
Mr. Ferguson said, Objection.
The court said, Sustained.
Mr. Skirik said, Okay. If we could please go to page 7. And if we can zoom in on the bottom, section 2.1. Titled, Our Plan to Allow the Chinese People to Communicate Freely with the Western World.
By Mr. Skirik.
Do you see that, Mr. Dragon? I do. Did you consider this language in conducting your valuation analysis? I did. Okay. And how did this impact your analysis?
Mr. Ferguson said, objection.
The court said, sustained.
Mr. Skirek said, Your Honor, can we return to sidebar briefly, please?
Continued on next page. At the sidebar.
The court said, Mr. Skirek.
Mr. Skirek said, Yes, thank you. I just want to bring to the court's attention, this is Your Honor's ruling from May 17, 2024. That reads, in relevant part, the court shall not preclude Dragon's qualitative testimony that, broadly, the CCP censorship could create a market that could bolster a company's value. But you precluded him testifying about the related data. And that's precisely the line I'm trying to walk here, Your Honor.
Mr. Ferguson said, and Your Honor, if I may just, the next sentence is about quantitative impact. And he cannot offer any testimony about that, and the question was, did that impact your valuation analysis? Which is going to be a quantitative analysis.
Mr. Skirek said, I'm sorry. That's completely misconstruing not only what we just all read together but it misconstrues his testimony. The first sentence says that the court is not going to preclude qualitative testimony. And this is all qualitative. Not quantitative. I haven't asked him about any numbers, Your Honor.
The court said, Can I take a look at that? So it says, the court will not preclude Dragon's qualitative testimony that, broadly, CCP censorship could create a market niche that could bolster a company's value. But as Dragon has not offered any data, he shall not be permitted to testify as to any quantitative impact of the censorship on the company's value.
Mr. Skirek said, We haven't asked him about any numbers, Your Honor.
The court said, his opinion now is about a number. And so the only logical conclusion that one can draw when you ask what is the impact on his conclusion about the numerical valuation?
Mr. Skirek said, I mean, respectfully, Your Honor, I have not asked that question.
The court said, I know that. I know you haven't.
Mr. Skirek said, I merely asked whether it impacted his valuation analysis, and his thinking as to valuation, right?
The court said, so that goes to the number he puts to the value of the company. I'm going to permit you to ask whether he's considered these subject matters, but I'm not permitting you to ask the impact question. We're done.
Continued on next page. In open court.
The court said, go ahead.
Mr. Skirek said, thank you.
The court said, sustained.
Mr. Skirek said, now if we could please go to page 9. And if we could focus in on paragraph 3, proposed transaction.
By Mr. Skirek.
Now, Mr. Dragon, do you see this paragraph 3 that is on your screen? I do. Mr. Skirek said, okay. And if we could just scroll down to the chart that's on the top of the following page. And Mr. Dragon, did you consider this in conducting your valuation analysis? I did. Okay. And Mr. Dragon, to your understanding, based on this document, how many shares were being offered for sale in the GTV private placement? The offering was for between 20 million and 200 million shares. And for what percentage of the company did that represent? 10% of the company if it was 200 million shares. And if you could just explain to the jury, in your understanding, who owned the remainder of the shares? Both before and after the transaction. The remaining 1.8 billion shares were owned by a company called Soraka Media Group Incorporated. And that was post-private placement, correct? That was both pre and post. Okay. Well, is there a difference between before the transaction and after the transaction? Yes. Before the transaction the company had what we called a pre-money valuation. The way to think of this is, if I had a company that was worth $5 million and then I raised another $1 million. Pre-money the company would be worth $5 million and post-money it would be worth $5 million plus the $1 million I raised. For a total of $6 million. Mr. Skirek said, okay. Now if we could go to page 16 of this document, please. And focusing in on paragraph 7. Summary of investment terms. Now did you consider this language in conducting your valuation analysis? Yes, I did. Okay. And can you explain what the financing amount would be as part of this transaction? Yes. The amount to be raised could be between $20 million and $200 million. As I understand it, the entire new shares of $200 million were sold, so $200 million was raised. Mr. Skirek said, okay. Now if we could please go to page 18, and just blow up paragraph 9 entitled Risk Factors. Now, Mr. Dragon, did you consider this language under risk factors as part of your valuation analysis? Yes, I considered the risk factors as language here as part of my analysis. Okay. And did you consider the fact that GTV was?
Mr. Ferguson said, objection to leading.
The court said, I did not hear the question.
Did you consider that the investment in GTV was described as highly speculative as part of your analysis?
The court said, so Mr. Skirek, the general subject matters, not the specific language.
Mr. Skirek said, sure, Your Honor. I didn't address any numbers. It was the general subject matter.
The court said, the risk factors. That's the general subject matter.
Mr. Skirek said, if we could go to page 19, please.
By Mr. Skirek.
And this language at the top of page 19, did you consider that as well? I did. Mr. Skirek said, okay. Now if we can go to page 20. And at the top. If we could please blow up that first bolded sentence in the top paragraph. Now what does this paragraph describe?
Mr. Ferguson said, objection, Your Honor.
The court said, all righty. So we're going to stick to the general subject matters, the headings.
Mr. Skirek said, certainly. The general. What is the general subject matter of this paragraph?
The court said, Mr. Skirek, I know you know what I mean.
The general subject matter is that.
Court said, no.
Hold on. I'm going to give you another question.
The court said, he's going to give you a different question.
Is it fair to say this paragraph describes the discretion that the company's management has?
The court said, okay, Mr. Skirek. The heading. Just the general subject matter.
Mr. Skirek said, Your Honor, can we have another sidebar, please?
The court said, so it's separated into sections which I believe are numbered. Those numbered sections, those are the general headings that I'm referring to, not the subheadings.
Mr. Skirek said, Your Honor, I believe this is a heading.
The court said, I think this is a subheading.
Mr. Skirek said, thank you, Your Honor.
By Mr. Skirek.
This subheading is under risk factors, is that fair?
The court said, well, my point is that you're to stick to the headings and not go into the subheadings.
Mr. Skirek said, and my question was just to confirm that this is under the heading that Your Honor is referring to. Risk factors.
Mr. Ferguson said, we'll stipulate it's underneath the risk factors top heading, Your Honor.
The court said, so this is one of the subheadings, and the government has stipulated to that. Now you can ask about that general overarching numbered heading but not the subheadings.
Mr. Skirek said, okay.
By Mr. Skirek.
The risk factors listed here, is this among the risk factors listed?
Mr. Ferguson said, Your Honor, can we objection?
The court said, all right. So, sir, did you consider the risk factors that were listed?
The witness said, I did, Your Honor.
The court said, okay. Next question.
Mr. Skirek said, if we can go to page 25, please. And if we can blow up, on the bottom of the page, the bolded portion.
Mr. Ferguson said, Your Honor, this is still subheadings.
The court said, would you like me to ask the questions?
Mr. Skirek said, no. Can we have another sidebar, please?
The court said, okay.
Continued on next page. At the sidebar.
The court said, so Mr. Skirek, you're an incredibly smart person. I know that you understand what I'm saying. But you're resisting me, and I want you to stop.
Mr. Skirek said, respectfully, Your Honor, I truly don't understand what the line is that we're drawing between setting.
The court said, let me make it very clear. So you have these numbered sections, and you can ask about what is in that heading that follows the number. None of the text, none of the subheadings. So if it's risk factors, you would say, did you consider the risk factors listed? Period.
Mr. Skirek said, Your Honor. I think, I'm trying to understand the difference between just asking about a subheading entitled risk factors and the bolded portions which actually list the risk factors. And what the distinction is between being able to elicit testimony about a heading that says risk factors and the substantive risk factors.
The court said, well, because, Mr. Skirek, I know you know the answer. The subheadings are more specific than the general heading. I know that you know this.
Mr. Skirek said, and I'm just trying to understand for my purpose. Frankly, Your Honor. For the balance of the questioning in this case, I want to make sure that I'm adhering to the court's ruling and that I understand. Am I only permitted to ask about headings in certain documents?
The court said, not in certain documents. In this document, you're going through the headings in this document, and their general categories, and following the general categories there's more specific language. It's the specific subheadings and the paragraphs that you're not to go into, just the general categories.
Mr. Skirek said, okay. And I just want to make sure I understand. The reason that I'm not permitted to ask about the specific risk factors is because that is somehow quantitative as opposed to qualitative.
The court said, so you want to ask him about the impact that these representations had on him. And he's here to give us a number. And so necessarily the impact is about drawing this conclusion about the valuation, the number, and so that's where I'm not letting you go.
Mr. Skirek said, okay. And my final question, and I appreciate Your Honor's indulgence, if I'm at some point permitted to ask about the qualitative factors that relate to the portion of Your Honor's ruling that we read before. Am I not?
The court said, we are here. These are the qualitative factors. You can't get into them. You can't have him elaborate on it.
Mr. Skirek said, okay. I understood the court's ruling to permit us to discuss with this witness the qualitative factors that went to the size of the market or the potential market. And that's where I find it, Your Honor, to be clear, that was our understanding of the court's ruling. I believe that's what the text of the ruling said. So I'm trying to figure out how I'm permitted to do that within the confines of what Your Honor just described.
The court said, so now we're moving away from this document to what?
Mr. Skirek said, no. The language in this document is relevant to that, to the market, the size of the market.
The court said, so I'm just going to take you back to where I started. You can ask questions about these general categories without going into the impact, without having him elaborate on the language in the subheadings or in the text.
Mr. Skirek said, okay. Would I be permitted to ask, for example, on the size of the market issue? Whether language in this document, where it says there are 1.4 billion Chinese people who are interested in the content. Can I ask specific questions about that, or am I not permitted to ask specific questions about that?
The court said, no specific questions about that.
Mr. Ferguson said, and Your Honor, he's asked about the risk factor thing. I assume we're going to move on to a different numbered paragraph heading. He asked about it many times.
The court said, okay. We are. I know that we are.
Mr. Skirek said, yes. Just for the record, Your Honor, you know. This seems to me to be inconsistent with our understanding of the court's ruling. We understand the court's ruling now. And we will be guided accordingly.
The court said, okay.
Continued on next page. In open court. By Mr. Skirek.
Okay. Mr. Dragon, the paragraph at the bottom of this page, the second bolded portion, to be clear. Is that something that?
Mr. Ferguson said, objection, Your Honor.
You took into consideration.
The court said, so just stick to the numbered headings.
Mr. Skirek said, understood, Your Honor. Let's move to, we can take this document down. Now, Mr. Dragon, returning to the private placement. What is your understanding of what happened in the GTV private placement? The company sought to raise $200 million by selling 200 million shares at $1 a share. And these would be new shares that did not exist before in GTV media. And they sold the entire allotment of those shares. Okay. And so it was a successful fundraise, fair to say. Yes. Okay. Now, Mr. Dragon, based on your review of the materials that you described before, including the private placement memo that we just reviewed, did you reach a conclusion about the valuation of GTV? I did. Okay. And what valuation method did you apply to reach that conclusion? I applied what's called the backsolve method. That's a method where you look at a transaction in the company's stock and determine if it's a good indicator of value of the entire company. Okay. And is that a valuation, a methodology that looks at the placement of the company's securities? Yes. That's usually, there's some sort of transaction in the company's securities. So a placement of the company's securities would be a transaction in the company's securities. They sold 200 million shares. Okay. And why is the backsolve method a valid valuation methodology? The backsolve method is actually considered one of the best valuation methodologies. The reason it's valid is it is determining the value of the company by looking at the demand for securities in the company. So that if, for example, you sold 10% of the company for 200 million, then that would imply that the value of the total company is 2 billion. Okay. And why is that validation that you just described important? It's very important when you look at a backsolve transaction. You put it to what I would call a three-prong test. The first thing you look at is, was it for a large amount of money? If I only sold one share in the company, whether it was sold for $1 or $20, that wouldn't really tell you much about the value. However, here we sold 200 million shares in the company, and so that's a very significant transaction in terms of number of shares. The second thing that makes the second test is, was this for a significant dollar amount? If we sold a lot of shares but they were for just a fraction of a penny and the overall money raised was only $2 million, that wouldn't tell us much about the value of a $2 billion company. However, here, we sold shares equal to $200 million worth of value, and that is a large amount of money. The third prong of the three-prong test is, was there a lot of people interested in the transaction? At the price the shares were being offered, were lots of people interested in investing in this company? After they went and did their own research and came to a conclusion about whether or not this was a good investment. And we know that there was over 5,000 investors in this company, which is a significant number of investors. Now ultimately, Mr. Dragon, did you arrive at a conclusion about the value of GTV at the end of its private placement? I did. And what was that conclusion? My conclusion was that the equity of GTV, all of its common stock, was worth $2 billion. Mr. Skirek said, "Thank you, Your Honor. No further questions at this time."
The court said, cross-examination.
Mr. Ferguson said, "Thank you, Your Honor."
Cross-examination. By Mr. Ferguson.
Good afternoon, Mr. Dragon.
Good afternoon.
I'm one of the prosecutors on the case. I have some questions for you.
Okay.
Now you were testifying as an expert in valuation, right?
That's correct.
And Mr. Skirek had you read a bunch of lines from the PPM. Do you recall that?
I do.
Are you an expert in reading documents?
Mr. Skirek said, "Objection."
The court said, overruled. You can answer.
I read financial documents daily as part of doing my job, yes.
And you're not offering any expert opinion on reading what a document says, correct?
Mr. Skirek said, "Objection, Your Honor. It's a really."
The court said, I don't understand the question.
You didn't have any personal involvement in the PPM, correct?
I was not involved in creating the PPM, that's correct.
And you didn't have any personal involvement in the fundraising, correct?
I did not have any involvement in the fundraising either.
Now what you did do was offer an opinion using the backsolve method, correct?
That's correct.
And the backsolve method has a few inputs that are relevant, fair to say?
There's things you look at, yes. I listed them.
And so it's fair to say there's a few inputs that are relevant?
Mr. Skirek said, asked and answered.
The court said, sustained. Go ahead.
One of the inputs is investor demand. You said demand on direct, correct?
That's correct.
And demand depends on the investor views of the value of a company's shares, right?
That's part of what creates demand, yes.
And for GTV, thousands of investors paid $1 a share, right?
That's correct.
And the total amount paid by the investors was significant, right?
It was $200 million in new shares.
And you said that was a, significant amount, is that fair?
That's correct.
And so there was also a large number of investors. The number of investors was significant, fair to say?
The number of investors was significant, over 5,000.
And so your opinion essentially is that valuing GTV shares at $1 per share is a reasonable valuation. Is that fair?
That's correct.
And since there were 2 billion shares, a $2 billion valuation for GTV is also reasonable. Is that fair?
My conclusion was the company was worth $2 billion, correct.
Now this method depends on the investor's assessment of the company, correct?
That's correct.
And it depends on how the investors assess the company's value, correct?
That's correct.
And for this method to be accurate, the investors have to accurately assess the company's value. Correct?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
In a marketplace, you're going to have numerous people look at this. Some people assess it and determine that it is a worthwhile investment. Other people can look at it and determine that it's not. So that overall, you have a supply of shares. And the demand is then met by the people who, after assessing the investment, the industry. How other companies may have done in this industry. Decided that this was a good investment and that the price that the shares was being offered at was a fair price.
I'm talking about the people that actually bought the shares, okay? Do you understand that?
Yes, I understand that.
Okay. So the people that actually bought the shares. The valuation by them is the basis for your opinion, fair to say?
Mr. Skirek said, objection. Form.
The court said, overruled. You may answer.
My opinion is based on the overall transaction. All the people who bought shares and all the people who looked at it. And that is how you come to the conclusion that 10% of the company was worth 200 million, so therefore 100% of the company was worth 2 billion.
But I just want to be clear. Do you agree with me that part of the basis for your opinion is the investors who actually bought the shares at $1?
Yes, that's part of the basis of my opinion.
And if those investors had a misconception about the value of the shares, your method would incorporate that misconception, correct?
Mr. Skirek said, objection. Objection.
The court said, overruled. You may answer.
If those investors had a misconception about the value of GTV's shares, your method would incorporate that misconception, fair to say?
Mr. Skirek said, objection. Asked and answered.
The court said, overruled. You may answer.
Okay. Well. The way that supply and demand works in the market is each investor comes to their own conclusion as to what the opinion was. And those who came to the conclusion that this was a good investment at this price bought the shares.
Mr. Ferguson said, Your Honor, we move to strike as non-responsive, and I can ask the question again.
The court said, sustained. The answer is stricken. If you'll read the question back, sir. If you'll listen to the question carefully and only answer what's being asked.
The witness said, okay. Record read.
If there was a misconception, that's basically assuming that markets don't work. But if there was a misconception on the value, that would be incorporated into their decision to buy the shares.
So is that a yes?
Mr. Skirek said, objection. Asked and answered.
Mr. Ferguson said, I'm just trying to get an answer to the question.
Mr. Skirek said, he answered.
The court said, if you'll just read back the question one more time, please.
Record read.
Mr. Skirek said, I believe he answered it. It's the previous set of questions.
The court said, no. That's the reason that I asked for it to be read back because I did not hear an answer to the question. Would you mind reading back the question one more time, please?
Record read.
If that was how they made their decision to purchase on a misconception, that would be incorporated into their decision to purchase and my methodology.
Now, Mr. Dragon, you testified that you considered the risk factors in the PPM. Do you recall that?
Yes.
And you agree with me that risks are an important thing to consider when valuing a company, right?
That's correct.
Risk is an important thing to consider when making an investment, right?
That's correct.
That's because risk is about the likelihood your investment will lose money, right?
That is a component of risk, yes.
And when risk is lower, when the likelihood of losing money is lower, the investment appears better. fair to say?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
Lower risk investments generally are preferred, all other things being equal.
And so when investors are guaranteed there is no risk, the investment that had no risk would appear better, fair to say?
Mr. Skirek said, objection.
The court said, it's a compound question.
Excuse me. Are you asking me whether this investment had no risk?
I'll rephrase.
The court said, go ahead.
If investors are guaranteed there is no risk, that means there's no likelihood of losing money. Fair to say?
That's fair to say, hypothetically, yes.
And if there's no likelihood of losing money on an investment, the value of the investment would be higher, fair to say?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
Yes.
Now if the GTV investors relied on a guarantee there was no risk, the apparent value of the investment is not accurate, in those investors' view.
Mr. Skirek said, objection, form. The word reliance.
The court said, sustained.
Now you agree with me that the likelihood of making money is also an important representation, right?
I'm not sure what you mean by the term important representation.
Well, let me rephrase. If you're assessing the value of investment, it would be significant to know what the potential upside of that investment might be, fair to say?
When you assess any investment, you don't know what the upside is. You can only estimate what the upside is.
Right. And so if someone guaranteed there could only be upside, is that an accurate representation? In your view?
Mr. Skirek said, objection.
The court said, sustained.
Now, Mr. Dragon, the backsolve method you use to value GTV depends on GTV's investors, right?
Mr. Skirek said, objection. Asked and answered.
The court said, overruled. You may answer.
It involves, as I said, on a number of factors. And that's why I applied what I call the three-prong test.
And the method you used, it doesn't factor in at all whether GTV's investors were lied to, correct?
Mr. Skirek said, objection.
The court said, you may answer.
The methodology I used was looking at the legal documents that were provided for the memorandum and the actual purchases by the people who, after making their own risk assessment, were willing to pay the price for the shares.
Continued on next page.
Mr. Ferguson said, move to strike I guess and I'll ask the question again.
The court said, if you'll read back the question please.
The record was read.
There was no indication on the memorandum that there was any lies. So I did not factor in that the investors were lied to because I don't know whether that's the case or not.
And so that's a yes, you didn't factor that in?
Mr. Skirek said, asked and answered.
The court said, sustained. Go ahead.
You said there's no indication on the PPM that investors were lied to, right?
Mr. Skirek said, asked and answered.
Mr. Ferguson said, I'm trying to get to the next question. Well, you know what, Your Honor. Let's go on. Now, Ms. Loftus. Can we pull up Government Exhibit Z9 at page 6? Mr. Dragon, your opinion is that $2 billion was a reasonable valuation. Right?
Mr. Skirek said, asked and answered.
Mr. Ferguson said, I'm just trying to get to the question, Your Honor.
The court said, go ahead. You can finish your question.
I want to focus you on the exhibit in front of you. Do you see in the top left the date is June 2nd, 2020?
I do.
And do you see that you know that June 2nd, 2020 is the date that the private placement for GTV closed, right?
That's correct.
And the person pictured in this photograph, that's Miles Guo, right?
Yes.
And he's holding up a share certificate in this photo, you see that?
Yes.
All right. I'll ask you to please read the first paragraph listed there.
We had an initial valuation of $200 million for GTV and the private placement required a minimum investment of $20 million. The private placement exceeded the highest expectation and raised $350 million. This is up to now. This figure is about $360 million. Let's say $350 million. $350 million does not include the $117 million from VOG. If $117 million plus $350 million is more than $480 million, which is almost $500 million, almost $500 million. But the figure we have now is $350 million received, which is just for the contracts with GTV. This turned out to be a conservative estimate and 17 times the valuation.
If we can scroll down, Ms. Loftus, and can you read the next paragraph, the one in the middle there?
Given the tremendous demand for GTV shares and the good capital of GTV going forward, my lawyers and financial experts mutually agree that a $2 billion valuation is probably too low and that the actual value of the company is probably closer to $10 billion given the tremendous demand for GTV shares.
Mr. Dragon, just to start. This reference to my lawyers and financial experts who, according to Mr. Guo, mutually agree that $2 billion valuation is probably too low. You weren't one of those experts, correct?
I was not.
You didn't value GTV in 2020, right? At the time of this, you didn't value GTV?
Mr. Skirek said, objection, asked and answered.
The court said you may answer.
I was not involved in valuing GTV in 2020. My involvement is in 2024.
You only valued GTV in connection with this case, right?
That's correct.
And you're not offering any opinion that a $10 billion valuation was reasonable, correct?
I'm not offering that opinion.
Were you even asked to try to justify a $10 billion valuation?
Mr. Skirek said, objection.
The court said you may answer.
As part of looking at the company, I was not asked. But I looked at the company from a lot of different perspectives.
Mr. Ferguson said, Your Honor, objection.
Mr. Skirek said, he asked, Your Honor.
The court said, that last sentence is stricken. Go ahead.
So you're not offering any opinion that $10 billion is a reasonable valuation, correct?
That's correct.
Let go to GXZ9 at page 76, please. And do you see the date in the top left is March 30th, 2021?
Yes, I do.
And the person pictured here is Miles Guo again, right?
I believe so.
Now let's scroll down to the next page, Ms. Loftus, and let's focus on the bottom paragraph. If we could blow that up. Could you read that bottom paragraph, please, Mr. Dragon?
For GTV, how many funds tell GTV now that with the assessment the worth of GTV is now probably 60 billion? 60 billion. In other words, for the shares you have bought in the past, for example, 1 million shares. How many shares shall we give you now? It's multiplied by 30 times, that is, 18 million shares.
Sir, you're not offering any opinion that a $60 billion valuation of GTV was reasonable, correct?
I'm not offering any opinion on that.
If we could go to GXZ9 at 115. Do you see the date there is August 11th, 2021?
I do.
And the person in the split screen on the left, that's Miles Guo, correct?
I believe so.
Now can you read, focusing on the bottom paragraph, could you read the last two sentences in that paragraph?
Rolex is worth 7.8 billion, which is about 8 billion rounding up, right? It's only worth 8 billion. Which is only 1/5 or 1/6 of our GTV in terms of market value.
If $8 billion is 1/6 of GTV's market value, that would mean GTV's market value is $48 billion, correct?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
If you accept the premise, that would be 48 billion.
That's exactly right.
Mr. Skirek said, objection to the testifying.
Mr. Ferguson said, can I ask the question?
The court said, I did not hear the objection.
Mr. Skirek said, object to counsel testifying.
The court said, don't testify. Go ahead.
You're not offering an opinion that GTV's value was $48 billion, correct?
Mr. Skirek said, asked and answered.
The court said, overruled. You may answer.
I am not offering the opinion.
Ms. Loftus, if we could please pull up GXZ 212V. You can start playing at about 1 minute 39 inches.
Media played.
Sir, you're not offering any opinion that G Fashion is valued at $100 billion?
Mr. Skirek said, "Objection, Your Honor. Well beyond the scope."
The court said, "You may answer."
Well, first of all, I was asked to value the company as of April 2020. Both in this case and in the two previous cases you mentioned. You asked for valuations totally significantly after the valuation date I was asked to determine value. So in that sense, these are questions I haven't even considered. So companies' values can change over time. I can't tell you what the value of the company would be after the valuation date because I was only engaged to value the company as of April 20th. 200.
Ms. Loftus, let's go to GXZ9 at 134, please. The date in the top left here is November 16, 2021, do you see that?
I do.
And there's a person in the image person in the middle that's Miles Guo, right?
I believe so.
Ms. Loftus, can we please play GXC 432V?
Media played.
Can we go back to Government Exhibit Z9 at 134? Can you scroll down a little bit? Now, Mr. Dragon. You're not offering any opinion that the Himalaya exchange was worth $2 trillion, correct?
Mr. Skirek said, "Objection, beyond the scope."
The court said, "You may answer, sir."
The Himalaya exchange was not part of the scope of my valuation, so I'm offering no opinion.
And you're not offering any opinion that 5% of the Himalaya exchange was worth $100 billion. Correct?
Mr. Skirek said, "Objection. I was engaged to value the company at the time of the offering memorandum. This is over a year later. This is not something I would look at because it was out of the scope that I was engaged to value the company. I was engaged to value at the time of the offering memorandum in 2020.
It's fair to say you weren't asked to value the Himalaya exchange at $2 trillion, sir?
Mr. Skirek said, "Objection, asked and answered."
The court said, "Sustained."
Mr. Ferguson said, "May I have a moment, Your Honor?" Sir, you testified how you valued GTV around April 2020. Are you aware that Miles Guo continued selling what he said were GTV shares well after that?
Mr. Skirek said, "Objection."
The court said, "Overruled. You may answer."
Are you asking me whether Miles Guo sold his personal shares?
No, GTV shares well after April 2020.
Mr. Skirek said, "Objection."
The court said, "You may answer."
I'm not aware of any sales of new GTV shares after the closing of the private placement memorandum.
Mr. Ferguson said, "Just one moment, Your Honor."
Pause.
Mr. Ferguson said, "No further questions."
The court said, "Redirect."
Redirect examination. By Mr. Skirek.
Thank you, Mr. Dragon. You were asked some questions on cross-examination about potential investors' misconceptions. You remember that? I remember questions about that, yes. And you were asked whether if investors had misconceptions whether that would be incorporated into the valuation analysis that you performed. Do you recall that? Yes. Now, was one reason that companies selling shares issue written documents like a PPM to avoid misconceptions?
Mr. Ferguson said, "Objection to leading and improper."
The court said, "Sustained as to leading. Go ahead."
What is one reason that companies selling shares issue written documents to potential investors?
Mr. Ferguson said, "Objection. He's not an expert on that."
The court said, "Sustained."
Mr. Skirek said, "He's a valuation expert, Your Honor."
The court said, "Sustained. Go ahead. Move on."
Now, with respect to potential investor misconceptions. Does the backsolve method assume that every investor has perfect information?
Mr. Ferguson said, "Objection to leading."
The court said, "You may answer that question."
No, it doesn't. Can you explain that, please? Sure. Every single investor is going to read the memorandum and they're going to go and do their own research on, what the prospect for this company might be. And everyone comes to a different conclusion, so there's no way of. That some individual could maybe draw an incorrect conclusion of preventing that. And that's the same for any stock offering.
Mr. Ferguson said, "Your Honor, we move to strike as non-responsive and total speculation." He has no personal knowledge of any of that, and it violates the court's order.
The court said, he's not an expert on investor behavior as far as whether they read or not read the prospectus. Move on. The answer is stricken.
Mr. Skirek said, Your Honor, the question is with respect to the methodology, the backsolve method. How does that account for the possibility that investors may have varying levels of information or judgments?
Mr. Ferguson said, asked and answered.
The court said, you may answer that question. Go ahead.
Thank you. The way it accounts for it is a large number of people look at it.
The court said, so you're not to give an opinion though about what individual investors may be thinking or may have read.
The witness said, I'm just talking how markets work, Your Honor.
The court said, go ahead.
The way markets work is an opportunity, whether it's stock or selling a hamburger. Something is put up for sale and people look at it and decide whether it's a good opportunity or not. And the ones who do buy it decide it's worth their money. In this case, there was a very large number of people who looked at it, and over 5,000 people after doing their research decided this was a good investment. Now, Mr. Dragon, you were also asked some questions on cross about the risk factors. Do you recall that? I do. And you were asked about a guarantee. Do you recall that? I do. Now, in conducting valuation analyses, do you take guarantees into account? I might. Can you explain that, please? Yes. If there was a guarantee that was backed by legal documentation and that after discussing with an expert in, say, guarantees, a lawyer or something who understands this area, if they said that the guarantee was legally valid, then I would consider that in my valuation.
Mr. Ferguson said, Your Honor. Objection and move to strike to the hearsay of what may be some legal conclusion on a speculative nature.
Mr. Skirek said, there's no hearsay, Your Honor. This is about how valuation analysis works.
The court said, I'm going to permit the answer. Let's continue.
Thank you, Judge. And so if a valuation analysis the guarantee were one that was not valid and legally binding, would that affect your analysis?
Mr. Ferguson said, Your Honor, objection.
The court said, you may answer.
Mr. Ferguson said, he cannot testify about legal conclusions.
The court said, you may answer as to what would affect your analysis.
If I felt the guarantee was legally binding and had the ability to be backed up with sufficient resources, then I would consider it in my valuation. However, if it's just someone talking and there's no legally binding document, I would not consider it.
Mr. Ferguson said, Your Honor, I think we need to approach. I apologize.
The court said, all right.
Continued on next page. At the sidebar.
The court said, Mr. Ferguson, you opened the door to guarantee.
Mr. Ferguson said, I didn't open the door to him opining on whether oral guarantees are legally binding versus written guarantees are legally binding. He is not an expert in that. He has no expertise to offer about it. Second, the point of these questions, Your Honor, like we've objected to many times throughout the trial, is to suggest that the victims were gullible or negligent and they listened to this guy make some crazy guarantee, and isn't it really on them?
The court said, I think that you opened the door wide enough to permit these questions, and I think he's about to stop, so we're going to move on.
Continued on next page. In open court.
The court said, the answer stands.
In addition to the guarantees, you were also asked some questions about a document that is in evidence called GXE9, the chart. Do you recall that? I probably would if you showed me the document. I don't know the code number. If we could please pull that up for the witness and everyone for that matter. And if we can go to the entry from June 2, 2020, which I think is on page 6. Do you recall this now, Mr. Dragon? I do. And Mr. Ferguson asked you some questions about this. You recall that? He did, yes. And you recall that this is the date on which the GTV private placement closed, is that right? That's correct. There's a reference here to a potential, withdrawn. There's a reference here that you read that the private placement exceeded the highest expectation and raised $350 million. Do you see that? Yes, I do. Now do you have an understanding as to what is being referred to here? My understanding is that the $350 million includes the $200 million of new GTV shares that were issued by GTV and includes shares that were owned by Soraka that were sold because there was a very large investor interest in this offering. And so it's fair to say that GTV sold more than $200 million worth of shares. GTV itself sold $200 million. And the remainder came from where, to your understanding? Soraka sold some of the GTV shares it already had. Now, did
Mr. Ferguson said, Your Honor, what is the basis of this? I'm sorry. I think we may need a sidebar. Your Honor. Apologies. We object on personal knowledge.
Mr. Skirek said, I'm not sure how that's an objection to the question, Your Honor.
The court said, if he has personal knowledge you may answer.
Now, there's also reference here, if we scroll up a bit in this chart to the middle paragraph beginning. Given the tremendous demand. Do you see that? I do. You read this on cross-examination with Mr. Ferguson as well, right? Yes. And it reads, given the tremendous demand for GTV shares and the good capital position of GTV going forward. My lawyers and financial experts mutually agreed that a $2 billion valuation is probably too low. Do you see that? I do. And then you were asked some questions by Mr. Ferguson whether a higher valuation was something that you evaluated. Do you recall that? I do recall that. Now, did you have access to the information that Mr. Guo did at this time in June of 2020?
Mr. Ferguson said, Objection, how could he possibly know that?
Mr. Skirek said, I think he would know.
The court said, he doesn't know what Mr. Guo knows, so he can't answer that question.
Mr. Skirek said, Your Honor. Can he answer the question whether he had access to the lawyers and financial expert who were referred to here?
Mr. Ferguson said, Objection.
The court said, sustained.
Did you have access to any information about the GTV fundraise apart from what you received in connection with your testimony here today? No. So you didn't have access to, or you don't know whether Mr. Guo had access to a broader set of information than you did? Right.
Mr. Ferguson said, calls for speculation.
Mr. Skirek said, you don't know. The question is you don't know.
The court said, he can answer whether he knows or doesn't know. You can answer.
I don't know what Mr. Guo had access to. Right. Now, in order to determine in your expert opinion whether a higher valuation was justified at this point in time, you would need access to a broader set of facts.
Mr. Ferguson said, Objection to leading.
The court said, you can answer. Go ahead.
I considered.
The court said, the question is not what you considered.
I would have to have access to additional information if I were to try and determine whether a higher valuation was justified. Now, at this time your understanding, this time being June 2nd of 2020. Your understanding is that the private placement is closed, correct? That's correct. So what was said here by Mr. Guo available to GTV investors in the private placement? No. Now, you were also asked several questions by Mr. Ferguson about statements that were made by Mr. Guo later in time concerning the valuation of GTV. Do you recall that? I do recall that. And you were asked some particular questions about a statement about a $60 billion valuation that was made in 2021. Is that right? I was asked about that, yes. Did you look at information from that point in time to be able to assess whether that valuation estimate was fair at the time it was stated? No, I didn't. My assignment was to value the company as of the time of the private placement in April 20, 2020. You were also asked a similar set of questions by Mr. Ferguson about a $48 billion valuation that was implied from something Mr. Guo said in 2021. Do you recall that? I do. Same question, did you have access to any information about the valuation of GTV at that point in time? No, I didn't, and that was not in the scope of my assignment. You were also asked some questions by Mr. Ferguson about G-Fashion. Do you recall that? I do. Do you know what G-Fashion is? Not intimately, no. Fair enough. And you weren't asked to value G-Fashion, right? That's correct, I was not. Same question with respect to the Himalaya exchange. You weren't asked to value Himalaya Exchange. I was not asked to value the Himalaya Exchange either. Now, does any of what we just talked about, the 2021 statements concerning valuation about GTV, affect your opinion as to the value of GTV at the time of the close of the private placement? No, it doesn't. Valuation experts consider what is known and knowable at the time of the valuation, which was April 20, 2020. And the window of the private placement memorandum offering. Mr. Skirek said, "Thank you. No further questions."
The court said recross.
Recross examination. By Mr. Ferguson.
Sir, you didn't work at GTV, correct?
No, I didn't.
You didn't work at Soraka, correct?
No.
In 2020, you didn't work for Guo?
That's correct.
In 2020, you didn't do any valuation of GTV, correct?
I did not value the company in 2020, if that's the question you're asking.
Thank you, Mr. Dragon. Now, Mr. Skirek asked you questions about other valuations of higher numbers on redirect. You remember those?
I do.
And you testified you didn't have any information about those later valuations, isn't that right?
Mr. Skirek said, "Objection, misstates testimony." What I testified to.
The court said, overruled.
What I testified. My assignment was to value the company during the period of the private placement memorandum. And that valuation was known and knowable at the time of the private placement offering.
The materials you reviewed were provided you by the defense lawyers here, correct?
That's correct.
You don't have any personal knowledge that factored into your valuation related to GTV, correct?
Mr. Skirek said, "Objection, asked and answered."
The court said you may answer.
It depends what you define as personal knowledge.
Well, you relied on the material they gave you, that's fair to say, right?
I relied on the materials I was given and also on research I did independently.
Sir, they didn't give you materials to justify a $100 billion valuation of G-Fashion, fair to say?
Mr. Skirek said, asked and answered 3 times.
The court said you may answer.
I'm not sure what the question is. Could you restate that, please?
They didn't give you. The defense lawyers did not give you materials to conduct a valuation of G-Fashion for $100 billion, correct?
Mr. Skirek said, same objection.
The court said, overruled.
Valuation experts by our professional standards are not allowed to be given a value by legal counsel. We come to our own independent conclusions.
They didn't give you any documents related to that, is that fair?
Mr. Skirek said, objection.
The court said you may answer.
Mr. Skirek said, related to what?
To G-Fashion and the valuation of it.
I was not hired to value G-Fashion. I was hired to determine the value of GTV at the time of the private placement memorandum.
Did the defense lawyers ask you to value G-Fashion in 2021?
No.
Did the defense lawyers ask you to value GTV in 2021?
Mr. Skirek said, objection, this has been asked and answered repeatedly.
The court said, sustained.
Sir, you don't know what the investors who have testified in this trial have said, correct?
Mr. Skirek said, objection.
The court said you may answer.
I have not been present at this trial until today. So I have no idea what has been said beforehand.
Mr. Ferguson said, no further questions.
The court said, all righty.
Mr. Skirek said, no questions, Your Honor.
The court said, thank you. You may step out, and the defense may call its next witness.
Witness excused.
Mr. Skirek said, defense calls Maggie Sklar.
Maggie Sklar, called as a witness by the defendant, having been duly sworn, testified as follows.
The court said, please state your name and spell it, please.
The witness said, sure. My name is Maggie, Maggie, Sklar.
The court said, you may inquire.
Mr. Skirek said, thank you, Your Honor.
Direct examination. By Mr. Skirek.
Good afternoon, Ms. Sklar. Where are you presently employed?
I'm employed as a managing director at Seda Experts, SEDA Experts. That is an expert witness consultancy firm where I provide expert witness testimony in crypto and financial markets cases. I also run my own consultancy business, Sklar Strategies, where I represent clients in the crypto industry as well as other financial markets industries.
Thank you. Now, Ms. Sklar, can you tell us a bit about your educational background, please?
I'm a graduate of Georgetown University. Georgetown is in Washington, D.C. I graduated with a BA in 2001. I also graduated from Georgetown with a law degree in 2005.
And, Ms. Sklar, have you spent any time in public service?
I have. I was in the government for about a decade. I started at the CFTC. That's the U.S. Commodity Futures Trading Commission. And the CFTC is the regulator responsible after Dodd-Frank Act for regulating a lot of financial markets called derivatives. Also, I'm sure you'll ask when we get to crypto, but a lot of focus on crypto as well. While I was there, I started as a special counsel in the Division of Market Oversight where I regulated some of the largest exchanges. I was Associate Director for International Affairs. I was also the Senior Counsel and Policy Advisor for Commissioner. And I was also the Senior Counsel and Policy Advisor for Chairman Giancarlo.
Thank you for that. And as part of your work at the CFTC, did you advise on cryptocurrency and blockchain-related issues?
I did in 2015 when I was advising for Commissioner Wet Jen at the CFTC. The CFTC was the first agency to claim some level of authority over Bitcoin. And so I advised on that matter. But I also while the Senior Counsel and Policy Advisor to Chair Giancarlo, also known as Crypto Dad, by the way. That is the title of his book. But also the title of many of memes and other things in the crypto industry that he has been associated for. And that is because while I was also working for him and advising him, he testified before Congress for the first time describing what the CFTC could do with crypto, why he was interested. And why he was interested in crypto. And importantly as well, while I was there, we approved the first regulated crypto product Bitcoin futures in the United States, as well as the world. So it gained both attention all across the United States government as well as governments all over the world.
And while you were at the CFTC, did you also advise on crypto exchange-related issues?
Yes. So the first Bitcoin futures product we advise on, but others came after that as well as others not just Bitcoin, but other types of cryptocurrency.
And then did a time come when you left the CFTC?
I did. I joined the Federal Reserve in Chicago as their Senior Policy Advisor and Director of International Engagement for Financial Markets.
And while you were at the Federal Reserve, did you also advise on crypto-related issues?
I did. I did internally as well as continue to do speaking engagement externally as well on crypto.
And then following your work for the Federal Reserve, what did you do next?
I became a partner at Davis Wright Tremaine, which is a large international law firm. And I was in the banking and financial services practice.
And did a time come when you left the law firm?
I did at the end of last year to join Seda Experts and do my own consultancy. But also in between I also was the chair of the Public Policy and Regulation Committee for the Global DCA, which is the Global Digital Asset and Cryptocurrency Association.
That's a trade association of some sort.
Yes.
Ms. Sklar, do you also have speaking engagements that you participate in?
I do. I've spoken on cryptocurrency and blockchain issues at most major industry associations, including, for example, SIFMA, which is the Securities Industry Association, as well as specifically crypto associations. Most recently just last month at the Government Blockchain Association. But also for academic institutions, I think most recently at Duke University.
Now, what is your connection to this case?
I was hired to discuss cryptocurrency and the blockchain.
Are you being compensated for your work on this matter?
I am.
And how?
I'm being compensated at an hourly rate through Seda Experts, which is the firm I work for.
And what is your hourly rate?
For this case, $14.50 an hour.
And approximately how much have your fees been as part of this matter to date?
I think around now maybe 70,000, maybe 60,000, but around there.
And has the defense team covered your costs for traveling to testify here today?
Yes, on Amtrak and staying at hotels locally, yes.
Ms. Sklar, does your compensation depend in any way on the outcome of this case?
No, it does not.
Does your compensation depend on whether you testify a certain way?
No, it does not.
Before you were engaged in this matter, had you and I worked together before?
No, we have not.
And how about any other members of the defense team, before your engagement on this matter? Had you worked with any other members of the defense team before?
I have not.
And then how about Mr. Guo? Had you ever done any work for Mr. Guo before your engagement on this case?
No, I have not.
Now, did we prepare for your testimony here today?
Yes, we've met before, yes.
And do you recall approximately how many times we met?
I think about 4 times in person and maybe 3 times on Zoom.
Now, Ms. Sklar, did you review certain materials as part of your preparation for testimony here today?
Yes, I did.
What materials did you review?
I reviewed the indictment. I reviewed the exchange's white papers. I reviewed third-party contracts related to the exchange, Armanino, Certic, BitGo. I reviewed certain testimony and I reviewed the blockchain.
Mr. Skirek said, Your Honor. The defense offers Ms. Sklar as an expert in cryptocurrency and cryptocurrency exchange blockchain issues.
Mr. Horton said, Your Honor, we have 2 discrete issues to raise at sidebar.
The court said okay.
Continued on next page. At the sidebar.
Mr. Horton said, Thank you, Your Honor. This is an expert witness who is also a lawyer who has worked at the CFTC regulatory agency jurisdiction in this country. We'd ask, given that background, given that her subject matter is not sort of the law of crypto, but rather mechanics in the normal cryptocurrency industry, that Your Honor give a brief instruction. Instructions on the law in this case should not come from a lawyer. That will come from Your Honor. So we ask for that instruction, given this is the first lawyer witness in the case. Then there's 2 issues that come out of the path up to qualifying her.
The court said, Can I interrupt you? Are you expecting that she is going to be giving legal expert testimony?
Mr. Horton said, I don't know. But given that a part of establishing her expertise was that she's a lawyer. She went to law school, worked at regulatory agency. She got law degree from Georgetown. She was a lawyer at CFTC to commissioner at the CFTC. I think it qualifies that we're not getting instructed on the law of cryptocurrency. That will come shortly from the court. She's testifying as to something else.
The court said, So are you expecting her to testify on legal conclusions?
Mr. Skirek said, No, Your Honor. The disclosure in this case have been clear that Ms. Sklar is not being called to testify as a legal expert. She's being called to testify for her expertise into the industry.
Mr. Finkel said, Another point, Your Honor. She worked at the CFTC. She knows what is legal and isn't legal. Not specific to the law. The law will come from Your Honor, and that should be.
The court said, Could you repeat the scope of the qualification that you're asking for?
Mr. Skirek said, She's being offered as an expert in cryptocurrency. The functioning of cryptocurrency exchanges and relatedly blockchain. And I will add, because I foresee the government raising this in a moment, that she is not being offered for having conducted some forensic analysis from a sort of code software expert point of view. She's not an expert in software. She's not an expert in coding. She's being offered as an industry expert in how things work.
Mr. Finkel said, Your Honor, on that point, if I may. The other day, I think last week, I raised an issue that we asked a couple of questions of defense, whether she reviewed the blockchain and whether she reviewed the smart contract. And Your Honor directed defense to confer with us, and the government and defense, me and Mr. Schrick and Ms. Murray, had a very good conversation. In that conversation, we were told by Mr. Skirek she did not review and analyze the blockchain. She merely looked to see on Etherscan that there was a blockchain available. Ms. Sklar just said she reviewed the blockchain, analyzed the blockchain in this case. That's beyond the scope of her disclosure, and it's not permitted. And to the extent Mr. Skirek is going to go against what's in the disclosure, and frankly is different than what we discussed, which is really disappointing, we would have put that in our letter. We flagged a lot of issues for Your Honor. She can't testify about the blockchain or analysis she did on the blockchain, what was happening on the blockchain. 1. She's not qualified to do that, and we would object to her qualification on that issue. She's an attorney who worked on contract. And more to the point, it's not in their disclosure that she analyzed the blockchain, and we were told that she wouldn't testify to that.
Mr. Skirek said, if I could respond to that, please.
The court said, I just want to go back to what you said. You said you want me to qualify her as an expert in cryptocurrency and the functioning of cryptocurrency exchanges and relatedly blockchain. So,
Mr. Skirek said, cryptocurrency, as Your Honor well knows, operates on a blockchain. So to the extent that she needs to, I expect to ask her if she knows she can explain what a blockchain is at a high level. How it functions. We're not going to need to get into too much detail than that. It's pretty basic description of how it works. Does that answer Your Honor's question? If I may respond to Mr. Finkel's point.
The court said, go ahead.
Mr. Skirek said, I have to say, first of all, I'm a bit disappointed how that conversation was reported. I don't believe that is how that conversation went. And I listened to you, and I'd appreciate it if you'd listen to me. I never said that she wasn't going to testify that she looked at the blockchain. In fact, I was very specific as to the disclosures in this case that have been very specific that she can use publicly available tools such as Etherscan. This was something that was an issue in briefing before Your Honor, and the motions was to preclude. We were very clear. She used publicly available resources like Etherscan to look things up on the blockchain, which is something that frankly either of us can do. It certainly helps that she has the expertise. And she is going to testify to observations that she made based on using those publicly available tools. That is the distinction. If I understood you correctly, Mr. Finkel, you were asking whether she was going to testify whether she did some forensics of all of the movements of the tokens on the blockchain. She did not do comprehensive analysis of that. But she can testify to things that she sees using publicly available resource and tools. Some of which will be whether they exist, whether the token exists, where they were at certain points when they were created. None of which is the subject or needs to be the subject of any forensic analysis.
Mr. Finkel said, I don't want to get into a back and forth about the conversation between Mr. Skirek, Ms. Murray, and myself. But that's not an accurate reflection of what Mr. Skirek told us about Ms. Sklar's testimony. And we had that conversation to avoid this one, to have to bring the issue to Your Honor. The point is that Ms. Sklar, we had understood, could say that she went on Etherscan, which is a publicly accessible tool, and saw that there is a smart contract on the blockchain. They exist. We didn't call our expert. We will on our rebuttal. He will testify there is really no activity on the blockchain. To the extent she is going to say anything more than there is a blockchain which exists, Mr. Skirek, we don't object to that fact that she saw there is a blockchain.
Mr. Skirek said, you mean the tokens on the blockchain?
Mr. Finkel said, no. There is a blockchain. If I could just finish. She cannot testify, she is not an expert on it. Number 1. Number 2, it's not disclosed she saw any transactional activity on the blockchain, or what it means or the analysis of it. That's beyond the scope of her testimony. Her testimony. As we already understood, they had a contract with BitGo. They got Arminio. They have white paper. They have certificates. All that suggests it's a cryptocurrency, or whatever it's going to say. But any analysis of what's occurring on the blockchain, that's what our expert disclosed in detail what he saw on the blockchain. Ms. Sklar did not, and so that's a disclosure problem. And 2, she's a regulator. She doesn't know about blockchain. She doesn't have a chain analysis.
The court said, Is that information publicly available, the transactions?
Mr. Skirek said, yes, Your Honor.
Mr. Finkel said, the transactional information is public, however. What it means and how it's interpreted requires expertise, and she is not suited to deliver that opinion, number one. And more to the point, Your Honor, and this is, I think, the problem, it wasn't disclosed. It's not in her disclosure. So we're not prepared for it at all for her to say these movements and these transactions back and forth.
Mr. Skirek said, Your Honor, I'm happy to refer the court to the ruling dated May 17 on Ms. Sklar's testimony. The relevant portions are highlighted here. It's a publicly available tool. It's used to review the blockchain. And Your Honor held gives them a fair opportunity. The disclosure was adequate and gives them a fair opportunity on cross.
Mr. Finkel said, what that says is different than what Mr. Skirek just said she's going to testify about.
The court said, let me just read this again. So I said that Guo clarified that publicly available information is a reference to the publicly available blockchain on which HCN and HDO were minted, which was available to view using website called Etherscan. What I understand the government to say is that she did not go into her specific observations. Am I correct?
Mr. Finkel said, that's exactly right. We can't go further than what the court's order says.
Mr. Skirek said, of course she has observations. What's the point of looking up the information on the blockchain? That's the only reason one would do that.
The court said, so she's not here to merely state the transactions she observed. You want her to interpret what that activity means. Am I correct?
Mr. Skirek said, Your Honor. I believe her testimony is going to cover the fact that she looked these tokens up on Etherscan. She can tell that there was movement of the token, which is obvious using Etherscan. She can testify they were created, dates they were created. This is all information that was publicly available via Etherscan.
The court said, it's one thing to state that the information is available publicly. You can look it up using Etherscan. It's another thing to get into the specifics of the actual transactions.
Mr. Skirek said, she can see the transactions on the blockchain just the way that or anyone can. It's mere observation.
The court said, that brings me back to the question that I asked. So sure, she can say what's there. But the question is her interpretation of that activity, what it means.
Mr. Skirek said, the blockchain not only records, as Your Honor knows, static snapshots of where tokens are at a given point in time. It also reports transactions. That's the nature of it inherently, is that it records transactions. It makes them publicly available. It's no different than saying she observed transactions. So, I mean, that's the same thing. It's enabling her to say, I saw the tokens on the blockchain and observed transactions.
The court said, what was your disclosure of your expert?
Mr. Finkel said, the disclosure, there are a few things sort of circling the disclosure. Our expert did an analysis of the blockchain. He traced the movement in the blockchain. He determined that according to the blockchain 99.9, I think 99% of HCN and HEO were owned by the Himalaya exchange. There's very few transactions on the blockchain. Despite the fact that HCN and HEO were according to the market capitalization, it makes it the sixth most valuable cryptocurrency. Essentially, his opinion is that the value of HCN and HEO as reported on the Himalaya exchange doesn't fit with the number of the transactions on the blockchain. Plus, the concentration of the ownership on the blockchain suggests that it's entirely controlled by the Himalaya exchange, which implies that it's not a true cryptocurrency because it's not owned by the publicly, and it's not usable by the public. To get back to sort of Ms. Sklar, and the problem is twofold. One is, I hate to say this, but we were told in explicit terms that Ms. Sklar would testify that she could see HCN and HEO on Etherscan. And the fact that they're available, exactly what Your Honors ruled as part of her opinion, we don't object to that. What we object to is what Mr. Skirek is now saying, which is different than what he told us Thursday. It's a little frustrating, and I apologize for being frustrated.
Mr. Skirek said, I share the frustration.
Mr. Finkel said, I'm glad you do. What Mr. Skirek now said is she went on the blockchain and saw transactional movement on the blockchain. That's an analysis of what's going on.
Ms. Schrofa said, no, it's not.
Mr. Finkel said, Excuse me. Excuse me. Why then didn't you tell us that?
Ms. Schrofa said, he did.
Mr. Finkel said, You weren't part of the conversation.
The court said, all right. Please direct your comments to me, Ms. Schroff.
Mr. Finkel said, You don't?
The court said, Mr. Finkel, direct your comments to me.
Mr. Finkel said, I'm sorry. The fact that she is now going to analyze what she saw on the blockchain. We don't know what that analysis is. There's no opinion about it in the disclosure. The mere fact that it existed that was disclosed. What Your Honor wrote is disclosed, and that's fair. But going beyond that, saying she saw movement back and forth, and what that movement means, we don't know her opinion.
Mr. Skirek said, I feel, Your Honor, that this is why just one more comment to reiterate. Unlike many other kinds of records or data, a blockchain is unique in that it reflects movements that you can see moving, right? You don't need someone to interpret the blockchain when you can, let me finish. You don't need someone to interpret it in the same way because you can see movement on the blockchain. So she will offer her observations about those movements which she can see, which are publicly available, which are publicly accessible through Etherscan. There's nothing about that goes beyond the bounds of what Your Honor ruled on. Nor is there anything about that goes beyond the bounds of what our disclosures were.
Mr. Finkel said, It's not in the disclosure. That's the problem.
The court said, she's not going to say what she observed. She's going to draw a conclusion from that?
Mr. Skirek said, No, Your Honor.
The court said, what use is it to you if she can't draw a conclusion?
Mr. Skirek said, well, she doesn't need. I think we get to the conclusion that we need to without necessarily needing to rely on the kind of analysis. There's lots of ways to do that. We don't need to do the kind of analysis that their expert did.
The court said, you plan to elicit from her a series of transactions and then for you to draw the conclusion yourself?
Mr. Skirek said, no, Your Honor. Just to back up FO a second. We just got to the part where we're offering her as an expert. I haven't even asked specifics. This is all being done in the abstract, which I recognize is difficult for us and particularly for the court to analyze. I haven't asked a single question about this topic.
The court said, but he's anticipating and it sounds to me like you're going to where he thinks you're going to go.
Mr. Skirek said, I'm not sure that's true. Again, we may have a disconnect over what is publicly available, publicly accessible, and what a witness can report they observed, which is frankly, Your Honor, as far as we plan to go.
The court said, what exactly do you expect her to state?
Mr. Skirek said, I expect her to state that she used Etherscan to look up the token to confirm they were created, to see the date on which they were created, the wallets in which they were held when they were created, and the fact that both cryptocurrencies are moved at different points in time, which you can see on the blockchain, and that those facts are frankly the only facts that she needs. We don't need to get into anything else.
Mr. Finkel said, can I respond to that?
The court said yes. So my law clerks have pointed out to me that page 3 of Mr. Kamraju's letter dated April 29, 2024, paragraph D, which states, as a result of this structure, typically when a user trades cryptocurrency through a centralized exchange, that trading activity would not be reflected on the blockchain because the cryptocurrency is not actually being transferred from one wallet to another. So this does sound like there is.
Mr. Finkel said, so the concept, it is disclosed. The notion of that's an off-chain transaction, which Mr. Skirek explored extensively on Cross of Jesse Brown and Sam Roberts. That concept of what an off-chain transaction is, they're free to ask her about. Your Honor allowed them to do that. What is not disclosed, they can point it to us if it is her analysis of movement on the blockchain she observed and what that means.
The court said, you're distinguishing the public versus the non-public.
Mr. Finkel said, no. I'm distinguishing the concept of how blockchains work and off-chain transactions versus the actual analysis of HCN and HDO-specific blockchain. She did disclose that Ms. Sklar did disclose, and I don't contest. She can speak to the general nature of how blockchains work and the general nature of off-chain transactions. What is not disclosed is the specific transactions that she observed on HCN and HDO reported blockchains. And telling me I don't need to belabor this, but I'll just leave it at that. That's not in there. And I don't believe that defense counsel can point to something that says that it is. An analysis of what actually happened to HCN and HDO that she observed and necessarily informs her view, because if it didn't inform her view, why are they asking her? If she wants to generally speak about how blockchains work and Your Honor permits her to do that, I believe that's fine. But to go specifically to the HCN and HDO blockchain and say I saw this is the concentration of ownership and this is the movement on blockchain and that is a real cryptocurrency. It's not disclosed.
Mr. Horton said, Your Honor, with respect to this highlighted paragraph. The difference is typically an exchange has off-chain activity, like saying typically banks report customers' audits in internal ledgers. A typical factor she has from the knowledge with regulating the space. That's different from saying. And I looked at 100 terabytes of Bank of America's internal ledger. And I saw that customer John Doe did this transaction in this currency became larger. The general fact that it's her experience is regulating the exchange, they often have this kind of transaction. It's a common transaction. It's totally different from. I'm now going into a particular database and analyzing it from within.
Mr. Skirek said, last point because there's some confusion here. There aren't HCN and HDO blockchain. There is no such thing.
Mr. Horton said, they're on the Ethereum blockchain.
Mr. Finkel said, and their transactions are recorded.
Mr. Skirek said, I don't think you know this space because you wouldn't say that if you did.
Mr. Finkel said, I do, and our expert will say it. Please don't impugn my integrity.
Mr. Skirek said, there is a blockchain. This is the Ethereum blockchain, which Your Honor knows well. The question is merely using, and the blockchain is publicly available. There are ways to look at it. You don't need to have any special experience or access to information. You can do it if you know how to use it and use Etherscan. All she's done is employed those publicly available tools to look at a publicly available resources and make the observations just the same as any witness would make observations about things that happen around them or what they saw or what they heard and what they smell.
The court said, the problem that I have is she's an expert, and it would be appropriate for her to be making those observations and drawing conclusions if she had discussed that in her disclosures, and this is what I'm not seeing. I see a general statement, but I don't see the specific analysis.
Mr. Skirek said, I'm happy to go back and look at this and find the disclosure for Your Honor. I thought that the reference that Your Honor made in your opinion picks up the disclosure that this is something that's publicly available and in a viewable view in Etherscan.
The court said, that's not what I meant. I understood, of course, that that material is publicly available, but it's different to say that she's permitted to now testify about these specifics without having first disclosed them.
Mr. Skirek said, my point, I understand the court's point. My point, Your Honor. Your opinion was based on our disclosures. That's all that the court had at the time that you wrote the opinion was our disclosures, and the government challenged our disclosures. So that's why I think the fact that it's in the opinion shows that it was disclosed. I think Your Honor quoted from our disclosures, and I'm happy to take a look. I don't have it in front of me.
The court said, if you want to point me to something that's specific, in other words, that tracks what you expect her to say today, then fine, but I think that what the government is saying is that you can't do that, that there is no search-specific information.
Mr. Skirek said, if Your Honor would indulge me to give me 2 minutes to look through.
Mr. Finkel said, Your Honor's right. I think the conflating on what we don't object, which is the general concept of how blockchains work, and the specifics of the analysis. If Mr. Skirek is telling us he's going to point to anything in disclosure, here is my analysis.
Mr. Skirek said, I just said I'm going to try to do that.
The court said, go ahead and I'll wait for you.
Mr. Skirek said, are we close to the 2:30 break? Would it make sense?
The court said, I suppose the question of how quickly you can get to that information. We have 6 minutes.
Mr. Skirek said, I'll try. Thanks.
Continued on next page. In open court, jury present.
The court said, members of the jury, it's time for our 2:30 break. We will continue at 3 o'clock. Remember, you're not to discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, watch or listen to anything from any source that touches on the subject matter of this case. Ma'am, you may step out. Don't discuss your testimony.
The law clerk said, jury exiting.
Jury not present.
The court said, counsel, if you step up again.
Continued on next page. At the sidebar.
Ms. Schrofa said, somebody seems to left our binder at the office. We are reprinting them now. And we'll have it for the court shortly.
The court said, is what you're talking about something different from what this April 29, 2024 letter?
Mr. Skirek said, I would have to go through because we have 2 disclosures. This was the supplemental disclosure.
The court said, I think it's the same. I'm looking on page 3 paragraph G, which says, that evidence that there is not substantial on-chain trading or redemption activity of a token, such as is the case with HCN and HDO, does not demonstrate that the token is not a cryptocurrency. So here she's referring to her observation of an absence of activity to draw the conclusion that does not mean that HCN and HDO are not cryptocurrencies. So there is some reference to the specific activity.
Mr. Finkel said that one activity, yes. But what we understand from the questioning and from Mr. Skirek's answers to your inquiries at sidebar is that she did more than that. She performed an analysis on what was on the chain. She looked to see how who was being moved to who. The concentration of ownership. If they want to ask that one question that was disclosed, then they can do that. But all we're trying to do is protect what we were disclosed under Rule 16. Mr. Skirek hasn't identified any other Rule 16 disclosure to suggest that they're entitled to offer an opinion as to more. That's all.
The court said, did you want to go beyond what's stated in G?
Mr. Skirek said, I think G and 2, Roman 2.2, which is the minting.
The court said, what page are you on?
Mr. Skirek said, this is page 2.
The court said, so you are referring to. Ms. Sklar will also opine that in the cryptocurrency industry, there is a common market understanding that a cryptocurrency is digital currency that uses blockchain technology to record transactions on a distributed ledger. Cryptocurrencies are frequently created pursuant to self-executing smart contracts and are used as a store of value. She will further opine that given that HCN and HDO each were minted using smart contracts which can be seen on the public Ethereum blockchain, and are purchased using fiat currency and traded, they meet the common market understanding of cryptocurrencies. Finally, Ms. Sklar will opine that they based on the white papers HCN was designed to operate as a trade-in coin and HDO was a stable coin.
Mr. Horton said, if I might address that.
The court said yes.
Mr. Horton said, we spent a lot of time in preparing for today's testimony there. There's a single opinion in paragraph 2 about something that can be seen on the blockchain. Set aside whether they're saying something can be seen means that she went and saw it and analyzed it. But she says can be seen are the smart contracts for HCN and HDO. Those are 2 discrete documents, one each. Those are the constitutional documents, so to speak, the formation documents for these tokens. Saying if you go on Etherscan you can see there was a smart contract for HCN and a smart contract for HDO. That's what we understood. That is what paragraph 2 says. That's got nothing with them saying. And then I analyzed and here's the import of that.
Mr. Finkel said, or the analysis of the smart contract itself.
Mr. Horton said, it can be seen.
Mr. Skirek said, Your Honor, I just want to point out for the record that in
The court said, "Where are you?"
Mr. Skirek said, "In paragraph 5e, which may or may not be the paragraph Your Honor may have been reading from before." "Yes, 5e, second sentence relating to redemptions."
The court said, "For similar reasons?"
Mr. Skirek said, "Yes."
The court said, "It starts. Furthermore, centralized cryptocurrency exchanges permit their users to redeem or convert their cryptocurrency tokens into the equivalent value in fiat currency, such as US dollars. For similar reasons, such redemptions would also not typically be reflected on the blockchain. Because even though the user is trading their token for fiat, there is no transfer of cryptocurrency between wallets. Rather, cryptocurrency remains in the exchange's wallet, and a corresponding debit is made in the user's account on the exchange's internal ledger."
Mr. Horton said, once again. That paragraph uses the word typically, as the other paragraphs do, to describe what she understands as typical features. Not of the Himalaya exchange, but of cryptocurrency exchanges writ large based on her general knowledge of the industry. Nothing in that paragraph of that particular analysis that was undertaken for purposes of her testimony. To say that typically you see future A at industry institution B, is totally different from saying, "And then I went in and look, and it matches the normal typical features that I'm going to opine about."
Mr. Finkel said, "She's always been an expert, and that's what she's been qualified to do, to talk about industry practices, and what she's interacted with the CFTC. We objected to that, Your Honor, but we're not revisiting Your Honor's conclusion. What we understand they're now seeking to do is an analysis of those smart contracts and of the blockchain, which is not what's disclosed. And there still hasn't been in all this time Mr. Skirek saying, 'No, look. This is her opinion about the blockchain.' She can testify, because Your Honor ruled that she can, about, as Mr. Horton just said, how cryptocurrency exchanges typically operate, but not to take it a step further, which is. And I looked at the HCN and HYO smart contracts, or the HCN and HYO blockchain, and determined these two purported cryptocurrencies are tokens or credits, whatever phrase you want to use, act consistently with what is specifically market practice."
Mr. Skirek said, "Your Honor, what's clearly disclosed here is that she used publicly available tools, as I said before, to make observations, right? To make observations about what exists and what happened. All of which I hope anybody would argue is beyond the ability of an expert to testify when third parties otherwise qualified to testify about observations in their industry. Right. And then we've also made clear that she's going to infer certain things from those observations and infer certain things from the lack of transaction or the absence of transaction, which is a different inference than the government wants to draw. But it's an inference nonetheless that's permissible with an expert testifying based on her own observation that again are mere observation. We don't need to be clear. We don't need her in our review to conduct the same sort of analysis. There's more than one way to skin a cat to conduct the same sort of analysis that the government's expert conduct. She can offer her view based on what she saw and based on inference from what she didn't see, and that's entirely permissible."
The court said, "So my understanding is that she does not go into any specific about what she saw in the disclosures?"
Mr. Skirek said, "We did state, Your Honor, that she looked at the blockchain. That she reviewed and made observations about what was happening on the blockchain."
The court said, "She doesn't share those observations with the government or with me."
Mr. Skirek said, "It's no different than saying we showed an expert a document dated April 29, 2024. Do we need to go and say, here are all the things that are in that letter dated April 29, 2024? It's the same thing as saying she looked at the document. She looked at the blockchain. It's the equivalent."
Mr. Finkel said, "The prior expert is instructive here. Mr. Dragon, I believe it was disclosed, reviewed the PPM. As part of his analysis of the PPM, he reached the opinion of the $2 billion valuation was appropriate. That's the opinion. Here there's no opinion about what her analysis was of the blockchain. As Your Honor just pointed out, she reviewed it. She looked at it. It doesn't mean we know what her opinion is. That's what Rule 16 disclosures are all about. And they still haven't pointed to exactly what Your Honor's question was. What was the observations that she had that informed her opinion to inform the government, and to inform Your Honor when Your Honor ruled on this? This is simply a disclosure issue. And it's just a question of just to be clear. We do not object because Your Honor already ruled on it. General practices are fine. But with respect to what she reviewed specifically, and had formed an opinion on HTO and HCN smart contracts and blockchain activity, it's not the same thing.
The court said, "My understanding is that the government is not challenging the conclusions that are stated in Mr. Kamaraju April 29, 2024 letter. They're not saying she cannot draw these conclusions. What they're objecting to is going into a granular analysis that has not previously been disclosed. Am I correct?"
Mr. Finkel said, "Yes."
The court said, "I think that is only fair that she has to stick to what has been disclosed as opposed to what's coming up with brand new data that is not."
Mr. Skirek said, "To be clear, there's no new data. I'm frankly hopeful that when we get to the specific questioning on this issue, some of this will be obviated by seeing where we take the specific questioning. I just want to be clear in the interest of being efficient and having minimal interruption. I am permitted to ask what she viewed on the blockchain using Etherscan that seems foundational. That was clearly disclosed, and in fact referred to in Your Honor's opinion."
Ms. Strofa said, "An observation is different from an analysis of the observation. That's the distinction I think that the government doesn't."
Mr. Finkel said, "Her answer is the analysis of the observation."
Ms. Strofa said, "No, it's not."
Mr. Finkel said, "This is frankly a replay of what happened with Mr. Dragon. Your Honor made a pretty clear ruling of where Mr. Skirek could or could not go, and he tried to get around it. I don't think that's appropriate with another expert here. She didn't disclose it. It hasn't been disclosed. They shouldn't be able to put information the government didn't have an opportunity to prepare for in front of the jury."
The court said, "They can't cross-examine her adequately if they're just getting this information for the first time."
Mr. Skirek said, "They're not, Your Honor. The fact is we said use this tool to look up publicly available information. The same publicly available information that their expert looked at that. They're well aware of that. They had analysis. There is no surprise here whatsoever, Your Honor. I think at the end of the day we have clearly disclosed that she used this tool to look at what's publicly available on the blockchain. And I think everybody would agree that was disclosed, that was incorporated in Your Honor's May 17th opinion. It seems to me that should be fair game."
Mr. Horton said, "The question is not whether there's new data in the world. The question is what data is in the Rule 16 disclosure, the purpose of which is to put us on notice so we can prepare for the cross-examination. This document, which was their second notice by the way. They supplemented deficient notice to provide Your Honor, says that she observed particular discrete things on the blockchain. Namely, 2 smart contracts. That's what it says. That's what it said for 2 months now. We've been talking about this document for 25 minutes. And it's not clear what it means because we're still looking at it."
Ms. Strofa said, "It's like talking about the number 6 train and saying there's 6 stops on the number 6 train. We're not seeking to analyze the 6 stops, but the 6 stops are completely apparent. They know the 6 stops. I know the 6 stops. What is the issue?"
The court said, "I think the problem is that they don't know. That's the problem."
Ms. Strofa said, "The 6 stops. I think that's what Ms. Skirek is saying. It's all publicly available." Ms. Strofa said, "We know they have it is because their expert has it and opine on it for us."
Mr. Finkel said, "Rule 16 doesn't have an exception that if the government's expert did something and reached an entirely different conclusion than Ms. Sklar, by the way. That somehow makes it okay. There's no exception to that. We don't know what her view is. We know her view is ultimately different than our expert's view. And we know that our expert disclosed discrete aspects of what he observed and traced on the blockchain. Ms. Sklar did not disclose that."
Continued on next page. At the sidebar, continued.
The court said, "Yours sort of goes into specifics, correct?"
Mr. Finkel said, "Yes."
The court said, all right. Well, it should be parallel, and I'm not going to permit you to go beyond what was disclosed. That is my ruling.
Mr. Skirek said, and I just want to be clear, Your Honor. Am I permitted to ask? Did you use Etherscan to observe the blockchain?
The court said, absolutely, because that has been disclosed.
Mr. Skirek said, okay. And what did you observe?
The court said, what I want you to do is to study what was disclosed, and you'll see from looking at Mr. Kamraju's words, what had been disclosed, and that's what you can go into, not into this granular analysis.
Mr. Skirek said, I don't think there's any granular analysis, Your Honor. I just want to make sure, when I ask. What did you observe, in a non-leading fashion? That the government's not going to jump up and object to her saying she saw them manipulated on the blockchain. Which is clearly disclosed, that she saw that. That's clearly disclosed.
The court said, one way to handle this is for you to ask leading questions that have been agreed to in advance, so that we don't get into her saying something she should not say. So why don't you come up with the leading questions between the two of you?
All counsel said, thank you, Your Honor.
Recess. In open court, jury not present.
The court said, have the parties come to a conclusion? You're winding up?
Mr. Finkel said, I think we have, but we just need 1 minute.
The court said, okay. All righty.
Ms. Schrofa said, Your Honor, may we have the witness take the stand?
The court said, sure.
Mr. Finkel said, so, Your Honor, we've agreed to 2 questions to be asked in a leading fashion. The government does not believe.
Ms. Schrofa said, excuse me. The translator cannot hear.
Mr. Finkel said, the government does not believe there needs to be follow-up to those questions in light of the discussion at the sidebar. And that's where the parties have an agreement on that concept.
The court said, well, I'll hear the questions when they're asked and decide if there can be any follow-up. I just want to remind Mr. Skirek and the witness to speak slowly, because the interpreters need to interpret.
The witness said, okay.
The court said, all right. Let's have the jurors brought back in.
Jury present.
The court said, please be seated. You may continue the inquiry.
Mr. Skirek said, thank you, Your Honor. I believe that we left off when the defense was offering Ms. Sklar as an expert. I believe, when the sidebar was called.
The court said, all righty then. Members of the jury, I am qualifying Ms. Sklar as an expert in cryptocurrency and the functioning of cryptocurrency exchanges and, relatedly, the blockchain.
Mr. Skirek said, thank you, Judge.
By Mr. Skirek.
Now, Ms. Sklar, for the benefit of the jury, let's talk a little bit about Crypto 101. What is a cryptocurrency?
A cryptocurrency is a form of digital currency in that it exists purely on the internet and online. But it is also used not just as currency but as a means of exchange, a store of value, a form of technology, and has also become its own sort of culture and philosophy about how money should be used.
Okay. And when you say it's on the internet, what is the role of the blockchain in cryptocurrency?
Right. So technically, and the technology behind cryptocurrency and what makes it different than, say, using your Visa, which also feels like it's online money, but you're really using real money through a credit card, the cryptocurrency only exists through a blockchain. So in this case, for example, or, Bitcoin, which I think people are generally familiar with. But in this case Ethereum, they're on a blockchain. So the blockchain is an online form of technology that serves as a public ledger, to explain transactions. And I guess how I would try to maybe visually explain it, if you haven't seen it. You could think of it as an Excel spreadsheet. So you have rows and columns. And one column. You're going to have what's called the hash. But just think of it as a bunch of whole letters and numbers that represent the transactions, so a bunch of data. And then next to that you'll have a whole bunch of numbers and letters that represent the from column. And next to that the to column. Also a whole bunch of numbers and letters. You'll have date. And then you'll have the amount that was transferred. And so when you think about it, from an Excel spreadsheet perspective, think about it the way the blockchain works is you take that and, I don't know if this dates myself, but use SharePoint to your office mates, or maybe use MS Teams, you could use Google Docs. The point of why I'm using that to visually try to explain it is, it goes to a bunch of people and then everyone has to vote on it. And so everyone votes, and then that block, that chain, becomes, when everyone votes on it, permanent on the blockchain. And that continues sequentially over and over and over across the days, weeks, months. And it could be, let's say John and Joe are transacting that first block. Maybe Joe's fast enough that the next time he sells, the next block is him selling. That's not usually how it works. But, it could be just something completely different that happens. But you can see the chain. It just keeps going like this and going across, and it's publicly available to review. There were private websites as well, but that's part of the purpose of the blockchain is that you see that. But there's no names involved. It looks like letters and numbers.
Okay. Thank you. And what is the functioning of a wallet when it comes to cryptocurrency and blockchain?
Sure. So in order to know what you have on the blockchain and your crypto, if you're doing it individually, and there are other ways of doing this, too, but just to start, a wallet is, a term borrowed from just regular finance, right? You have your wallet, your money is in your wallet. In cryptocurrency, a wallet is the digital representation of that. So you have a service that has all those letters and numbers I'm mentioning that just goes across, like, it stores that value for you, so that you know what it is that you have. It's very hard to remember otherwise. It's a lot of numbers and letters.
Okay. Thank you. And what is a cryptocurrency exchange?
A centralized cryptocurrency exchange is an exchange where people come together to buy and sell cryptocurrency. The exchange is the intermediary or the body that stands in between them. So you're not directly buying and selling with someone, there is an exchange in between you, similar to, again, borrowing terms from, regular finance, how an exchange works as well, when you buy and sell stocks. You're not, buying directly from Apple when you buy Apple stock. There's someone in between you that's facilitating that transaction.
Okay. And what are some of the benefits of a centralized cryptocurrency exchange?
Well, first of all, you don't have to remember your hashtag of all these letters and numbers. That is the responsibility of a centralized exchange, to maintain that type of information. A centralized exchange also provides other types of services, usually compliance, KYC, and AML. KYC is Know Your Customer, AML, anti-money laundering. Also cybersecurity and auditing and recording functions. So that you just, similarly to when you buy or sell stock. The centralized crypto exchange also should be able to tell you what it is you bought and sold, for how much, and what date.
Okay. And now how is cryptocurrency created?
Similar to wallets and other sort of terms borrowed from traditional finance. Cryptocurrency is created by what's called minting, so just as money is minted and created, cash. Cryptocurrency is minted by creating new cryptocurrency that's put on the blockchain through what's called a smart contract. And that information is also publicly available online, on the blockchain.
Okay. And what is the role, if any, of the smart contract or code encrypting in minting? Excuse me.
Well, it shows you, it provides public access to people that want to see the code, that want to understand the code, to see whether it exists or not or how it's being minted. Not a coding expert. But you can see it online, coding experts obviously can, but it is publicly available. It's part of the how crypto culture has evolved that it's very open source in that way.
Okay. Now what is a white paper?
A white paper is a term used in crypto it's usually publicly available and on their website. To show what the technology is, what the purpose is, what the value proposition is. Why someone should purchase that crypto. It's usually also forward-looking. So they usually start with what they think the value is at the time, but they very often typically include what their value proposition is in the future and where they see their crypto being used and why.
Okay. And is there a custom or practice in the space with respect to white papers?
Yes, they're typically put online on the website and shared, again. Part of the open source culture. But also to encourage people to want to use or adopt that cryptocurrency by showing the technology and what the potential uses are. That's how people learn about it.
Okay. Now you mentioned the culture that surrounds cryptocurrency once or twice in your answers. Are you familiar with the term HODL, HODL?
Yes, it means to hold on for dear life.
And could you just explain for the benefit of the members of the jury what that means?
Sure. It's an expression used in the crypto culture online frequently as an expression of enthusiasm. And it's used both ways. It's used when the price of cryptocurrency goes up. HODL can mean to hang on because they believe the price is going up, and not to sell early. But also when the price of cryptocurrency, and if I didn't say this before, it's used across all cryptocurrencies. When the price goes down, too, it's also used as in, don't sell off right now, hold on. Because we believe this cryptocurrency has value.
Okay. And the same question with respect to the phrase, to the moon. Are you familiar with that?
Yes.
Okay. And can you explain what that is, please?
It's also an expression used in the crypto community. Also an expression of enthusiasm. I mean, the moon is, I think 239,000 miles away? Maybe some people actually believe the price of crypto will hit $239,000. But in general, it's an expression of the price going up and being enthusiastic about that price going up.
And in your experience, are those terms common in the crypto world?
Yes. And as I mentioned, they're used across all cryptocurrencies. It's not specific to any cryptocurrency.
Okay. Thank you. Now that we understand the terms a little bit better, let me ask you, why do people use cryptocurrency?
There are a couple reasons. First, I'd say enthusiasm for the technology. Second, privacy. Third, the unbanked and underbanked. And fourth, for cross-border remittances.
Okay. Maybe we'll sort of take each one of those in turn. I think the first one you said was a belief in cryptocurrency, or enthusiasm. Can you just expand on that a little bit, please?
Yeah. So the concept of cryptocurrency, of having a digital currency that doesn't exist through or for a bank is new and novel. It excites people in the industry and the people that create it and people that invest in it and believe in it. And even from the time of Bitcoin's inception until now, a lot has changed. And there's a lot of enthusiasm about it. You know, one comparison is often used to the internet. And when the internet first came out, there were some skeptics, thoughts about government regulation. But we all remember the first time we got our first email and it was an exciting moment. And so cryptocurrency is also in that moment, that it continues to evolve. And when you think about the internet, we had the internet, we had email. Now we have things that people couldn't even imagine were possible with the internet. TikTok and social media and every virtual reality and things like that. And so cryptocurrency, for enthusiasts, is also still has a lot of potential, and current potential.
Okay. And then I think another reason you identified as to why people would use cryptocurrency was privacy. Could you just explain that a bit more?
Sure. Cryptocurrency can be issued not from or through a bank or other intermediary. So it affords a certain level of privacy in that respect. As I mentioned, you can follow what's happening on the blockchain, but there aren't names involved, or addresses. And if you create different types of systems, ecosystems for crypto, people from the outside can't see what's happening on the inside.
Okay. And then I think a third reason you identified was access to banking. Maybe you can just explain that one a bit as well.
Sure. So underbanked refers to people that have access to bank accounts but do not have the full sort of services of a bank account. They may not be able to afford a savings account. They might not have the credit ratings to get a mortgage from their bank, for example. And unbanked are people that don't have bank accounts at all. And in the United States, there are millions of people that are unbanked and underbanked. Around the world, There are over 1 billion people unbanked. And when you count underbanked too, you're over 2 billion people. So how I think about it too is, in the United States. I take for granted that I can walk to an ATM. That my bank will be backed by the US government and have money when I go, and my bank will be backed, obviously, as well, when I go take out money. That is not the situation for a lot of people in the world. And so, but a lot of people do have cell phones, a lot of people do have access to either wireless or Wi-Fi. And so having apps that allow them to transact money, cryptocurrency, is one way for the unbanked and underbanked to transact money. It is being used in many developing countries as a way of increasing financial inclusion in that respect for people that don't have bank accounts. And, I would also point to, there are situations where people even that were banked may become unbanked. For example, in Ukraine, when Russia invaded, there were a lot of people that were not able to access ATMs. They were not able to when they went to their banks. There wasn't enough money left to be circulated around. People turned to cryptocurrency. And indeed, hundreds of millions of dollars worth of cryptocurrency has actually been sent to Ukraine to help because of the banking situation there.
Okay. Thank you for that. And then I think the last reason that you identified as to why people would use cryptocurrencies was cross-border remittances. Can you just explain that?
Sure. So somewhat relatedly to, that in other countries, also in the United States, people have access to phones, but may not have access to bank accounts. Cross-border remittances refers to, when you don't have a bank account, but you're making money, how do you? And your family that lives abroad, how do you send that money? And one way that cryptocurrency is used is because of that. Cross-border remittances through some major providers can charge 30% or more of what you're sending. And so when you're thinking about people that are unbanked or underbanked, why they're using these services, 30% of or more of what they're sending is, I think it's a large percentage for anyone. But it's particularly a large burden for people that are just trying to send what they're trying to send, which might be minimum wage or less.
Okay. Thank you for that. Now how does a sort of typical cryptocurrency, withdrawn? How does a typical cryptocurrency transaction work on a centralized exchange?
On a centralized exchange, you would either, depending on the exchange, either send US dollars to the exchange which would be converted into either crypto or other stablecoins, which I haven't defined yet. But it will be converted into whatever the token or crypto that you're buying is. Or other exchanges accept crypto for crypto, so you can put crypto into the exchange to buy other forms of crypto.
Okay. Now let's just talk about custody and custodians. What is a custodian?
A custodian is the entity or representative that holds your cryptocurrency. That could be a wallet, an exchange, or some other entity that has custodial rights to your crypto.
Okay. And is the custodian akin to a bank that holds the crypto on your behalf?
Mr. Horton said, objection to leading.
The court said, overruled. You may answer.
Sure. So by entity, we said entity. Yes, it's some party, intermediary, broker, bank. Some entity that is holding your crypto and has custodial rights over it. So that, they have custody of it. You can't physically hold cryptocurrency. So it has to go somewhere.
Okay. Now what are stablecoins?
Stablecoins are a form of cryptocurrency that are meant to be pegged or equivalent to a 1-to-1 ratio. So one stablecoin equals $1, for example.
Okay. And are there other stablecoins that could be pegged to other currencies as well?
Yes. US dollar stablecoins are the most common, but stablecoins are often also pegged to the euro. That's probably the second most common.
Okay. Now why do people use stablecoins?
There are a couple of reasons. One is just, when you think about just holding a basket of assets. Stablecoins are just another type of asset. So there, again, sort of the intention is for it to be 1-to-1, so, if you think of having, your own, basket of assets, you might have stocks. Stocks go up and down, like cryptocurrencies do. Stablecoins might be more like having money in a money market. Mutual fund, which is meant to be like one-to-one, or like a savings account with a relatively low interest rate. It's something stable in your basket of assets, and it's not going to fluctuate. Next in the cryptocurrency sort of system, just how it's developed is. Stablecoins are often used when you're using cryptocurrency because of the instability in the price. When you're trying to transfer your cryptocurrency to different venues or means, it's common to transfer it to a stablecoin so you know where your money, what the dollar value is when you then try to transfer that out to somewhere else.
Okay. Now are you familiar with what, if any, outside service providers a centralized exchange may work with?
Yes.
Okay. Can you give us some examples, please?
Sure. They might use compliance providers, and that would include, or could include, AML and KYC providers, cybersecurity, outside wallet providers are also very common, and auditing services. As well as probably other services, looking at the code, for example, as well.
Okay. Thank you for that. Now moving on to the facts of this case and the specific cryptocurrencies at issue. I believe you said a few minutes ago that amongst the materials you reviewed were the white papers. Right.
Yes.
Okay. Can you provide an explanation of the white papers for HDO, please?
It explained the stablecoin and what the value proposition for it was going to be. And what it was at the time.
Okay. And based on your review of the white paper for HCN, can you just explain what your understanding is of HCN, please?
Sure. That was the exchange's cryptocurrency. And the white paper there too explained the purpose of it and the value proposition and where they expected that to go as well.
Okay. And why is it that an exchange would want both a stablecoin and a trading token?
I think it makes sense when you think about then the sort of transfer, first of all, the difference in value, holding one that's more volatile, holding one that's more stable. So there's that, in your basket of assets. And then there's also just the transferring in and out. When you transfer your crypto to a stablecoin, you know what it is. When you try to transfer your stablecoin out or to something else, what it is that you're doing. And it's that's done. Again, the price of crypto can be volatile so, so transferring it to a stablecoin is frequently the way that people move their crypto around when they're transferring it around.
Okay. And what, if any, role does a stablecoin like HDO play in getting sort of value into a centralized exchange?
It's one way of purchasing a crypto from the exchange, from a cryptocurrency from the exchange. And then it's, the exchange can, pursuant to the white paper and how the exchange operates. How that gets used.
Okay. Fair to say it's something of an on-ramp into the exchange.
In this.
The value into the exchange.
Yes, in this case you could buy a stablecoin to, transact on the exchange.
And so one would purchase stablecoins using US dollars. And that value in US dollars would then be tradable on the exchange, fair?
Yes, that's.
Mr. Horton said, "Objection, Your Honor."
The court said, "Overruled. You may answer."
And the same.
Oh, sorry. Yeah, according to the white papers and what I've seen, yes, that was the purpose of that.
Okay. And the same question with respect to getting value out of the exchange. Did it function? Serve that function as well?
Yes, according to the white papers and the documents I've seen, that was the purpose.
Okay. Now, Ms. Sklar, did you withdrawn? I believe you testified earlier that you used something called Etherscan to make some observations about the tokens at issue here.
Yes, Etherscan is a publicly available version of the blockchain to look at the Ethereum blockchain.
Okay. And can you just explain that a little bit further for members of the jury?
Mr. Horton said, "Objection, Your Honor, in view of the sidebar, scope."
Mr. Skirek said, "I'm just asking for an explanation of what Etherscan is, how it works, not what she observed here." Your Honor.
The court said, generally.
Sure. So similarly to how I explained visually, using an Excel spreadsheet example. The Etherscan website looks relatively similar. It just has columns going across with the hash, which is the identifier, has the from and the to, has the date, has the amount, and it's searchable. So you can search by token, by stablecoin, if you know the hash numbers you're looking for, the from, to. You can search it by date. It's on the internet. It's part of the way crypto and Ethereum works is that it's a public blockchain.
And is it typical for people to use Etherscan to observe the blockchain?
I think so, because it's free. I mean, there are other versions you can pay for, but, the free one is usually what people go to.
Fair enough. Okay. Now did you use the Etherscan to observe the tokens at issue here? Just yes or no?
Yes.
And did you observe a minting event for HDO?
Yes.
And by minting event, we mean when it was created.
Yes, as I explained, yes.
Okay. And did you observe a minting event for HCN on the blockchain?
Yes, I did.
Okay. And can you just briefly tell us what you observed about those minting events?
Mr. Horton said, objection, again, due to the sidebar.
The court said, sustained.
Did you observe on Etherscan that there were relatively few transfers of HCN and HDO?
Yes.
And was that surprising to you?
No, not for tokens that are relatively new. There's typically, when tokens start trading, there's a lot of illiquidity in the market.
Okay. Now let's just talk about the nature of the Himalaya exchange for a moment. What kind of exchange was the Himalaya exchange?
A centralized exchange.
Okay. And I believe you testified before that a centralized exchange may use a single wallet or a set of wallets.
Yes. Part of why people use a centralized exchange is because the exchange has the wallet in custody so that, again, you don't have to remember all of the numbers, all of the transactional data. The centralized exchange does that.
Okay.
And Himalaya Exchange was a centralized exchange is a centralized exchange.
Okay. And from your review of the white papers for the two tokens at issue, do you have an understanding of a credit system that the Himalaya exchange used?
Yes.
And can you just explain that to the jury, please?
Their credit system was an internal system to keep track of cryptocurrency being transacted. It was called a credit system. But you could probably use any other word too. The word credit is just the word that was used. It could have been described as an internal ledger system. Other centralized exchanges do similarly have internal systems to account for crypto.
Okay. And you testified before that there were relatively few transfers that you observed using Etherscan. Is it fair to characterize those as on-chain transactions?
The ones that are available, the ones that you can view on Etherscan are publicly available. And that would be an on-chain transaction because it's publicly available on the blockchain.
Now what would you expect to see in terms of the public visibility of transactions conducted in a centralized exchange?
Internally, if there's an internal ledger, credit system, or a tokenization system, however the accounting is being termed or called internally, those transactions would be considered off-chain. They would not be on the public blockchain. But there would be an internal system within the centralized exchange to keep track.
So one would not be able to see transactions happening on the Himalaya exchange, for example, on-chain. Is that fair?
Mr. Horton said, objection. Compound.
Mr. Skirik said, it's one question.
The court said, if you'll rephrase that, please.
Mr. Skirik said, sure. For a centralized exchange, would you expect to see all of the transactions conducted on that exchange on the blockchain?
No, and in fact, one of the largest centralized exchanges in the world doesn't do that either.
And what exchange are you referring to?
Coinbase.
Okay. So for the Himalaya exchange, could you tell how many transactions were conducted by the exchange simply by looking at the blockchain?
No.
Mr. Horton said, objection, scope.
The court said, sustained.
The Himalaya exchange is a centralized exchange, right?
Yes.
And any reason to expect the Himalaya exchange to reflect transactions differently than any centralized exchange?
Mr. Horton said, same objection, scope.
The court said, sustained.
Okay. Have you heard of the phrase closed system when it comes to a cryptocurrency exchange?
Yes.
Okay. And what does that mean?
That the centralized exchange would be more internalizing its own crypto and functions and conducting more off-chain than on-chain. But when it needed to be on-chain would be on-chain.
Okay. And so fair to say you would expect most of the transactions to be off-chain?
For a closed system, yes.
For a closed system. Okay. Now would you consider the Himalaya exchange a closed system?
That's my understanding from the white papers, and what I've seen was the intent of it is the intent of it. Yes.
Thank you. Now, Ms. Sklar, I believe you, withdrawn. Did you review any third-party contracts that the exchange had with outside service providers?
Yes.
Okay. And can you just tell us about those briefly?
I saw CertiK, which reviewed the code, Armanino, which did the auditing, and BitGo, which was the wallet custodian.
Okay. And what significance, if any, do you draw from the exchange's use of these third-party service providers?
It's very typical, as I mentioned, to outsource certain things to third parties, and in fact, it's usually considered a best practice, particularly when you think of who they were using. Well, first of all, to outside auditors are always a best practice rather than relying on your own. And BitGo is one of the world's biggest and most well-known wallet custodians for crypto.
Okay. And how about Armanino, the auditor?
Again, you need to having a third-party audit for any type of exchange is always a best practice.
And in terms of best practices, what, if any, best practice would there be with respect to the auditing of reserves?
Well, you would look at, the bank accounts to see what their reserves were, and what mix that was, whether it was cash, US dollars, or other types of assets.
Okay. And just to be clear, because I think I may have jumped over the part about what reserves are. What are reserves?
Sure. For stablecoins, to when you have a reserve-backed stablecoin and you're trying to do one-to-one. It means do you have what's backing the stablecoin to make it one-to-one?
Okay. Now the outside service providers that you just described. Are those common service providers for a cryptocurrency exchange?
Yes.
In particular for a centralized cryptocurrency exchange?
For a centralized, yes.
Okay. Now, Ms. Sklar, based upon your review of the materials that you've described, and your expertise, did you reach any conclusion with respect to HDO and HCN?
I mean, that they were cryptocurrencies being, offered from the exchange. And they were on the blockchain.
Okay. And so your view is that HCN is a cryptocurrency that exists on the blockchain?
Yes.
And that HDO was a cryptocurrency that exists on the blockchain?
A stablecoin, yes. Form of cryptocurrency, yes.
Thank you for that. And what is the basis for that conclusion?
My review of the documents, including third-party documents we just mentioned, and my review of Etherscan and the blockchain.
Mr. Skirik said, okay. Thank you, Ms. Sklar. Your Honor, no further questions at this time.
The court said, cross-examination.
Cross-examination. By Mr. Horton.
Good afternoon, Ms. Sklar.
Good afternoon.
To learn about the Himalaya exchange, you reviewed its white papers, right?
Yes.
And those are documents that are written and issued by the exchange, is that correct?
Yes.
Did you pull those down from the exchange's website?
They're on the website, but I was also given that I also saw them through the attorneys.
And did Mr. Guo's lawyers allow you to interview any authors of these white papers?
Mr. Skirik said, objection.
The court said, overruled. You may answer.
I did not, no.
And did you in fact interview any of the authors of these white papers?
I didn't, no.
You don't know the names of the authors of these white papers, do you?
I don't, no.
And in preparing to testify today, you didn't visit the exchange's headquarters in Abu Dhabi, did you?
I did not.
You testified about your understanding of the intent of the exchange. Do I have that right?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
The intent from the white papers, yes.
Those were based on what the Himalaya Exchange said its intentions were, is that correct?
Yes.
You didn't create an account at the Himalaya Exchange, did you?
No.
You didn't purchase H-coin credits, did you?
No. I don't think it would be appropriate for me to testify if I actually owned anything in Himalaya Exchange.
So just so I'm clear, you haven't personally used the Himalaya Exchange?
No.
Okay. And, I mean, just, again, so I'm clear, you didn't buy any H-dollar credits for yourself.
Mr. Skirek said, asked and answered.
The court said, sustained.
Do you have a cryptocurrency wallet, Ms. Sklar?
Yes.
Does it have Himalaya dollars in it?
No. As I said, I haven't.
Mr. Skirek said, objection. Asked and answered.
No financial, yeah.
The court said, sustained.
Mr. Horton said, I'll move on, Your Honor. There were at least 4 white papers issued by the exchange, isn't that right?
I think so.
Did you review all the white papers?
Yes.
So how many were there?
I've seen.
Mr. Skirek said, objection. Asked and answered.
The court said, overruled. You may answer.
I've seen drafts. I want to say I think there's 4, but, yeah, I mean, I saw what I was given. And there were drafts, yeah. It was more than, probably, 4.
I see. And there was at least one for H-coin and at least one for H-dollar, is that right?
Yes.
And 2 of those white papers were issued in 2021, correct?
Yes.
And another 2 were issued in 2022, is that right?
Yes.
And each of those white papers is almost 40 pages long, is that true?
Yes.
Each one.
If you represent they were 40 pages, I'll believe you. I don't have them in front of me.
Did you read them all the way through?
Yes.
More than once?
Yes.
And each one of those 4 I just mentioned is more than 12,000 words long, is that right?
Mr. Skirek said, objection.
The court said, overruled. If you know you can answer.
I don't know.
And you just testified that you read them more than once, is that right?
Yes.
And did you feel that you understood them after reading them more than once?
Yes.
You've reviewed white papers before you were hired to testify in this case, right?
Yes.
In fact, you're a lawyer, aren't you?
Yes.
You've been a lawyer for more than 15 years, isn't that right?
19, yes.
And in fact, you're a regulatory lawyer in particular, isn't that correct?
Yes.
And you used to regulate cryptocurrency exchanges, isn't that right?
Mr. Skirek said, objection. The witness.
The court said, you may answer.
Mr. Skirek said, the witness didn't regulate.
The court said, you may answer.
I can sort of, so, as you know, technically, cryptocurrency exchanges aren't regulated by the CFTC or the SEC right now. But regulated financial products, yes.
Ms. Sklar, you have a lot of experience reading and understanding cryptocurrency white papers. Isn't that fair to say?
Mr. Skirek said, objection. Cumulative.
Yes.
The court said, you may answer.
Yes.
And in fact, you've advised clients of your own on drafting white papers, isn't that right?
I have, yes.
You said that white papers are how people learn about crypto tokens, right?
Yes.
You don't know how members of the Mountains of Spices farm learned about H-coin, do you?
I don't.
Do you know if David Dye shared the white papers with members of the UK farm?
Mr. Skirek said, objection. Your Honor, can we have a sidebar?
The court said, if you know you may answer.
I don't know.
Mr. Horton said, I just have one more question on that topic, Your Honor, right now. Do you know if any farm leader shared white papers with farm members?
Mr. Skirek said, Objection, Foundation.
I don't know what that means.
The court said you may answer.
Sorry. I don't know.
Okay. You testified earlier about cryptocurrencies and credits, right?
Yes.
And I think in your words, cryptocurrency only exists through the blockchain. Do I have that right?
That's how you can tell if it's a cryptocurrency is when you can look at it on a blockchain.
And if you can't see a coin on a public ledger, you can tell it's not cryptocurrency, right?
I wouldn't characterize what I said that way, but...
Mr. Skirek said, Objection.
The court said you may answer. I'm sorry.
The witness said, I'm sorry.
The court said, I spoke over you. If you'll read back the question, please.
Record read.
The court said go ahead.
No. I wouldn't characterize what I said that way.
Okay. But I understand you correctly that cryptocurrency only exists through the blockchain, right?
For it to be a cryptocurrency, it would need to at some point be on the blockchain. But that doesn't mean what you're doing doesn't involve cryptocurrency.
And you testified about exchange credits, right?
Yes.
And those are notations on internal databases, right?
In this case, yes.
Yeah. And those internal databases, they're not on the blockchain, right?
In my understanding, the credit system was not on the blockchain.
The Coinbase internal credits, those are off-chain. That's what Coinbase calls it, right?
They call it an internal distributed ledger system, but yes. They could have called it credits or anything else, but that's what they call it. That's on their website, yes. And that's...
Okay. But...
the usage of Coinbase.
I'm sorry. I didn't mean to interrupt you.
No. Yeah, go ahead.
The court said when you say they, who are you referring to?
The witness said, sorry. Me?
The court said yes.
The witness said, sorry. Can you repeat back? When did I say they? Sorry.
The court said, if you just please restate the answer, the question and the answer.
You said that Coinbase.
The court said, I'm asking for the reporter to read it back.
Mr. Horton said, sorry.
Record read.
Sorry. Yes, by they, I meant Coinbase. It's part of the usage of Coinbase. But it's also publicly available, as an explanation, how Coinbase operates.
The court said go ahead.
Mr. Horton said, thank you, Your Honor.
By Mr. Horton.
The internal database at Coinbase, Ms. Sklar, that you're just describing now, that's not on the blockchain. Correct?
That's my understanding, without also revealing anything that I'm not allowed to reveal. I'm only going to discuss things that are publicly available.
Understood. These internal databases where an exchange keeps their credits. They're not publicly available, right?
The internal database, no.
And the Himalaya Exchange's internal database, where its credit transactions are located. That's not publicly available, right?
That's my understanding.
You haven't seen the Himalaya Exchange's internal database, isn't that right?
I have not.
And you testified about what you expect to see on a centralized exchange's ledger, isn't that right?
Mr. Skirek said, Objection.
What's usual or could be?
The court said you may answer.
What's usual or could be, but every centralized exchange is allowed to, frankly, have its own model.
And you don't know, sitting here today, whether the Himalaya Exchange's private ledger matches your expectations, isn't that right?
Sorry. My expectations of?
Well, you just testified about what's usual at a centralized exchange, isn't that right?
Yes.
Sitting here today, you haven't looked at the Himalaya Exchange's internal ledger, isn't that right?
Right.
So you have no way of opining about whether the Himalaya Exchange's actual internal ledger matches your expectations of what's usual at a centralized exchange. Isn't that true?
I haven't seen it, so I can't really say either way. I have, as I just said. I haven't seen it.
Your testimony today was that the Himalaya exchange is designed to be a centralized exchange, right?
Yes.
And that means that some person or group of people control its operations, isn't that true?
Yes.
Do you know who those people are?
I've seen the diagrams and the, organizational charts. I haven't memorized them. But I've seen them.
And who gave those to you?
They're in a document that may or may not be an exhibit. There's a business plan.
And, sorry, who gave that document to you, the org chart at the exchange, before you testified?
The lawyers, but it's in the Himalaya Exchange business plan. It may even be in the white paper as well. In fact, in the white paper, there are bias in there. The org chart is in their business plan, as I recall.
And so because it's designed to be a centralized exchange. That means there's some group of people with control over this internal database that you haven't seen. Isn't that right?
Yes.
Okay. Now some centralized exchanges sell crypto tokens directly to customers' wallets, isn't that true?
Yes.
It's possible to use Coinbase, for example, bring your own wallet as a customer. And receive and hold crypto token yourself, isn't that right?
Mr. Skirek said, objection, compound.
The court said, you're asking whether it can be done?
Mr. Horton said, I can break it down a little bit, Your Honor.
The court said, okay, go ahead.
If a person goes to Coinbase with their own wallet, they can obtain cryptocurrency to hold themselves directly, isn't that true?
Mr. Skirek said, objection.
The court said you may answer.
Now, but that wasn't always the case.
But it's true now, isn't it?
It is true now. It took time though.
And Coinbase. Not the only centralized exchange where you can show up with your own wallet and get crypto tokens to store in your wallet. Isn't that right?
Yes.
But in the Himalaya ecosystem, customers could not hold H-coin tokens in their own wallets. Isn't that true?
At that time, but that's not what the plan was, according to the white papers.
Well, I'm not asking about the plan. Is it currently the case, right now, today, that you can hold H-coin tokens in a customer wallet?
As of today, I don't believe so.
Okay. In fact, all that Himalaya Exchange customers can buy are credits, right?
Right now? I think so.
Well, what about for the entire period of your review?
I mean, the plan was, obviously, for.
I'm sorry. I'm going to just interrupt you really quickly, Ms. Sklar. Because I'm not asking you about the plan or the future or anyone's intentions.
Mr. Skirek said, Your Honor, can she be allowed to answer the question?
The court said right. So he's asking you not about what they may have planned to do but what they actually did.
Sure. At the time, yes.
In fact, isn't it true, Ms. Sklar, that even in the white papers, stating their intentions, the Himalaya Exchange said that customers couldn't hold any crypto assets at all in the Himalaya ecosystem? Isn't that true?
Honestly, you'd have to point me to where that says. I actually don't recall that sentence.
That's fine. Mr. Horton said, can we pull up GXAS 12, which is in evidence, please, Isabel, and go to page 11. Let's start at the first page. Actually, so we can see what document we're looking at. So Ms. Sklar, this is the January 2022 Himalaya Coin White Paper. Did you review this?
Yes.
Mr. Horton said, okay. If we can go to page 11, please, Ms. Loftus. And do you see the section of this page, Ms. Sklar, that's titled Structural Considerations?
Yes.
Mr. Horton said, if you could blow that up, please, Ms. Loftus. Ms. Sklar, if you could just read on this last paragraph, it starts, prospective members. And if you could just read that sentence, aloud.
Sure. The one that starts with prospective members?
Sure. It's the last paragraph, the first sentence.
Prospective members are advised that neither crypto assets or fiat currency may be held by members within the Himalaya ecosystem. And the Himalaya ecosystem does not provide. And none, it's a long sentence, and none of the Himalaya Exchange or any other entity within the Himalaya ecosystem holds any necessary licenses or authorizations to provide any type of custody or other arrangements to facilitate this.
Ms. Sklar. That 4-line sentence says that members cannot hold any crypto assets of any kind at the Himalaya ecosystem. Isn't that right?
No. It says.
Mr. Skirik said, objection.
The Himalaya ecosystem does not provide. The sentence refers to that they didn't yet have the ability to do Bitcoin and Ether, which was their plan.
Let's start at the beginning of the sentence.
Okay.
There's a line and a half before we hit the first comma. Can you read that line, please?
Before the first comma. The prospective members.
That's right.
Okay. Prospective members are advised that neither crypto assets or fiat currency may be held by members within the Himalaya ecosystem.
Okay. That language from the white paper released by the Himalaya Exchange says that members cannot hold crypto assets within the Himalaya ecosystem. Does it not?
Mr. Skirik said, objection.
I mean, the sentence says what it says, but I may disagree with how I read it.
Well.
The court said. So what is the question? Is the question what does it say?
Ms. Sklar, you interpret documents like this for a living, correct?
Mr. Skirik said, objection, Your Honor, relevance.
The court said. Overruled. Of course it's relevant.
Yes. Just give me.
And these documents are not written only for lawyers, isn't that right?
Right.
They're written for people who might invest in coins they might find on the internet, isn't that right?
Yes, but they're heavily edited by lots of lawyers and lots of other people. So this is not the clearest sentence I've ever seen, just to be honest.
Stipulating that it's not a clear sentence, does the first clause, before we get to the comma, say that neither crypto assets or fiat currency may be held by members within the Himalaya ecosystem? Yes or no? Is that what it says?
Mr. Skirik said, document speaks for itself.
It says that, but I disagree with what I think the sentence means.
Ms. Sklar, the question was.
The court said. The question wasn't how you interpret it, but what does it say?
I read it, though. I mean, it says what it says, and I've read it now a few times.
The court said okay.
Mr. Horton said, Your Honor, we can move on.
The court said. Excuse me?
Mr. Horton said, we can move on from the topic.
The court said go ahead.
Ms. Sklar, if somebody wanted to buy a credit on the Himalaya ecosystem, they would have to send US dollars to a Himalaya bank account, isn't that right?
Yes.
And you said in your testimony earlier that one reason that people use crypto tokens is to avoid using banks. Isn't that right?
Mr. Skirik said, no. Objection. Totally misstates the testimony.
Mr. Horton said, the question was for the witness, not Mr. Skirik.
The court said, sustained.
Mr. Horton said, maybe I misunderstood, Your Honor.
By Mr. Horton.
Ms. Sklar. Did you not testify that a reason to use cryptocurrency is to not use a bank for financial transactions?
Mr. Skirik said, same objection.
The court said. Overruled. You may answer.
I mentioned privacy and I mentioned not using third-party intermediaries like banks, yes.
Like banks, correct?
Yes.
But isn't it a fact that to buy a credit on the Himalaya ecosystem, you had to send US dollars through a wire transfer, isn't that right?
I mean, they had to send US dollars. Whether they were using Venmo or wire transfers. I actually don't know, but yes, the dollars had to get there, yes.
Is there a way to use Venmo or wire transfers without using a bank?
No, not usually. Well, no.
Not usually or no?
I mean, no.
And sending those US dollar wires to the Himalaya exchange, that transaction, that's not on the blockchain. Right?
A wire transfer, no.
It's not a cryptocurrency transaction when you do that, is it?
Right. It's not.
And after the exchange gets the US dollars from a customer, by the way, I'm sorry. One question. Are wire transfers anonymous?
No.
Can you send US dollars without revealing your true name?
Mr. Skirek said, asked and answered.
The court said, overruled. You may answer.
When you send a wire transfer through your bank knows your name.
And after a customer sends US dollars through the wires and gets an H-coin credit. The customer at the Himalaya exchange, they have no right to get an actual H-coin token, isn't that true?
They get the credit, which is representative of a right. But are you asking whether they get an actual coin or?
Well, both of those. Do they get an actual coin?
I don't think so. I think at the time that they would get the credit.
And you said a moment ago that the credit is representative of a right to get the coin. Is that your testimony?
That's my understanding of what the credit system.
Mr. Horton said, Ms. Loftus, can we bring the white paper back up, please, GXAS 12, same page, page 11. If you can blow up the third paragraph from the top. I'm going to read this one this time, Ms. Sklar. Credits can only be used on the Himalaya exchange or within the Himalaya ecosystem. Representing a right to participate in trading on the Himalaya exchange and do not carry any right to require their exchange for fiat currency or crypto assets.
Millimeter.
So holding an H-coin or an H-dollar credit at Himalaya did not carry a right to require its exchange for crypto. Isn't that what this says?
To require it, yes.
Mr. Horton said, okay. We can take it down, Ms. Loftus. The credits that customers could buy at the Himalaya exchange. Those credits couldn't be used anywhere else other than the Himalaya ecosystem, isn't that right?
Right.
When you go to Coinbase, for example, you can buy cryptocurrency and take it out of the exchange. Can't you?
Yes.
You could buy Bitcoin on Coinbase and sell it on Binance, isn't that right?
Mr. Skirek said, objection.
Bitcoin isn't issued by Coinbase, it's.
The court said you.
Oh, sorry.
The court said you may answer.
It's a little bit apples and oranges there because Bitcoin isn't issued by Coinbase. So of course you can get it out, it's not a closed system.
Well, my question isn't whether Coinbase issued the coin. It's whether you can buy Bitcoin at Coinbase and then sell it at a different exchange.
That is how they've set up their system, yes.
And cryptocurrencies are often listed on multiple exchanges, isn't that right?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
If the issuer has designed it that way, but it doesn't have to be.
And Bitcoin, for example, that's listed on over 100 exchanges, isn't that true?
Mr. Skirek said, objection, foundation.
The court said you may answer.
I mean, Bitcoin is the most decentralized cryptocurrency, no one even knows who created it, so yes. It's everywhere.
Tether, that's another stable coin, isn't that right?
Tether is a stable coin, yes.
And Tether is listed on 115 different exchanges, isn't that true?
Mr. Skirek said, objection.
The court said you may answer.
I can't confirm 115, but yes, it is I think the most highly traded stablecoin right now, yes.
You said a moment ago that Coinbase didn't issue Bitcoin, is that right?
Yes.
And you were drawing a comparison with the Himalaya exchange issuing its H-coin and H-dollar. Isn't that right?
I was, yes.
Binance is another cryptocurrency exchange, isn't that true?
Yes.
And they issued an exchange coin called BNB, isn't that right?
Yes.
And Binance exchange coin, BNB, is listed on exchanges other than Binance, isn't it?
Yes, as part of their design, yes.
In fact, it's listed on 62 other exchanges, isn't it?
Mr. Skirek said, objection.
The court said, you may answer if you know.
I don't know 62, but I know it is traded, yes.
Continued on next page. By Mr. Horton.
You said in your testimony today that you reviewed other witnesses' testimony in this case, is that right?
Yes.
Did you review Jesse Brown's testimony?
Yes.
Do you know that he's the former CEO of the Himalaya Exchange?
Yes.
Do you recall that Mr. Brown testified that his understanding was that Himalaya coin wasn't listed at any other exchange because the exchange was worried that would cost its price to drop?
I can't if he said that, but I can't testify whether that's true or not. I don't know.
My question is not whether it's true. It is whether you read Jesse Brown, the former CEO of the exchange, testified that H coin wasn't listed at any other exchange to avoid its price dropping.
That's what he said.
And he was sitting right where you're sitting right now when he testified to that?
Mr. Skirek said, objection.
The court said, she wasn't here for the testimony so she can't answer.
Withdrawn. By the way, Ms. Sklar, Himalaya coin was not listed at any other exchange, was it?
It was not.
And H dollar was not listed any other exchange?
It was not.
Now speaking of H dollar, Ms. Sklar, that was described in the exchange's papers as a stable coin. Isn't that right?
Yes.
When I refer to it as HDO, you'll know I'm talking about the same thing?
Yes.
And sort of basic feature of stable coins is that they're redeemable, isn't that true?
It depends on the terms of the contract.
Well, let me ask you this. Are you familiar with any stable coins that can't be redeemed into the currency they're associated with?
Yes.
Which are those?
Tether, before it was subject to the CFTC's and New York State Department of Financial Services action, was only redeemable by people who had over 100,000. Which meant that the vast majority of average users of Tether could not redeem Tether.
But some could, right?
If you had over a $100,000 you could, yes.
And redeemable means that you can convert the stable coin into real-world currency, isn't that right?
Yes.
I don't say fiat because that's confusing, but that's what that means?
Yes.
And in fact a true fully reserved stable coin, it's redeemable one-to-one at all times, isn't it?
That's the intent, but even the best stable coins sometime drop down a peg to 98%, but, yes. That's the purpose of reserved coins, yes.
And if it wasn't redeemable at all times, it wouldn't be a true fully reserved stable coin, right?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
The purpose of a redeemable full reserve stablecoin is to be able to redeem it.
Putting aside its purpose, Ms. Sklar. What makes it a true stable coin is that it's redeemable at all times, right?
Mr. Skirek said, asked and answered.
The court said you may answer.
It sort of goes back to what I just mentioned about Tether and the issuer. If you have a stable coin right now on Coinbase, for example, Coinbase doesn't have an obligation to redeem it back one-to-one. If you wanted to go to your issuer, you could try to do that, but it depends on the contract with the issuer.
Ms. Sklar, didn't you write the words? A true fully reserved stable coin is redeemable one-to-one for US dollars at all times. Didn't you write that?
Is that from something I wrote?
Isn't it?
It's possible. Could you just refresh my recollection?
Yes. Ms. Loftus, can we pull up GXC 0207 and go to page 7 of it? Actually, let's go to the first page for the author. So, Ms. Sklar, just for the witness and the parties, please. This is the first page.
The interpreter said, Your Honor, can you please remind all parties to please slow down, please?
The court said, please slow down.
If you could go to page 2 for Ms. Sklar, please. That's your name there as an author of this document?
Yes.
Can we go to page 7, please? I may have the wrong page. Can we try the next page? At the top of page 8, Ms. Sklar, Ms. Loftus, can you highlight that 2-line fragment? Looking at this, Ms. Sklar. Does it refresh your recollection that you wrote? A true fully reserved stable coin is 100% backed by cash and short-dated U.S. Treasuries and is redeemable 1-to-1 for U.S. dollars at all times?
Yes. The point is a true fully reserved stable coin. This paper is about stable coins that are different, but I did write this sentence, yes.
And, in fact, the Himalaya dollar was not redeemable for U.S. dollars at all times, isn't that true?
I don't know that that's not true.
Ms. Loftus, if we can look back at the January 2022 H-Dollar White Paper GXAS 18. This is a document in evidence. If we can go to page 10, and if you could zoom in on the fourth paragraph down. Ms. Sklar, this paragraph says. Additionally, a member may make a request to the Himalaya Exchange to accept a transfer of HDO credits in exchange for an equivalent payment in US dollars to be paid to the bank account of the member. Just stopping there, that's describing a redemption, right?
Yes.
However, such exchanges are at the discretion of the Himalaya Exchange. And the Himalaya Exchange is not obliged to fulfill any such request.
Yes, that's what it says, yes.
And the meaning of that is that H-dollars were not redeemable into cash whenever a holder wanted. Isn't that right?
Mr. Skirek said, objection. These aren't her words.
The court said you may answer.
It says at the discretion.
What that means for non-lawyers is the Himalaya Exchange could decide not to redeem for dollars, right?
I mean, that's my understanding of the words at the discretion.
For any reason they wanted, right?
Mr. Skirek said, objection.
I have no idea what the reasons.
The court said, overruled.
Or for no reason at all, right?
Mr. Skirek said, same objection.
The court said, overruled.
I didn't work there. I don't know what the reasons would be. Do I understand what the word at the discretion means? Yes.
That means that the exchange could decide no redemptions for H-dollars for any reason we decide.
I don't know for any reasons. They might have their own reasons.
Mr. Skirek said, objection.
I'm not asking if they had reasons. I'm saying what this document says that you reviewed and testified about says that the Himalaya Exchange gets to decide for any reason it wants whether to redeem an HDO credit for US dollars.
Mr. Skirek said, objection.
The court said, overruled. You may answer if you agree with him.
It says at the discretion. Does that mean any reason? I assume there must have been some internal process that it wasn't just any reason.
I'm not asking about internal processes.
I didn't work there, so I don't know.
And you don't know about any internal processes there, do you?
I don't know what this sentence refers to.
Did you review any minutes of board meetings there?
I did not, no.
Ms. Sklar, you're a regulatory lawyer. What limits on the discretion to deny redemption for H-dollars are in this document?
Mr. Skirek said, objection. Foundation calls for speculation.
The court said, you can ask whether she knows of any limitation on their discretion.
The witness said, is that the question?
The court said, that's my question.
I'm not aware.
Okay. And the last sentence of this paragraph that we have up now says, references in this document. This is the January 2022 H-Dollar White Paper, references in this document to HCN, the Himalaya coin. A new coin issued by Himalaya International Financial Group, HCN or Himalaya coin. HDO or any other type of asset on an account at the exchange or through the Himalaya Pay app. References in this document to that list of things are references to credits corresponding to that asset. Is that what that says?
Yes.
In fact, Ms. Sklar, the Himalaya Exchange did refuse redemption for Himalaya dollars, isn't that true?
Mr. Skirek said, objection. Foundation.
The court said if you know.
I also thought they gave redemption.
You testified a moment ago that you read Jesse Brown's, the transcript of his testimony in this trial. Right?
Yes.
Do you remember that Mr. Brown testified that after the Himalaya Exchange's bank accounts were seized in the fall of 2022, the exchange stopped doing redemptions for H-dollars?
After the accounts were seized, yes.
So the Himalaya exchange stopped doing $H redemptions?
After its accounts were seized, yes.
What was the exchange using to back up $H with cash after its accounts were seized?
Mr. Skirek said, objection to form.
The court said, if you know you may answer.
I don't know actually.
I want to talk about those. Those are the reserves, right? Cash that backs up stable coins are reserves. Right?
Yes.
I want to talk about those reserves for a minute. You testified about reviewing documents that Himalaya sent to a company called Armanino, right?
Yes.
And Armanino at that time did audits of crypto companies, right?
Yeah.
Does Armanino still do audits of crypto companies?
No.
Do you know why they don't?
Mr. Skirek said, objection, relevance, Your Honor.
The court said, you may answer if you know.
I don't know why.
Did you review a document that said the exchange has $400 million more or less in cash reserves for its $H?
Yes.
Do you remember that document had a part at the bottom that says, I'm representing that this is accurate and complete?
I believe so.
Mr. Skirek said, objection.
I think I know what document you're talking to.
The court said you may answer.
I think I know the document you're referring to. I can't recall that it says that sentence. But if you represent to me that it does, I mean I have no reason to believe it doesn't say that.
And crypto auditors rely on information that's given to them by the companies they're auditing, right?
All auditors do, not just for crypto.
Do you remember that Armanino document where information was represented by the Himalaya exchange? Do you remember it was signed by Jesse Brown?
Yes.
Do you know if Jesse Brown read that document before he signed it?
Mr. Skirek said, objection.
The court said, if you know you may answer.
I don't know.
Do you know sitting here today if the information in that document is accurate and complete as Mr. Brown represented with his signature?
All I know is what the document says and what was represented in it.
Did you speak with Priya Patel when you were learning about the Himalaya exchange?
I did not.
Do you know who she is?
Yes, from some references in documents, yes.
And she was a general counsel at the Himalaya exchange, isn't that right?
Yes.
Did you know that Ms. Patel gave that same document, the $400 million cash reserve document, to BitGo in January of 2020?
Mr. Skirek said, objection.
The court said, if you know you may answer.
I don't know.
And that document said that Himalaya exchange had $400 million in cash reserves in August 2022, right?
Mr. Skirek said, objection, Your Honor. She already said she doesn't know.
Which document, the one I saw?
The $400 million cash reserve.
Mr. Skirek said, excuse me.
The court said, it's not clear that she said that she was aware of that document.
Let's take a quick look at it. Ms. Loftus, can you pull up GXBR 208A? It's in evidence. If you can go to the second page, please. This is one of the documents you looked at, right, Ms. Sklar?
Yes.
Can you blow up the top of the second page, please, Ms. Loftus? So this bank and fund holdings report signed by Mr. Brown is dated July 31, 2022. Isn't that right?
Yes.
And you said a moment ago you knew that the seizures of the Himalaya Exchange's bank account were in the fall of 2022?
Mr. Skirek said, objection, mischaracterizes testimony.
The court said, I don't recall her stating that.
You know that the Himalaya Exchange's bank accounts were seized, right?
Yes.
And did you know that Ms. Patel, Priya Patel, who you know, gave this document to BitGo, the company you testified about in January of 2023?
Mr. Skirek said, objection.
The court said, do you know?
I don't know. I don't know that.
And do you know that in January of 2023, the exchange's bank accounts had already been seized?
Mr. Skirek said, objection.
The court said, if you know.
I know they were seized. If you represent to me that was the month that it happened. I have no reason to doubt that.
And what's your understanding of what the cash reserves were for $H after the exchange's accounts were seized?
I don't know that.
Mr. Skirek said, objection.
Ms. Sklar. You testified a little bit about reviewing documents about the exchange's relationship with BitGo, right?
Yes.
And BitGo, theirs was a contract with BitGo for wallet services, isn't that right?
Yes.
What happened with the BitGo/Himalaya exchange relationship? Do you know how it ended?
I mean, I know it ended. I don't know if I should be characterizing.
Do you know that BitGo terminated its relationship with the Himalaya exchange?
Yes.
And do you know that happened after BitGo found red flags in its account review of the Himalaya exchange?
Mr. Skirek said, objection.
The court said you may answer.
If that's what they said, I can't say what they said.
You also reviewed documents about the exchange's relationship with a company called Certic?
Certic, yes.
And a company called Jumio, is that right?
I didn't see the Jumio documents, but I know what they do.
You know about their relationship?
Yes.
And GXBR 208A, that wasn't the only Armanino document you looked at, right?
Mr. Skirek said, objection. You didn't show her that document.
The court said, overruled. You may answer.
If I seen other Armanino documents.
Yes, in the course of this review.
Yes.
By the way, did the exchange ever publicly release its audits?
I'm not aware if they did.
But they said they would, right?
Mr. Skirek said, objection.
The court said if you know.
I don't know.
Can we pull up GXAS 18? It's the January 2022 $H white paper. And can we go to page 8 and blow up the third paragraph above the gold writing on the bottom? It says if the market, it's in the middle of the page. So this says, and you reviewed the January 2022 H-coin white paper that we're looking at. This says, the reserve will be managed, and that's referring to the $H reserve?
Yes.
With the aim of maintaining its value at a level equal to the value of all HDO in circulation, and will be subject to independent audit with audit reports made public. Isn't that what it says?
Yes.
Sitting here today, you don't know if that ever happened, right?
That 2022 document wasn't made public before it was seized in 2023, yeah.
My question, Ms. Sklar, is sitting here today. You don't know whether the Himalaya exchange ever made any audit report public, do you?
Right, I'm not aware that they made it public.
In all of the documents you reviewed from the exchange. All the documents reviewed from third-party contractors and the time you spent on Etherscan. You didn't see any evidence that H-coin was backed by gold, did you?
Mr. Skirek said, objection, Foundation, calls for speculation.
The court said you may answer. If you know you can answer.
That it was backed by gold, no, I didn't see anything.
And you didn't see any balance sheet at the exchange reflecting that the exchange held gold or owned gold. Did you?
I saw something about them holding gold. I don't know. I can't recall what document it was though.
And you reviewed a lot of documents about $H reserves, right?
That they had reserves, yes.
And none of those documents said the reserves were in gold, right?
I don't recall seeing that.
And the Armanino audit document we just looked at a few moments ago. That was an HDO reserve audit document, right?
Yes.
That document didn't say anything about its reserves being gold, did it?
Mr. Skirek said, objection.
The court said you may answer.
It said cash.
But cash isn't gold, right?
Right.
You're a former regulator. If the HDO was backed by gold, would they need to tell their auditor that?
Mr. Skirek said, objection, calls for legal conclusion.
The court said you may answer.
There's technically no requirement for any of this when it comes to stablecoins. The purpose. The philosophy behind it is, yeah, when you say something is reserved by something, it should be reserved by that. If you say it's reserved by gold, then there should be gold. If you say it's cash or cash equivalents. Which I also believe I saw somewhere too, which is what most stablecoins do. There's no regulatory requirement right now that says how to do it at all.
You testified earlier that you advise clients on white paper, is that right?
Right.
Have you advised clients on dealing with crypto audits?
Yes.
Would you advise a client to not tell its auditor about the nature of its?
Mr. Skirek said, objection, calls for speculation. She's not testifying as a legal expert.
Mr. Horton said, I'm asking about the facts of how she interacts with the clients she advises.
Mr. Skirek said, it's a hypothetical question about what she would do.
The court said, she's an expert. She can answer hypothetical questions.
I would tell my clients to be honest, but, my clients are also my clients. I don't control what it is they actually do in these situations, but I give my advice for them to be honest.
Now, in addition to reviewing documents, you reviewed some witness testimony in this case, is that right?
Yes.
Did you review everything that Miles Guo has said about H-Coin?
I have not, no.
Did you review anything that Miles Guo had said about H-Coin?
I actually don't think I have.
Did you review anything that Miles Guo said about H-Dollar?
No.
Ms. Loftus, can we please pull up what's in evidence as GXZ9 and go to the bottom of page 120 of this document? Please. Ms. Sklar, the person who's in the middle of the screenshot at the top of this page, do you know who that is?
I've never seen this before. That's Miles, right?
I couldn't hear you.
That's Miles Guo, right?
What's the date on the left-hand top left of this page?
October 20th, 2021.
That's less than 2 weeks before the launch of the Himalaya exchange, isn't it?
Yes.
And, Ms. Loftus. If you can scroll down to the next page 121 and zoom in on the second large body paragraph there. Ms. Sklar. The sentence the third line down starts with what is called, do you see that?
Yes.
Starting with what is called, can you please read aloud until I stop you?
Can I ask who is saying this? Is that Mr. Guo?
This document is in evidence as a statement of Miles Guo.
Okay.
Starting at, what is called, can you just please read aloud until I stop you?
What is called? I'm talking about your H-Coin's brother Seven designed it at that time.
I'll stop you there. You don't know who Brother Seven is, do you?
Yes.
You do know who Brother Seven is?
It's in the caption of the indictment.
And who is Brother Seven?
Referring to Mr. Guo.
From Brother Seven designed it at that time. Please keep reading.
It has the first one. It has the attribute of currency. Why? It is 20% gold. Awesome. It was born as currency on the first day, so it is value, and it is linked to gold, not to others. Clear gold directly. Do you want me to keep going?
Just the next sentence, please.
No matter how much it raises, 20% will turn into gold.
Thank you, Ms. Sklar. Ms. Loftus, if we can take us to 168 of this same document that is in evidence. If you could scroll up sort of the top part of the page with the screenshot. Do you see the date on this page is May 2022? Ms. Sklar?
Yes.
You see the URL tear says gnews.org?
Yes.
You know that G News is Miles Guo's media outlet, right?
Mr. Skirek said, objection, foundation.
The court said, you may answer if you know.
I haven't been to this website, but if that's his, then I'll take your representation for it.
Do you see there's a pricing chart for H-Coin and H-Dollar in this screengram?
Yes.
Where does that pricing data come from?
G News.
My question is, where did G News get that information?
Mr. Skirek said, objection, how could she possibly know that?
The court said, if you happen to know you may answer.
Just reading off the screen, follow NFSC News on Getter. I don't know.
Ms. Loftus, if you could go down to the paragraph it straddles the bottom of 168 to the top of 169, please. I'll read some of this, Ms. Sklar, and I'll ask you to pick up where I leave off. And again, this is the same document we're looking at its statements from G News. Luna coin plunged 99.99% to almost zero this week from $120 a month ago. And its stable coin UST plummeted from $1 to under 20 cents, exposing a major flaw in the current stable coin reserve in the digital currency industry. Can you start reading from there, please?
Miles emphasized in the live broadcast that the traditional financial institutions and many digital currency projects around the world collapse when faced with a run. You want me to continue?
Yes, just to the bottom of the text, please.
But the H-coin stablecoin, HDO, H-dollar can guarantee that no run will ever happen under any circumstances. The stablecoin, HDO and USD, deposited by users always maintain a constant 1:1 exchange rate without any financial leverage or room for misappropriation.
Ms. Sklar, this says that HDO can guarantee that no run will ever happen under any circumstances. Do you see that?
Yes.
And a run refers to when the price of a stable coin basically plummets, right?
Technically, the run is when people are actually running to try to take their money out and the price may plummet because of that. But the run is the activity that might lead to it.
And if you hold a stable coin, you don't want there to be a run on it, right?
Right.
You're an expert in stable coin, right, Ms. Sklar?
Right.
And you read all about Himalaya dollar to testify today, isn't that right?
Mr. Skirik said, objection, asked and answered.
I read the documents I referred to, yes.
Ms. Sklar. What was the mechanism in H-dollar to guarantee that a run would never happen under any circumstances? How did that work?
I think it was one of the documents you showed me before. The Armanino document shows that they were overcapitalized 1-to-1 for their stable coin. That they had slightly over 400 million. So they had enough also to probably pay out whatever fees or wind down expenses they needed on top of a 1-to-1.
Just so I'm clear, Ms. Sklar. Is it your testimony that H-dollar could guarantee that no run would ever happen under any circumstances?
Mr. Skirik said, objection. That's not her testimony.
The court said, overruled.
I don't think anyone can guarantee anything, but the document showed that it had more than 1-to-1.
Is that the only stable coin that's over-collateralized as far as you know?
Some of them are supposed to be, but again there's no regulation requiring it. It's good practice.
Just so I understand.
To overcapitalize if you can.
Is your testimony that there are right now in the world stable coins that can guarantee people who may buy or hold them that they will never have a run, never under any circumstances?
Mr. Skirik said, objection.
The court said, overruled. She may answer. Go ahead.
They might have a run. A run is irrelevant if you have 1-to-1 backing. Give everyone their money back and it works.
The interpreter said, if the witness and counsel can slow down.
The court said, slow down.
It can't be guaranteed, right, Ms. Sklar?
Mr. Skirik said, objection.
A run can't be guaranteed.
Right, can't be guaranteed?
Yes, runs can happen.
Ms. Loftus, if we can go back to the bottom of page 120, GXZ9. This is the same screenshot we were looking at a moment ago, isn't that right, Ms. Sklar?
Yes.
Same date, October 20th, 2021, and that's a few weeks before the exchange launch?
Yes.
Ms. Loftus, you can go down to the top of 123, please. If you could blow up the paragraph that starts with second, remember what Brother Seven said. I'll read some of this. And then ask you to read some Ms. Sklar. And again, this is a statement by Miles Guo. Second. Remember what Brother Seven said. The real H-coin, you don't care about the first 3 months. You don't care if it rises to 1 million or falls to 0.001 cents. The real owner of H-coin is 2 years later. And it can almost tell you whether you should hold it or not. H-coin must be making money. Can you read the next 3 sentences?
If anyone loses money, I can say that I will compensate 100%. I give you 100%. Whoever loses money, I will bear it. Do you want me to keep going?
No, that's okay. You're also an expert on crypto trading coins, right?
Yes.
Are you aware of any crypto coin whose holders are guaranteed against any losses by a particular individual?
Mr. Skirek said, objection.
The court said you may answer.
No, but I probably want to invest in that cryptocurrency. I mean yeah. No one does that. But not because they can't. Most people can't.
Ms. Sklar, what was the total amount you were paid to testify today?
It's somewhere around 70,000.
Mr. Horton said, no further questions, Your Honor.
The court said redirect.
The witness said, actually, sorry, can I revise that answer?
The court said you may.
That's what Seda experts was paid. I get paid less than that. That's what the management company charges.
Mr. Horton said, thank you, Ms. Sklar.
Redirect examination. By Mr. Skirek.
Ms. Sklar, you were asked some questions on cross toward the beginning. About whether you were allowed to interview people from the Himalaya exchange. Do you recall that?
Yes.
Did you ask to interview anyone from the Himalaya exchange?
I did not.
Did we deny you the opportunity to interview anyone from the Himalaya exchange?
No.
Mr. Horton, also read you withdrawn. Mr. Horton also referred to a number of individuals and entities back toward the beginning of his cross-examination. Do you recognize any of those individuals or entities?
No.
Mountain of Spices.
No.
Does that mean anything to you?
No.
Now. Mr. Horton also asked you the question whether if you can't see a cryptocurrency on the public ledger, it doesn't exist. Do you recall him asking you that?
Yes.
Now, are you familiar with private blockchains?
Yes.
And what are private blockchains?
It's an internal blockchain, an internal ledger system, similar to how a public blockchain would look. But it's internal. One popular example is JP Morgan Coin, that's for JP Morgan. They have an internal blockchain and an internal coin. It's not public. Blockchain isn't public.
And on a private blockchain, you can't see those cryptocurrencies on the public blockchain, right?
Right.
And on a centralized exchange, you can't see transactions reflected on the public blockchain, right?
Right. That's traditionally how it works. I have crypto as I mentioned. I have no idea where it is on the blockchain cause I use a centralized exchange to do transactions.
Would you agree with me that those are at least two examples there of transactions on a blockchain that might not be publicly viewable from outside?
Mr. Horton said, objection to the compound leading question.
The court said, can you break it down, please?
Would you agree with me that a private blockchain? The use for a private blockchain cannot be viewed from the public blockchain.
Mr. Horton said, objection, asked and answered.
Mr. Skirek said, you can't object and.
The court said you may answer.
If it's a private blockchain, it wouldn't be reflected on the public blockchain.
Right. And same question with respect to transactions on a centralized exchange. Would those also not be viewable on a public blockchain?
Right. If that's the way the centralized exchange has it set up, as many do, yes. You don't see the individual transaction on the blockchain.
Would you agree with me that's at least two examples of cryptocurrency transactions that are not viewable from a public blockchain?
Yes.
Now. You were also asked several questions by Mr. Horton about the internal ledger nature of the Himalaya exchange. You recall those?
Yes.
And he asked whether the Himalaya exchange's internal system sort of would meet your expectation of what an internal ledger system would look like. Do you recall that?
Yes.
Now. Do you have a specific expectation of what an internal ledger system would look like at a centralized exchange?
No.
And why is that?
Each exchange would have its own software and technology which would be proprietary, frankly. So even if I did know what some of these systems might look like, those would be things I learn from privileged conversations.
Now, you were asked on cross whether a Himalaya exchange user could hold tokens in their own wallet. Do you recall that?
Yes.
Do you know whether that was possible as a technical matter?
Not aware whether it was or wasn't a technical matter or not.
Sorry, just to be clear. As a technical matter, was that possible?
Mr. Horton said, objection, asked and answered.
The court said, sustained.
Is it your understanding that it was technically possible? But it was part of the closed system of the Himalaya exchange not to transmit tokens to customer wallets?
Mr. Horton said, objection, leading.
The court said, if you could not ask leading questions, please.
What's your understanding of what was technically possible to do in terms of transferring tokens on the Himalaya exchange?
It was my understanding that they were developing that technology and that build-out, and that was also why they were working with BitGo and working to develop ways of having wallets and connecting wallets as well as other crypto.
And you testified both on direct and cross about the closed nature of the Himalaya exchange system. Right.
Yes.
Is it surprising to you given that closed system that the exchange didn't permit users to send tokens off the exchange?
Mr. Horton said, objection, leading, testifying.
The court said, sustained.
In a closed exchange, in your experience, is it typical for an exchange to allow customers to send tokens off exchange?
Mr. Horton said, same objection.
The court said, you can answer.
If the intent is to create a closed system, the purpose of the token is to be used through how the system is designed. And in this case, eventually the purpose was, according to the white papers, to allow merchants to exchange the tokens too so that you could use it as an exchange of value.
That's right. And so in your experience as an expert in this industry, is there anything unusual about having a closed system like the Himalaya exchange?
Mr. Horton said, the question was previously objected to. It's sustained, leading.
The court said, sustained.
What, if anything, is unusual in your experience? Withdrawn. Now. In response to a number of Mr. Horton's questions, I believe you started to testify or at least tried to about the long-term plans of the Himalaya exchange. Do you recall that?
Mr. Horton said, objection.
The court said, sustained.
Do you recall trying to testify about the long-term plans of the Himalaya exchange?
Mr. Horton said, same objection, Your Honor.
The court said, sustained.
What were the long-term plans of the Himalaya exchange, Ms. Sklar?
Mr. Horton said, objection, lack of foundation to the exchange long-term plans.
Mr. Skirik said, Your Honor, she got all the foundation one could ask for. She's read all the white papers which she described earlier as talking about the long-term plans.
The court said, long-term plans as to?
Mr. Skirik said, the exchange the long-term plans for its system, Your Honor.
Mr. Horton said, objection, about the long-term plans of a group of people she testified she never met.
Mr. Skirik said, whether she met them or not.
The court said, can you be more specific?
Mr. Skirik said, I will try. We'll see if Mr. Horton objects. Do you recall that part of the long-term plan of the exchange was to permit the deposit of other cryptocurrencies with the exchange?
Mr. Horton said, objection, leading.
The court said, sustained.
Mr. Skirik said, Your Honor, can I have a brief sidebar, please?
The court said, okay.
Continued on next page. At sidebar.
Mr. Skirik said, Your Honor, I believe I'm permitted to lead on redirect.
Ms. Shrofa said, that is the government's position in every single trial. And the Southern District of New York has always taken the position that the statute is clear that they can lead on redirect. And they have led on redirect throughout this entire case.
Mr. Skirik said, there's no mystery, Your Honor. I'm just asking about her understanding about the long-term plan of the exchange. I can either ask in a general way or in a specific way which the government has also objected to.
The court said, you can ask long-term plans with respect to.
Mr. Skirik said, I thought I just did that and that also drew an objection.
Mr. Horton said, from our perspective I think there's leading and then there's leading, and some of Mr. Skirik's questions put a developed argument into his witness's mouth and I objected.
The court said, I feel like you can get to this answer fairly easily.
Mr. Skirik said, Your Honor. I just ask that I be permitted to some degree, this is obviously an appropriate topic for questions. the government is just going to be objecting on form. I suppose we could be here all day until we get one that's not objected to.
Ms. Shrofa said, I'll certainly cite this portion of the transcript in future trials that the government doesn't think we're not allowed to lead on redirect.
The court said, so instead of talking with your adversary, talk to me.
Ms. Shrofa said, sorry about that, Your Honor. I think that the government's position has always been in this trial and in every trial, and I note the silence from the government on this point, that they're allowed to lead. And the statute says you can. You are permitted to lead on redirect examination, so that's my point.
Mr. Finkel said, happy to respond on behalf of the government. As Mr. Horton said quite correctly, there's leading, and then there's leading. And thank you for shaking your head.
The court said, Mr. Finkel.
Mr. Finkel said, sorry, Your Honor.
The court said, that was very snarky.
Mr. Finkel said, you're right. I apologize. As Mr. Skirek was doing. It was more leading than I think is appropriate, like Mr. Horton said, and that's why he raised the objection.
The court said, okay. What do you understand were the plans for X, okay?
Continued on next page. In open court.
Mr. Skirek said, may I, Your Honor?
The court said, go ahead.
By Mr. Skirek.
Ms. Sklar. What was your understanding of the exchange's long-term plans when it comes to other cryptocurrency besides HCN and HDO?
From my understanding, it was to eventually accept Ether and Bitcoin, which were the two largest cryptocurrencies in circulation, to be used instead of US dollars to buy HCN and HDO.
Fair to say they would be open to other cryptocurrencies.
Mr. Horton said, objection to leading.
The court said, overruled. You may answer.
To accepting other cryptocurrencies as a meat of exchange for other cryptocurrency. Whether they listed it for trading, I don't know that was the plan in order to keep a closed system. But to make it more inclusive in what types of crypto they were accepting, yes.
What was your understanding about the exchange's long-term plan when it comes to eventually permitting the tokens to trade themselves?
The long-term plan was for it to be a closed system in that it would be trading HCN and HDO, but that they would be able to translate it back and forth into US dollars and into other crypto and to be used by merchants they selected.
And that would replace the credit system?
Yes.
And what was your understanding of the long-term plan to permit HCN to be traded off the Himalaya exchange?
I'm not sure I know exactly what their long-term plan was. But presumably any crypto that gains traction does get traded on a secondary market.
Mr. Horton said, objection, motion to strike. The testimony is that she doesn't know the plan and the speculation.
The court said, sustained.
In your experience, is it common for a centralized exchange to have a period of development towards its long-term plans?
Yes.
In your understanding, where was Himalaya Exchange in its development at the end of 2021 and in 2022?
There is still building out the technology, developing their user base. Obviously editing their white papers and the philosophy and the use cases of what they wanted it to look like. Crypto is no different than any other startup. There's an idea. You need money and users for it to make sense. And you continue to develop it depending also on what your users want.
And lastly, Ms. Sklar. What was your understanding of the exchange's long-term plans with respect to something called HPay?
HPay would be a way to transmit crypto, some more of either more of a means of exchange or just a payment system. So sort of as I stated, as I saw it. Like their Venmo system, so you could actually send the coin to someone else without going through the exchange itself.
Now, if we could please pull up what's in evidence as Government Exhibit BR208A, and if we could please go to the second page of this. Now, Ms. Sklar, you recall being asked some questions about this document?
Yes.
And do you recall testifying that you believe that this document shows that the HDO tokens withdrawn? You recall testifying that in your view this document shows that HDO in circulation was over-collateralized?
Yes.
Can you just explain what you mean by that?
If you look at the top line, it's over 401 million, that's US dollars held in the bank accounts. And if you go to the bottom line, which is collateralize HDO, which is on the platform, you can see that number is slightly smaller, which means they're holding more money. More dollars in the bank accounts than are on the collateralized HDO credits.
And now you were asked some questions about the white papers. Do you recall that?
Yes.
And you were specifically pointed to some portion of the white paper that said it was in the Himalaya Exchange's discretion whether or not to pay redemptions in dollars. You recall that?
Yes.
In your experience, is that provision a common one in cryptocurrency exchanges?
Mr. Horton said, objection.
The court said you may answer.
I can't say how common it is, but it's not unusual to create your own redemption policies. It's a contract like any other that you're signing onto when you buy cryptocurrency, as well as any sort of other thing you might be buying.
And is it common in your experience to have some restrictions on redemptions from an exchange?
Mr. Horton said, same objection, Your Honor.
The court said you may answer.
Yes, for startup exchanges, yes.
And you testified that you just don't have any information with respect to how the exchange exercised that discretion. Do you?
I don't.
Now. You were asked several questions by Mr. Horton about whether HDO ceased to be backed by dollars at the point that the government seized the Himalaya Exchange bank accounts. Do you recall that?
Yes.
Prior to the time that the Himalaya Exchange accounts were seized by the U.S. government. Have you seen anything that indicates to you that HDO was not fully backed?
No.
You were asked several questions by Mr. Horton to the effect that the Himalaya Exchange halted redemptions when its account were seized by the U.S. government. Do you recall that?
Yes.
Have you seen anything in this case that indicates that the Himalaya Exchange did not honor redemption consistent with its policy prior to the seizure?
No.
You were asked a series of questions by Mr. Horton about audit report issued by Armanino and whether they were made public. Do you recall that?
Yes.
Do you know whether the audit reports withdrawn? Do you know whether the Himalaya Exchange accounts were seized before it could make any audit reports public?
Mr. Horton said, objection.
Mr. Skirik said, she was asked a whole series of questions about audits.
The court said you may answer.
The audit report wasn't issued before the accounts were seized. Is that the question?
The question is, do you know whether the timing of the account seizure affected the public release of the audit report?
Mr. Horton said, objection, calls for speculation.
The court said, you may answer if you know.
I don't know.
Now, you were asked several questions about gold backing. Do you recall that?
Yes.
And do you know that the only representations about gold backing at all in this case relate to HCN? Not HDO.
I mean, that's my understanding.
Right. Because HDO is a stable coin.
Yes.
By dollars?
Yes.
Now were you asked to review any gold reserve issue as part of your expert testimony today?
No.
So you wouldn't know one way or the other about any gold reserves because it wasn't in scope for you. Right.
Mr. Horton said, objection.
The court said, overruled. You may answer.
I don't know.
Now. You were shown by Mr. Horton the transcript of statements by Mr. Guo to the effect that no run could happen. Do you recall that?
Yes.
Now, can you just describe to us what a run is, please?
Sure. A run is generally when people panic and they run. The way it's used in traditional financial senses is people use to actually run to the bank and pull their money out. Now a run can be like electronic in the crypto world. It happened with another crypto. Everyone ran to get redemptions or to try to sell it. Now runs can happen through social media or other ways. It's when everyone tries to get money back. It's a process.
Understood. And what role does confidence play in a run?
If you have confidence that what you're investing in is backed and something real behind it, there isn't an incentive to run. A run is usually psychological effect that happens when people run to the bank or they run to sell something.
If they lose confidence, fair.
Yes.
And adversely, if people believe that the reserves are there, there's no reason for a run, right?
Mr. Horton said, object to the leading.
The court said, overruled. You can answer.
Again, like I said, it is mainly a psychological effect. So if you don't have a reason to make a run on something, then you wouldn't need to.
And would maintaining a cash reserve 1-to-1 of all HDO in circulation provide just the kind of confidence to prevent a run in your view?
Yes, because that's also the purpose of a stablecoin, is that you're supposed to have confidence in it. Having the backing, unlike other forms of crypto which are more speculative and are intended to go up and down.
Mr. Skirek said, "Thank you. No further questions, Your Honor."
The court said recross.
Mr. Horton said, very brief.
Cross-examination. By Mr. Horton.
Ms. Sklar. You were just asked some questions by Mr. Skirek on redirect about whether Miles Guo ever said $H was backed by gold. Do you remember that?
Mr. Skirek said, "Objection, misstates the testimony."
It was whether it was backed by I'm sorry.
The court said, overruled. You may answer.
Ms. Loftus, can you please pull up GXZ9 at the top of 105 and blow up the first two lines? This is a document in evidence at GXZ9. It's a statement from Miles Guo. Can you read the line that starts with the word there? Read that sentence, please.
This is $H backing H coins, and $H is backed by Himalaya Reserve as well as gold.
We can take that down, Ms. Loftus. Ms. Sklar. You were also asked questions by Mr. Skirek about Himalaya Exchange future plans, right?
Yes.
Ms. Loftus, if you can go to page 120 at GXZ9. If you could blow up the top half of this page. Do you see the date at the top left?
Yes.
That's September 29, 2021, right?
Yes.
That's just a few weeks before the exchange launched in November 1st of this year, right?
Yes.
This is highlights of Miles Guo's live broadcast on that same day, right?
Yes.
Can you read the sentence below it, please?
The safest virtual coin at the moment is the Himalaya coin because 20% of the value is anchored to gold.
Does that say the safest coin at the moment, Ms. Sklar?
That's what that sentence says.
Mr. Skirek said, "Objection."
The court said, overruled.
That's what the sentence says, yes.
Mr. Horton said, "One moment, please." Thank you, Ms. Sklar. No further questions from us.
Mr. Skirek said, "No further questions, Your Honor."
The court said, thank you, you may step out.
Witness excused.
The court said, members of the jury, it's 4:59. We'll continue tomorrow at 9:30, so I'll expect you to, as usual, be ready to come into the courtroom at this time. Remember that you're not allowed to discuss the case amongst yourselves, or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, watch or listen to anything from any source that touches on the subject matter of this case. Have a good evening.
Continued on next page. Jury not present.
The court said, please be seated. Is there anything before we start tomorrow?
Ms. Murray said, Your Honor, briefly a couple of points. One thing to note with respect to the direct examinations of both of the witnesses today. There were a lot of commentary after each answer. So the witness would give an answer and the questioner would say thank you or some kind of acknowledgement. We would just ask that the court police that and limit it. We don't think that's at all appropriate in a direct examination to kind of validate or acknowledge the answer that is given. It's commentary. It shouldn't be existent. It's also akin to the government's continuing objection to the direct questions being overly leading. Again, as we discussed at sidebar, we understand it's within the court's discretion. We don't object to certain leading questions particularly for efficiency. But when they veer into testimonial and they bake into the questions some judgment that's implicit that's being placed into the mouth of the witness, we would object. We note under Rule 611 it's up to the court's discretion to what extent, if any, to permit leading questions on direct, so we would just note that point. Separate and apart from that, we would ask if the defense could advise how many witnesses it currently expects to get through tomorrow for planning purposes and also because we understand there was some question about scheduling issues that might arise for certain witnesses. We'd just like an update on what we expect tomorrow.
Ms. Strofa said, Your Honor, I think what we are going to have to adjust the roll call because 2 of our witnesses have to be out of the United States by the end of day tomorrow. So it may involve a brief reshuffling. I'm happy to get back to the government in about 30 minutes. I need to talk to the rest of the team and I've been in here all day. We've had 2 witnesses waiting here in the room across all day. So actually we ran out of room, so one was in the cafeteria, but anyway.
Ms. Murray said, which witnesses, Your Honor?
The court said, if you'll please let the prosecution know.
Ms. Schrofa said, in 30 minutes. I'm not a scout, but 30 minutes it is.
The court said, so with regard to the leading and the commentary, too much commentary diminished the positive effects of leading, so not too much leading and no commentary. Thank you. Have a good evening.
Adjourned to July 3, 2024 at 9 a.m.